All right, let's go live. What's up, perps? Do that. Can't really use that hand still. Fun. Um. Anyway, what's going on, guys? Let's see. Let me get some stuff squared away here. Oh, that way. Ah, crap. Where'd it go? There it is. If I can pick it up. There, got it. It's like a crab machine. Anyway, what's going on, guys? So I figured a couple of cases. One that I listened to prior, another one that I didn't know was happening, but just heard about. And I figured I'd go ahead and share them with the rest of the class. Um, One of them, the first case is Rhode versus Bonta. This is about California's background check requirement for ammunition purchases, which is absolute horseshit. Um, they already force you to register firearms, go through background checks for all your firearms purchases, and they have seriously try to stop people from buying ammo, because they've denied so many people or delayed so many people on these ammo background check purchases. It's just another way that they can trample on people's rights, and we all know what it is. It's just more gun control. Gun control that ain't going to stop a goddamn thing. So we're going to listen to that case first. The second case was in front of in Rhode v. Bonta is in front of the Ninth Circuit. That should be working its way up to the Supreme shortly. The second case we're going to listen to is about Tennessee's ban on gender affirming care. And I'm saying that, trying to make the symbol with both hands, for minors. And you're talking, and you'll hear in this argument, this is talking about puberty blockers and all kinds of shit for very young people. It's not just, oh, well, this person's 17 and they want this shit. It's no, this person hasn't even gone through fucking puberty yet. And they want to be able to give them puberty blockers and all sorts of horse shit to affirm their gender identity, which is absolutely fucking insane. So you're going to listen to two sets, or we're going to listen to two sets of absolute insanity. And just when you think that you're hearing these leftists argue for protecting their gun control laws, that they can't get any more insane, them arguing for the transgender affirming care, whatever, for minors is absolutely maddening. It is some of the most insane shit that I have ever heard in my life. And I've heard some pretty crazy shit from leftists. So hopefully I can get this to play smooth. I'm actually going to shut down my camera to try to hopefully get this to play smooth. And let me say hi to everybody, because hell, I ain't even thought about that. So we got Lightning Scott checking in. Brother Lightning, what is going on? Brother Krabby Turtle, what is happening? Blue Curtain Burner, my brother, what is up? And we got Brother Tactical Muffin Top. What is happening, my brother? Hopefully you can be at work and not like throw your phone and sound like you got Tourette's after listening to this shit. We got Brother Bernie checking in. Brother Bernie, how's it going, my brother? Hopefully you're doing well on this Friday afternoon. We shall see after we listen to this absolute crazy horse shit. Because it is this stuff is absolutely insane. All right, let me get this first one pulled up. Hold on, I'm gonna have to do that after I do this. La da da da. Screen share. Here we go. Promise you, I'm only mildly retarded. Kind of, sort of, maybe. All right, off we go. Hopefully, again, guys, hopefully this will play smooth, but you know my country ass connection. So this is about the background checks for ammunition in California. Um, you'll see everybody move in. The first one that comes up, of course, is the lawyer for the state. Retarded gang too. Hell yeah. I definitely am a card carrying member of that club, and I freely admit it. You might as well own the shit. However, even though I'm a retard, I am capable of logical thought, so that kind of keeps me from being a leftist and a Democrat, which is always nice. I know they're all getting ready. I'm going to let it play though. Hopefully, it'll load and do its thing. Get to see some of the wholesome shit. Just thought it was just me all this time. Oh nope, dude, I got you covered. Uh, I got your back, brother Bernie. I'm a long time member, and definitely not a first time caller. But anyway, you guys know me. I like to listen to these oral arguments. I like sharing them with you guys. They are very interesting to listen to. Um, you kind of get to see where the left is coming from and the arguments that they're using. And to me, it always helps me kind of sharpen my argument and thought processes, um, to be able to talk about what they're saying, where they're coming from, and be able to dispute it. It's just one of the reasons I do find this so interesting listening to these hearings. But yeah, and another thing that really does highlight listening to
All rise.
these absolute leftist judges, which drive me insane. Remember, this is the
The
Ninth
United
Circuit
States Court
Court
of
of
Appeals
Appeals
for the
here.
Ninth Circuit is now in session. Please be seated.
Good morning, everyone, and welcome to the Ninth Circuit. Although we have a number of cases submitted, Hernandez Lopez versus Garland is submitted. Casas Jimenez versus Garland is submitted. Castellanos Vasquez versus Garland is submitted. Braxton versus County of Los Angeles is submitted. Oscar v. Garland is submitted. And the first case for argument is Kim Rhode versus Rob Bonta. Counsel, you can begin.
Good morning, and may it please the court. Micah Moore for the Attorney General. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Please watch the clock.
The challenge laws require California residents to pass a background check before they can acquire ammunition, just like they must to acquire firearms. Those background checks allow the state to confirm that those who receive ammunition can lawfully possess it. Plaintiffs in this case don't challenge the premise that governments can disqualify certain individuals from possessing ammunition. Their core theory is instead that the background check requirement violates the Second Amendment on its face. That theory fails.
Counsel, I want to interrupt you here. I just want some clarification. Is it clear that this is a facial challenge?
Yes, a facial challenge to the background check
I
requirements.
saw that in the
hell,
prayer for
Hydra.
relief that they did. They said that it was a facial challenge and alternatively an as-applied challenge. But I didn't see anything in any of the pleadings that suggested that there was anything particular to these plaintiffs.
I think that's correct, Judge Bybee. There's nothing in the complaint that suggests that this challenge is limited to the facts. And of
Did
course,
the district court acknowledge that this was a facial challenge?
yes, well, the district court enjoined the statutes in their entirety. And I don't think there's anything in the district court's order that suggests that under the injunction only runs as to.
Yeah, and if I'm thinking right here, the district court judge was Benitez, who shot this shit down, who said that this was unconstitutional to do these, have to go through all these background checks and waiting times and all this other horse shit just to get ammunition. Which, if you've paid attention or seen some of the other stuff, and we've done a lot of it here, I wish we could get the oral arguments from Benitez, but apparently their court doesn't do the streams on oral arguments like the Ninth Circus does. But Benitez, also known as Saint Benitez these days, has shot down a lot of California's unconstitutional horse shit. And of course, the Ninth Circuit turns around and they uphold their unconstitutional horse shit. So we'll see what they do here. And when he's talking about whether this is a facial challenge or an as-applied challenge, I don't see why in the hell it can't be both. The state always plays a game of hide and go fuck yourself. Either way, we win. So I can't see why it can't be argued the same way from the plaintiff's side. So I don't see why this judge is necessarily hung up on this, but
particular plaintiffs or facts.
Well, why are we considering all of the statistics if this is an on its face challenge?
I think because if it's a facial challenge, the plaintiff's burden would be to show that the statute is unconstitutional. There's no set of circumstances under which the ammunition.
But in that case, why do we even bother with looking at, for example, the wait times or the denial rates or the rejection rates?
I think because the Supreme Court has suggested in Bruin that if you have a background check requirement that's being applied in an abusive manner, and I think if there were features of the scheme that run from the statutes that are causing it to be applied in that way, then that would be.
But wouldn't that be an as applied if California said you have to pass the test, and the test was taking 60 days. Then we might say it's abusive. And if the regulation said 60 days, that might not be on its face. That might be an as-applied challenge, wouldn't it? Or if there turn out to be unusual wait times in application, that feels like that would be an as-applied challenge.
Brother CG, what's going on?
I certainly agree that there's aspects of plaintiff's challenge that sound as if they would be more properly brought as an as-applied challenge, but I understand, and they can correct me if I'm wrong, their argument to be is that there's an inherent risk anytime anyone submits to a background check that they're going to experience one of these issues or run into long wait times, and the fees themselves are prescribed by regulation.
In an on its face challenge, are we looking to see whether any person in California might be subject to an abusive time or an excessive wait time? Or are we looking for something else?
I think in a facial challenge, they would have to show that there's no set of circumstances in which the statute can be applied in a constitutional way. I do think that the record suggests that their facial challenge fails because what the record shows is that in the overwhelming majority of instances, people are able to get the background check completed in less than a minute. And so I don't think that's I think this discussion is revealing that their facial challenge might fail on the merits, but that wouldn't speak to any future as applied claim that someone might bring if they do run into a different situation.
Thank you.
And so, I think this is a challenge that Bruin has provided some recent and compelling guidance on. Bruin suggested that shall issue licensing requirements don't violate the Second Amendment unless if they are applied in an abusive manner. The Supreme Court just gave two examples. One example could be if the background check requirements require exorbitant fees. The other could be if they require lengthy wait times that are so long that they amount to a denial of Second Amendment rights. The record does not.
What difference does it make that in order to get to have an operational gun, basically, because you need ammunition to be operational, you have to do it every time you want ammunition, as opposed to maybe a year you have to renew it or the like?
I think that's certainly something that the court can take into account in evaluating whether the background.
Yeah, these background checks, as I understand it, are only good for 18 hours. I believe you can only get like 40 rounds of ammunition at a time. And there were a lot of people that were getting false denials on these background checks. And it was I can't remember the number offhand, but it was pretty freaking high. And then there were other restrictions on it. You know, you couldn't get ammunition for a gun that wasn't registered to you. So all the ammunition you get, or any ammunition you get, has to match a firearm that's registered to you, which is fucking ridiculous. So if I wanted to shoot my buddy's 40 cal, and I don't own a 40 cal right now, and I go to buy 40 cal ammunition, I can't buy it because that gun's not registered to. There's so many fucking different restrictions written into this stuff that it's just mind blowing when you actually get down into it. It's just ridiculous. And if the standards brewing where they had to find a law that existed at the time of the founding that was an analog for this shit, there isn't one. And these judges, if they were intellectually honest at all, they would shoot this shit down, no question. And listening to this, and it takes a little bit to hear, and it's kind of surprising to me. It sounds like the two female judges on this panel are the ones that are asking probably the questions that lead me to believe that they might actually find this unconstitutional. You guys tell me what you think after we listen to this whole thing, because it takes a little bit, and these judges are, in a lot of cases, kind of hard to read.
Check requirements are abusive, but I don't think that that fact alone can change the result here, where the record reflects that even if you are submitting to the background check multiple times to purchase ammunition, in each instance you do so, it's most likely going to take less than a minute to complete. And so I just don't think that that fact alone can change what the record shows. Something else that I also think is meaningful is that the state.
When you say less than a minute, are you referring, because apparently there's various different types of background checks. And some of them says it takes 5 to 6 days and et cetera. Which one are you actually referring to?
So I'm referring to all background checks, but the majority of background checks that people request are standard checks, which are subject to an expedited process.
So there you have to be in the federal automated firearms system.
Yes.
And how long does that take, or what is that process?
So most firearms are in the automated firearms system because the state has required registration for handguns since the 1990s and for long guns for the last decade. There may be issues that can arise if your AFS registration is not up to date. And so that's something that could happen if you change addresses. But for those individuals, the department provides a self-service website where firearm owners can initiate the process of updating their records.
What if you don't own a firearm? What if there's no record of you owning a firearm? So either you've acquired it in some other way, or you have access to someone else's firearm who is in the system, but you're not already in the system. Then what happens?
So if you own a firearm that's not in AFS, you can submit a
Live life, my brother. Welcome to the nightmare. How's it going today, Ben?
firearm ownership report to the department.
What if you just go in and you just say, look, I want to buy ammunition, and you're not already in the system because you have not indicated to California that you've purchased a firearm?
Okay, so if you don't have a record, then you have the option of requesting and passing a basic check, which doesn't require enrollment in the automated firearm system.
So if you haven't already indicated to California that you own a firearm, you have to go through the basic check?
Well, you may not have had to, you don't have to indicate to California to end up in AFS. It also pulls from firearms vendors' records. And so it's more, have you purchased a firearm in the last years in California, then you should be in the system.
Okay, but if California can't verify that you own a firearm, can you still buy ammunition?
You can still buy ammunition, yes. You just have to request and pass the basic check.
CCW checks you 5 times a month? Good God.
And okay.
So has any court held that footnote 9 of Bruin applies to the purchases of ammunition?
I don't think we have a case applying footnote 9 in the context of ammunition. There are certainly decisions that have thought about footnote 9 in the context of firearms background checks. And so
But
I think
there's a serious distinction between a firearm and ammunition, and that a firearm is somewhat durable. You would assume you'd own it for quite some time. Ammunition is expendable. You'd be purchasing ammunition repeatedly. So in footnote 9 is talking about a licensing process as opposed to permitting. So it seems that you're asking us to, without authority, stretch what footnote 9 means to say that we have to find that this was an abusive scheme before it was unconstitutional.
I definitely take the point that Bruin was decided in the context of firearms, but I do think the guidance that it offered is also relevant to ammunition. What the court suggested is that the focus should be on whether or not the requirements are abusive and that whether or not they're requiring undue wait times or exorbitant fees. And I think that's analysis that can be applied to ammunition as well. And the fact, I definitely take the point that ammunition is different than firearms, but I do think these background checks are different than firearms background checks in a way that supports our position as to whether or not they're abusive.
So-
They require...
I'm sorry.
Sure. I was just going to say they require shorter wait times. They cost less than a firearms background check. There's no waiting period that applies to ammunition transactions in the same way as firearms transactions. And so in most instances, you can leave the store with ammunition rather than having to wait 10 days as under the firearms regime.
So I understand your brief to argue that the purpose of this is to prevent prohibited possessors from having operable firearms. But isn't that accomplished by the background checks and the schemes to control the purchase of the firearm? So
Yeah, and this judge is bringing up another really valid point. If your background checks for firearms actually stop criminals from getting firearms, why are we even worried about the ammunition? I mean, isn't everything solved by the firearms background check? And if it's not solved by the firearms background check, well, then all of your gun control is kind of bullshit. Because if your background checks for ammunition actually stopped anything, well, I guess we just need background checks for drugs, and it would stop, the illegal drug markets. Because we all know that now that drugs are all illegal, nobody in California can get them, right? I mean, it's kind of like no one in California shits in the street.
now a prohibited possessor is going to come in and just buy ammunition. It seems like it's a bit of a stretch that this is going to somehow increase your effectiveness in policing prohibited possessors.
Well, I think the reality is that the firearms background check doesn't serve a purpose where someone's able to obtain a firearm through other means. And so the Jones Declaration, for example, that we cited speaks to this. That declaration described law enforcement investigations that started off from a denied ammunition purchase. And in several instances, the law enforcement was able to recover firearms that had been obtained illegally. And so
Now notice she didn't say that this led to a prohibited possessor of a firearm. She just says that it was a firearm that was obtained illegally, which, if I'm thinking right, what that is somebody bought a firearm in a person-to-person sale in California, didn't get a background check done, didn't register that firearm to themselves, and then they went to get ammo because they had no idea about all this other horse shit. And then it led to the police going in, taking their gun, and then probably charging them with something. Didn't stop a single fucking crime. Didn't stop an illegal prohibited possessor from getting a firearm or using a firearm in a crime. None of that shit. Yeah, man, there's been so many times through the years where I've been at Walmart or something like that, and I see a good price on ammo, and I call a buddy up who's got something I don't have, and I'm like, hey, they got a pretty good price for, I think at one point I didn't have a 270, and called a buddy and was like, hey, it's a pretty good price on 270 ammo over here. And he was like, hey, man, pick me up 2 boxes, and I'll square you away when you get them to me. It's like, okay, man, pick them up a couple boxes. They shoot me the money for them. No harm, no foul. Or some gauge of shotgun shell. I think I picked up a couple boxes for some guys. But it's not the government's fucking business at all what I buy, when I buy it, anything, how much of it I buy. It's none of their goddamn business. But hey, this is the nanny state.
I think that's the additional enforcement benefit that the ammunition background checks are providing, even if there's a separate firearms background check requirement.
Would you, I'd like you to turn to what test we are going to be applying. Are you familiar with our decision this year in B&L?
Yes.
Okay, so how does this fit into B&L's analysis as to
Now, there's a couple of cases they talk about in here I don't remember. I do think I remember B&L, which B&L was about firearm sales, like basically gun shows on state property. And this court, fucking the Ninth Circuit, upheld a ban on gun shows on state property, like fairgrounds and things like that, because they said it's not an infringement against the Second Amendment to, not have these gun shows on state property, because if you're not on state property, you can buy a gun, so you can still get a gun, so it's not an infringement. Just absolute horseshit. So that's the B&L case. Either way, all you have to realize is the Ninth Circuit upheld the ban on firearms being sold on state property because it's not an infringement.
whether a restriction on commercial sale of ammunition is within the plain text of the Second Amendment? So do we even get to the historical analysis?
I think this is a case where the court could not get to the historical analysis. B&L suggests that the relevant test is whether or not the regulation meaningfully constrains the right to keep and bear arms. Even separate from B&L, that test was established in Teixeira. And so I think applying that analysis here, plaintiffs just haven't shown on a facial basis that these background check requirements are preventing individuals from being able to keep and bear operable firearms for self-defense.
How is it operable if you can't get the ammunition?
Well, I think our argument is that you can get ammunition. It's just that you have to pass the background check requirement in order to do so.
But the point is that it's an infringement on that right. So you can't operate a firearm without ammunition. And I think Jackson is our case that says that it's part and parcel of the Second Amendment right to keep and bear arms. It's meaningless unless you can have ammunition to go with it. And B&L and Tejada were addressing the acquisition of firearms. I think B&L was really more, it was purchasing firearms at trade shows or something along those lines, and you could acquire a firearm like 600 feet away. So it really was no meaningful infringement on your right to acquire a firearm, which seems very different from a scheme that requires you to get permission to purchase ammunition every 18 hours. I mean, these expire so quickly. That strikes me as very burdensome.
Well, I guess a couple of different points. I think first, starting with Jackson, this court has recognized that ammunition is entitled to Second Amendment protection, and we aren't contesting that at all. But what the court has said is that ammunition is protected under an ancillary protection, and that protection is not itself absolute. It's only to the extent that it's necessary to realize the right to possess a firearm for self-defense.
So do you think this
She's fucking getting on that last nerve. This is something that you see the left arguing more and more these days, that the Second Amendment only applies to firearms for self-defense or firearms that are being used for self-defense. In other words, they don't have any protections for any other purpose but for firearms that are being used for self-defense, which is absolutely fucking retarded, because the Supreme Court has already said that firearms are protected for any legal purpose. If I want to buy one and use it as a goddamn doorstop, that is a legal purpose. If I want to buy one and shove it up my ass, that's a legal purpose. If I want to buy one and I want to go shooting clays with it, that's a lawful purpose. The left is arguing that it has to actively be used for self-defense. In other words, it can't just be bought for the purpose of self-defense. It has to be used for self-defense. It's just another way they can try to narrow the standard, which again is absolutely fucking maddening. Let me let this play, or I'm gonna fucking throw something.
nuance of describing a right as ancillary survives, Bruin?
I think it does. I think this court is bound by BNL, and in BNL, the court held that Teixeira's text and history analysis is consistent with Bruin. And so I do think this court's prior precedent on ancillary rights and when they implicate the textual right of the Second Amendment does apply here.
It's really hard to say that ammunition doesn't, because a gun without ammunition is not usable. So it's not ancillary, it's intrinsic to having a firearm.
I think that's not quite what this court has said. But I also don't think it's a principle that we deny that you need to possess ammunition in order to have an operable firearm. Our position is just that plaintiffs haven't shown that the background check requirement is meaningfully constraining their right to possess firearms for self-defense. So if they're
Yeah, but Blue, is it federally a crime? And technically, is sticking a gun in your ass sodomy? I mean, come on. Are we kind of splitting hairs there? Blades, what's up, my brother? How you doing? Doing a laughing? Yeah, kind of.
no further questions, I'll reserve the balance of my time for rebuttal.
All right, thank you.
Good morning, Your Honors. May it please the court, Matthew Rowan on behalf of the plaintiffs. The district court described California's ammunition background check and anti-importation regime as an extensive and ungainly first.
Putting together a Lee Pro 4000. Hell yeah, Blades. Dude, I still got 2 reloading setups I got to freaking put together that I've had for a while, and I have not gotten around to setting up yet. I know, I'm a freaking bad boy. What you gonna do?
First of its kind, sweeping statewide restriction on a phenomenon right that is unprecedented in American history. That description is not only correct, it understates things. Not once in the first 240 years of this country's history did any state see fit to require law-abiding individuals to submit to a state investigation each and every time they seek merely to acquire the ammunition without which their firearms are inoperable. That's not because ammunition sales or background checks are some newfangled innovation. Ammunition sales predate the founding, and there is a tradition in this country of limited, minimally burdensome firearm background checks that dates at least back 100 years. Yet it took long after that for any state to even think of implementing such a regime, and California was the first to actually do so 5 years ago. Given that historical reality, the idea that any ammunition background check regime could pass muster under Bruin and Rahimi strains credulity, but this court doesn't even need to decide that question to affirm the district court's decision, because California's one-of-a-kind regime is in a league of its own. And so
She did notice you had it for a year. Yeah, dude, man, I've got a Lee. It's a single stage. Oh God, I can't remember the model that I bought off a buddy of mine. And then I've got a shotgun single stage reloader that I got from another guy. So I've got one that I can reload all my rifle and pistol off of, and one I can reload my shotguns off of. And I have not set them up yet. I've got dies. I think I've pretty much got everything I need, but I've been a dopey bastard and haven't set them up. Oh no, not for 140, man. Shit, no. I couldn't pass that up.
I want to start just by going through the Second Amendment analysis and explaining why.
Before you do that, would you address the question of on its face versus applied? Is this
Sure.
an on its face challenge?
So this is a facial challenge,
All right.
and I would, I think the right way to think about facial challenges are nicely described in this court's en banc opinion in Lopez Valenzuela, where you were in the majority in that case from 2014. And what Lopez Valenzuela says is you look at the relevant constitutional decision rule. That's the phrase that was used there. There, somewhat confusingly, the relevant constitutional decision rule was Salerno's due process standard, separate from Salerno's spatial challenge dictum. And what the court said there was, yeah, even though one of the actual plaintiffs in that case could have been constitutionally detained, that was Arizona's Prop 100 laws that basically deprived any person who wasn't here lawfully present from the ability to get bail. They said even though one of the actual plaintiffs could be constitutionally held without bail under a different statute, that didn't render the statute.
Dude, I'd have to check and see what reloading is like in California. Because I really don't know, and how you might be in California, Blades. I can't remember if you would have to pass a background check for components or just, preloaded ammo. But either way, I mean, most people, and I'm one of them, are going to buy ammo versus loading. Even though I've got the shit to do the reloading and I'm just a lazy bastard and haven't set it up yet.
Not facially unconstitutional, because what you do is you don't look at sort of individual circumstances. You look at the relevant constitutional decision rule.
So what is your burden in this case?
Sure. So we think that we have a threshold burden under Bruin, and we think that the threshold burden is very easy for us to satisfy here, given that this is a complete gatekeeping on the ability to acquire ammunition.
So your position, you're going to take the strong position, which is that there can be no background checks for ammunition. Is that your position?
We do take that position, and we think clearly it implicates the Second Amendment to have a regime.
Yeah, before you get to that, because I want you to address B&L here in just a minute.
Sure.
in terms of framework. So the question of sort of the wait time here is largely irrelevant. Your position is that any delay of background checks being completed in less than 60 seconds, that would still violate the Second Amendment.
That question alone is why I think this is the judge who is going to hold that these laws are constitutional. I'm really, and I could be 100% wrong, I think the two women judges on here are going to say this is unconstitutional. At least that's the feel I get. But like I said, I could be 100% freaking wrong, because it's so hard to tell where these judges are coming from with their questions sometimes. From high school to LA County Sheriff. Yeah, dude, if you know California, their whole roster deal, so police officers can get anything off roster. They can get whatever they want because they're law enforcement, and then they can turn around and sell it in a person-to-person sale. Now, most people don't have a police officer buddy, so some police officer is going to be scalping a gun at $400 over what the gun actually costs. It's ridiculous, man. It's honestly, and if these Democrats, if they had their way, believe it or not, this shit would be national. There are bills that have been proposed federally. Some of them I've covered, that want basically everything California does and more to become national federal law. Chess, what is up, brother man? Yeah, brother, Thanksgiving was good, man. Hopefully you had a good Thanksgiving also.
So that is our position with respect to ammunition background checks, and I'm happy to sort of talk about that. But the reason why, even if you don't agree with us on that, the reason why the facts matter is the relevant constitutional decision rule here is Bruin and Rahimi's how and why test. And how, you have to look at not only what the statute says, but how it actually operates. And part of how this statute, or the many statutes operate, is dependent on the fact that rather than set up.
Oh, so California doesn't have any background checks on their reloading components? Oh, well, good fucking deal, man. If I was in California, I'd have my reloading setups done already. Because Jesus Christ. I think, if I'm remembering correctly, and I could be 100% wrong, the background checks for ammunition in California, I think, limit you to like 40 rounds at a time or some fucking ridiculous shit like that. And then, of course, the background check itself is only good for 18 hours. So you couldn't go in and buy 40 rounds of ammo, turn around the next day, buy 40 rounds, and the next day buy 40 rounds. I mean, it's just how someone can say this isn't an infringement is mind-blowing to me. But we've listened to enough of these things where you see how these leftists will defend any of this gun control.
A database that actually works, which is how Prop 63 initially was going to do. The sort of initial version that the voters of California approved required California to set up a centralized searchable database where your number would be your same as your driver's license number, and vendors would have access to it. And just like the Brady Act, they didn't just, Congress didn't just say NICS starts overnight. They gave the FBI 5 years and a bunch of money to set up a system that works. Whereas here, that's what the voters voted for, but the California legislature pre-amended Prop 63, and they got rid of what would have been Section 30370C. And instead they said, no, we're going to piggyback on the AFS system. But the problem with the AFS system.
Yeah, dude, I couldn't remember the failure rate for the background checks or how many were actually denied, but 11% sounds about right, if not maybe a little low, from what I've seen on this. And we all know what it's about. It's just another infringement. It's another hoop you got to jump through. It's just more ways that they can try to keep people from actually, practicing their right to own arms and have them in working order. It's ridiculous. Did you see the balloons that were left at a scene in NYC? Left at the scene in NYC. CEO down. No, dude, I didn't see that. Send me something on it. We'll look at it in between this and the next arguments.
Is that it relies on dealer inputs, and it was never intended until this regime was put in place to be used as a gatekeeper to the exercise of anything else. So, I mean, we have evidence in the record where, the drop-down menu, when you go to buy a firearm and dealer puts it into AFS, you have things that say Huntington Beach, BEACH.
Yeah. Okay, I have to say, I'm confused by all of this. I mean, everything that you're saying, I understand makes a lot of sense, but it feels like it would make a lot more sense if you had an as-applied challenge. So I understand on the facial challenge, I think I got.
Judge, what's stopping this from being both facial and applied? I mean, it should be both ways. And you mentioned at the start of the case that they're talking about both facially and applied. Facially, on its face, this law is absolutely unconstitutional. As applied to these people that were denied on these background checks, it is unconstitutional as applied to these people. So why the fuck can't it be both? Why are you trying to put this in a box? Oh, well, I think I know. It's because you want to try to uphold this bullshit. Yeah, at least you're not trying to ban colored firearms. Oh God, man, I saw that. That was out of Michigan, right? I think it was Michigan. Yeah. If you have a firearm that isn't an approved color, they want to ban it. God damn. Just when you think the left can't get any fucking dumber, they do. And I'm tired. I can't ask anymore if they can. Asking if they can get any dumber They see that shit like a fucking challenge at this point. They're like, okay, yeah, I can get dumber. Let me prove it to you. They're freaking insane.
Not the right answer to the question, which is that you don't, that even if California successfully integrated this from the beginning, if they had studied it for 5 years, worked all of this out and had 100% at 60 seconds or less, that would still violate the Second Amendment. Isn't that your strong position?
That is our initial position.
Okay.
And if you don't agree with us on that, still under the facial challenge rubric, the how facts actually matter, because the relevant constitutional decision rule under Bruin and Rahimi looks at the how and the why. You have to compare historical analogs in terms of the burden that they impose on the exercise of the fundamental Second Amendment right to the burdens that the regime imposes. And the way we know, I mean, this is an unusual case, not only in that we have a record, but we have 2 different time periods of records, because the case was back, before the district court in 2019 and again in 2023. And what we've seen is that thousands of Californians have been unable to acquire ammunition as a direct result of this regime. So I wanted to talk about B&L for a second. So we don't think that the B&L framework is.
Do you have any plaintiffs who have standing?
Yes.
To challenge those delays? I didn't see anything in your complaint that suggested that.
Oh God, now it's about standing. These fuckers will do anything to try to uphold these unconstitutional laws. Anything. These arguments about standing have been used to throw out so many fucking cases that were solid cases. But you're like one of the ones that they tried to throw out was the case of the sales to 18 to 20-year-olds. And the cases took so long in court, by the time they got to whatever circuit court, the people had already turned 21. So the court tried to argue, well, your people have turned 21, now they're no longer harmed, so they don't have standing in the case. Never mind the fact it's going to fucking affect tons of other people from 18 to 20. It's fucking... Some of these judges just... Oh, dude. I want to say it, but I'm not. Remember, you're talking about a state turning felonies to misdemeanors, getting rid of mandatory jail time, yeah, I know.
It was any individual person who had suffered a delay.
So we have a robust record here. I would commend.
Yeah. Is there anything in your complaint that suggests that you've got a plaintiff?
So the complaint was filed before the regime had
which
gone
indicates
into
that
effect.
it's an on its face challenge.
Right, but now it's gone into effect, and we have declarations in the record that the district court relied on. So Plaintiff Johnson at ER 58, after he moved, he was unable to use the standard check. It took 110 days for California Department of Justice just to respond to him. We know that Kim Rhode, the lead plaintiff, has had to spend thousands of dollars storing ammunition. She's an Olympian, and she can't get it to her house. This court's precedent, including cases like Montana Shooting Sports Association, makes clear that expending time and money to comply with a burden on the Second Amendment is sufficient for standing. We also have an associational plaintiff, CRPA, and we have 2 declarations from the treasurer and the president, respectively.
Once we go to, let's take Mr. Johnson, because the 110 days is a disturbing figure. Once we go to that, doesn't that make this an as-applied challenge?
So it doesn't, Your Honor, and I really think
good deal, Chess.
Facial and as-applied challenges, it's confusing, but I do think I would take a look back at the majority opinion in Lopez Valenzuela that explains that the facts often actually matter in as-applied challenges.
So wait, I'm sort of confused about those steps in Bruin. So it's your burden to show that this is an arm that's safe with.
A judge, a sitting federal judge, saying she is confused about the steps in Bruin. Holy shit. I can't even fit that into my fucking head, lady. It's very simple. does this implicate the Second Amendment? If it implicates the Second Amendment, is there a analog law that was in effect at the time of the founding? And if it was, then it might be upheld. If there wasn't an analog law, they said it didn't have to be a direct, but an analog law, then maybe, just if I can understand this as a dumbass fucking redneck welding instructor, how can one of the so-called justices, who are supposed to be legal authorities, not fucking understand this? Past my local turns. So that shit's so fucking ridiculous, Blades. It's not even funny, man. Have to do the extended for $20 or whatever. Man, it just anything they can do, they will do. And it's such a, again, I get back to the fact that Joe Biden has fucking packed these district and circuit courts with these leftist judges. So all of them are going to uphold all of this fucking gun control that these leftists want to put through. And when a state has bullshit laws like California and they go to a district or circuit court, this is who you run into are these leftist judges. They're going to uphold it. So it takes fucking a decade in a lot of cases to fight these unconstitutional laws when they should never make it past the first judge in a state court. It's just, man, it's just fucking maddening. Being deep shit, bro, from the, yeah. Oh, we're gonna be in deep shit, man. I'll have to check again and see how many judges that Joe Biden and his crew have actually put on the courts. Brother Colt, what's happening? How are you? But I'll have to see, and I'll check it sometime on this stream. And these are all going to be leftist judges that will uphold every bit of the leftist agenda. And we're going to be dealing with these dickheads for decades. And it should be very simple that when these judges uphold something that is found to be unconstitutional, for them to be removed from the fucking bench. Thanks for playing, dickhead. You are no longer a judge. You're no longer allowed to be a judge. Hope you have some other secondary skill to fall back on. But it's not. It's like freaking. It's worse than getting an act of Congress to remove these judges from the bench.
The Second Amendment protects, right? And it's the government's burden to show that there's a historical analog. Aren't I correct there? So where does the individual challenges come in?
So you're correct. And that's definitely the analysis that Bruin sets forth. And we think that it's a very clean analysis here, and that, of course, a law that says you have to pass through a gate that the government controls in order to acquire ammunition, of course that law implicates the Second Amendment.
Now, and see, this judge, even though she says she's confused about this, asked a very poignant question. Set forth in Bruin, it is on the government, it is their burden to prove that there is a historical analog to this law that's being challenged. And of course, there is no historical analog. It should be very easy to prove. And that is why they should just go ahead and uphold Benitez's decision in this case. It should be that simple. Benitez did all the work. Benitez proved there is no historical analog. But we'll see what the Ninth Circus does with this shit.
So we think that, B&L Productions and to share cases like that where you can't purchase firearms at 2 fairgrounds, but you can purchase it everywhere else. The difference between that law and a law like this is this applies always and forever to everyone. And it is an absolute gate that you have to go through that the state controls. So of course that implicates the Second Amendment. And I think Bruin footnote 9, the only way to make sense of Bruin footnote 9 is to understand that background check regimes and licensing regimes, which this of course isn't, implicate the Second Amendment. Otherwise, how could something ever violate the Second Amendment? The only logical way under Bruin and Rahimi's sort of 2-step framework for something to violate the Second Amendment is if you've passed the threshold inquiry. So we think that the sort of B&L production substantial burden sort of standard is not the correct way to approach a law like this. But even if you disagreed or if you thought the better course of valor was to assume without deciding that you were in sort of the B&L productions framework, of course, this statute imposes a substantial impairment on people's ability to acquire
The
operational
government
arms.
argues that that bullets are ancillary. That seems to go
Yeah,
to
Blade.
the first step, whether this implicates right of the people to keep and bear arms. So what's
Yeah, we're gonna hit that next, Blade. Yeah, you are gonna hear. If you think the arguments in gun control cases are absolutely mind-numbing and maddening, wait till we get to the next one. That was actually in front of the Supreme Court this week. Yeah, they equated the puberty blockers, which could make kids once they're adults infertile, to taking aspirin, or the denial of those to denying a girl from dressing like a boy or a girl from dressing like a. It just, yeah, you were gonna hear it. Ron Wayne, what's up, my brother? Hey, Ron, I think I figured out how I'm finishing that cutoff, and actually working on it. Got some stuff drying right now, so hopefully I'll be sending that off to you first part of next week.
position on that?
So, I mean, this court has said that they are ancillary. I think that the way that I would understand that with respect to ammunition is that they're ancillary in terms of being inherent. I mean, ammunition is itself an arm. So I don't think that, the ancillary piece goes to ammunition. What this court has said is it goes to the acquisition. But of course, one cannot possess what one can't get. So I think it's a mistake to think of acquisition as ancillary just because the Second Amendment doesn't say explicitly purchase or acquire alongside keep and bear. I recognize that Manny and B&L Productions take a somewhat broader view. And so if the court wants to sort of say, look, we're going to assume without deciding that we got to follow this substantial impairment test to get through the threshold, we think that's not the right way to sort of do this a priori under Bruin and Rahimi. But we think clearly it's passed here because, again, we have a record.
So do background checks for firearms, does that come within the Second Amendment?
Of course.
That comes within the plain text?
Of course. I mean, I think
Okay, now,
otherwise.
Okay, that I understand that B&L doesn't cover that, but we do have 3 other circuits that this year have said that background checks do not come within the plain text of the Second Circuit. So you're urging us to go into conflict with, by my count, the 4th, 5th, and 10th circuits.
So what those courts have held is twofold. What they've held is, one, if you frame the question as the conduct plus the restriction, so if you frame the question as, do you have a right to acquire a firearm without passing through a background check? Well, that's not covered by the plain text. But they've also then said, but of course, we can't say that background check and licensing regimes do not implicate the Second Amendment because that would overrule Bruin, which of course was a licensing regime case. And again, I think Bruin footnote 9 would make no sense if you thought that background checks didn't implicate the Second Amendment. And I mean, again, perhaps the safest way to do this is to just say, fine, we'll assume that B&L Productions is the correct standard for here, pass through the threshold, because of course, a law that prevents thousands of law-abiding citizens from acquiring ammunition without which a firearm is inoperable, of course that imposes a substantial impairment on law-abiding citizens' ability to acquire arms. So
Even if it's a 60-second check.
So I do think, I think even if it were a 60-second check with respect to ammunition, because as Judge Beatty pointed out, ammunition is expendable. In the record, when California first passed Senate Bill 1235, which pre-amended Prop 63, they did an economic assessment, and one of the assumptions was that people will buy 40 rounds at a time. 40 rounds doesn't last very long if you're training, which is something that
Hackerizer, what's happening, my brother? How you and yours?
you want people to be able to do. So people are going to go buy ammunition all the time.
Does California limit how much you can buy at one time?
So California doesn't, but we know from the record that people aren't just sort of spending money willy-nilly. I mean, I think
Although Miss Rhode might buy it in bulk.
so. Ms. Rhode might, although Ms. Rhode may not have to pay for it herself because USA Shooting does provide her some of it. So yes, I mean, there are certainly special cases, but what we know from the record is that people aren't willing to spend the 5 times as much as a standard box of 22 round ammunition just to pay for the $19 basic.
Damien, what's happening? My brother, how you doing today? Welcome to the shit show.
Check, which soon will be more expensive, as my friend on the other side pointed out in the footnote in their reply brief. So I do want to sort of shift to the historical tradition part of the analysis.
Can I ask you a question before you go there?
Of course.
So it seems like the real battle in these cases is how we define the proposed conduct. If you define it as brew and
Brother Joe Morris checking in. What's up?
did is, the right to keep and bear arms, it falls clearly within the plain text as opposed to saying the right to have a license to concealed carry or to carry in public, whatever. So B&L described the conduct as contracting for the sale of firearms and ammunition on state property, which is not in the text of the Second Amendment, but it could have been defined differently. And are there any principles? It seems like the case law is a little bit all over the board. So any principles that we can apply to decide how to define the conduct at issue?
So, I mean, I think that sort of when you're looking at smuggling in the restriction into deciding what the proposed conduct is, you jump the tracks a little bit. So, I mean, I think sort of a priori, I'd say the way that B&L or Manny sort of framed things is just wrong. I understand that this 3-judge panel is bound by those decisions. So what I would say is two ways of distinguishing them, and one of just saying that even if those apply, we pass the standard here. So the 2 ways of distinguishing them is
eat you twice.
cases like B&L and Teixeira, again, they're narrowly geographically limited. And you can go elsewhere and you are free to acquire arms 600 feet away. Whereas this is always and forever, everyone is at constant risk and everyone has to go through this. Judge Bybee, one point on the facial challenge is one of the problems with doing an as-applied challenge here is the sort of difficulties with actually getting the state to run the background check, which they decline to do upwards of 10% of the time, is that you don't know why they're not running it. So it would be very difficult for you to actually bring an individual as applied challenge because, of course, they would moot your challenge. So, I mean, I think when you have
then it's capable of repetition yet evading review. But I mean, it seems to me if you came here with Mr. Johnson and said, Mr. Johnson's licensed gun owner has no impediments to ownership to acquisition of firearms or ammunition, and in the process moved, and it took California 110 days to get the problem solved. That seems to me to be a pretty substantial burden.
Well, we certainly have done that. I mean, he is a plaintiff in this case.
Right, but that's an as-applied.
Listen to what they said right there. So, in upwards of 10% of the time, it's more than likely well over that, California just refuses to run the background check, and then they won't tell you why, so you don't have a legal reasoning to even challenge it. So if you try to challenge it without that legal reasoning, the court just says, well, this is moot. This is so fucking dirty. And these judges up here who would even think about upholding this shit, knowing they know how dirty this is. You shouldn't be allowed to be a fucking dog catcher if you will play these types of games with people's lives.
applied challenge. So, and that's just why I'm so confused. I was confused by the briefs. I was confused by the district court's opinion because I didn't see the district court ever acknowledge that this was a facial challenge or ever cite any standards for what that meant.
So again, I would, just go back and look at the Lopez Valenzuela opinion, which I think explains sort of how this works. And I do think, just quickly on the B&L point, I think the way to think about this as different from those cases.
With Cerakote microstick dry lube film, no, I've got zero experience with it. I'll have to look it up and see what it is. You had me at lewd, but
Is that the state is controlling your access to something that is necessary to exercise the Second Amendment right at all.
oh God, Colt, tell me you're not watching that. And if I knew that was happening right now, I'd be streaming it because damn.
And it controls it always. You can't go out of state and bring it in because of the anti-importation regime. You have to go through this process, and for a large and arbitrary percentage of the people, they won't even do it. So if that doesn't implicate the Second Amendment, then it's hard for me to understand what would. Again, I think Bruin footnote 9 only makes sense if licensing regimes clearly are covered by the plain text. But I recognize that B&L Productions seems to state a very broad principle. And so, if the court wants to just say, we're going to assume that substantial impairment is the right standard, then of course, substantial impairment matters. I also think there's no way to do, Judge Bybee, a substantial impairment analysis because otherwise you'd have a bunch of people do this on a broad basis. And again,
Oh yeah, dude. If I knew that was happening, we would have been streaming that too.
the how
we
and the
might
why
stream it
are
later.
the standards at the historical tradition stage. And if we look at the state's proposed analogs, they're not remotely in the ballpark.
Well, you could easily come up with a statute that would fail the substantial, the meaningful restraint, our language from Teixeira and B&L,
right
on its face. If California said you're going to have to wait 60 days, and it was right in the statute. Okay, doesn't matter how 60 days. It's a waiting period. That's on its face. You win that one easily.
So I think part of the problem with what California did is they didn't do step zero. They didn't create the database that is necessary for this to work for everyone.
And so if they did it by driver's license, that would satisfy the Second Amendment.
So we don't think
I thought your position was that any restraint would.
So that's certainly our strong form position. But as Judge Benitez himself pointed out, if they'd gone with Prop 63, we'd have a much tougher case. We would have to win, assuming that it actually worked, but we'd have to win sort of the strong form argument because the way that worked is that was going to be a 4-year license where you paid $50 once and it just used your driver's license number and it would be instant. But instead of spending the time and money necessary to put in a database that, again, is the gatekeeper to one's ability to acquire arms, period, they said, no, we're going to piggyback on this other thing that has never been used for this. And we know now that it doesn't work. And so just quickly on historical tradition. So, the state's analogs, they try to rely on loyalty oaths, which you entirely control and they're one and done. The idea that that's sort of similarly burdensome to a regime where you have to pass through the state's gate and you can't force them to do it, and you have to do it each and every time you want to acquire ammunition.
Counsel, your time is going to expire, and I'm going to ask the chief to give me permission the presiding judge to ask permission to a different line. All of this is avoided if there's a problem under the under the Dormant Commerce Clause. So would you just take a minute and explain to me your best argument under the Dormant Commerce Clause?
Sure. So the state concedes that vendors need a physical presence and a license in California to sell ammunition to Californians. The only option for an out-of-state vendor to sell to a California resident is to funnel sales through a select few licensed in-state vendors. That's textbook facial discrimination, because what California has done is they've hoarded a low.
Yeah, Agarize, well, that's what this case is about, is the ammo background checks in California. This is the Ninth Circuit, of course, that we're looking at. And basically the constitutionality of having you jump through a fucking hoop, get a background check, be denied constantly, just to buy the ammunition that you need for your firearm to operate with.
Local market for a favored group of local merchants. We also have real evidence of discriminatory effects.
What California has done is said you have to have a face-to-face transaction here.
Actually worse than that. So, I mean, so if you look at a case like Black Star, which I think is their best case, which was the Arizona exception to the 3-tier system. So that had a face-to-face requirement. And what it said was you can sell, if you're out of state, you can sell 2 cases of wine in face-to-face transaction to an Arizona resident. Here, you cannot do that. You have to ship it to an in-state vendor for processing. And we have evidence in the record that many in-state vendors that are licensed are either refusing to accept the processing or they're basically charging exorbitant fees.
If you're a Colorado manufacturer of ammunition, obviously you can't ship it in over the internet. So you can't ship it directly to the house via Amazon, for example. But there's no restrictions on how much you can sell to a licensed vendor in California. I mean, Colorado manufactured ammunition is being sold in California.
Well, so I think the relevant distinction is not between.
Am I right?
We're saying, look at Washington. Wasn't there a whole system down like this? Something the past week. I don't know. I'd have to look. But yeah, Washington's losing their freaking complete, absolute minds on everything firearms related to. And it's like anything else. If you watch California, a lot of the shit that you see California do, all these other leftist states are going to pick up eventually. California seems to be the kind of proving ground for a lot of this horse shit.
Let me just make sure I'm right on that
Certainly
point.
right.
Okay.
The relevant distinction is not between Colorado manufacturers and California dealers. It's between California dealers and everyone else. And what California has done is in order to have access to this market, you have to go through the select few licensed dealers. The only other regime in history that looks anything like this is the 3-tier system in the alcohol context.
How would this work, for example, on the sale of cigarettes or alcohol if you can't sell to minors?
Yeah, that's something that drives me nuts when they get on all this other stuff off. To me, it's off topic. Okay, alcohol, cigarettes, ammunition. None of those are in the same fucking ballpark. One, alcohol is an addictive substance that can have negative effects no matter how it's used. Nicotine, again, 2 things I'm a fan of, by the way, can have negative effects if it's used as directed. And then ammunition, which can have no negative effects just for owning and using as directed. There's no equation to these things, but they want to somehow give these some kind of a legal equivalence, and it's just fucking ridiculous.
How would you do that outside of a face-to-face transaction?
So alcohol, of course, has its own sort of constitutional allowance. And the way that works is you have to sell basically from out of state, from the states that have the 3-tier system, you have to sell.
Let's throw it down to this. And just because it hit me, there were plenty of times long before I was 21, all the way down into probably 10, somewhere around there. At certain times, my parents would allow me to take a 22 and a box of ammunition and go down somewhere and go shoot. They never handed me a fucking bottle of alcohol at 10 years old and told me, hey, just go drink this shit. You'll be okay. It's freaking alcohol-filled bullets. Yeah, that shit. Let me get rid of this cough one day. Yeah, that might make drinking a little bit dangerous. I'm just saying.
Sell to an in-state wholesaler, and then they sell the retailers. So in many states,
but how do you deal with a minor problem?
Yeah, so
The three-tier system deals with a much broader problem.
right.
So how do we deal with the minors problem
so
and cigarettes?
So you can make it criminal to
Yeah, and the lawyer for the plaintiffs mentioned that kind of at the start of this, that there's never been a regime like this in the past, and California is a complete outlier on it. Which of course now they're not. There's been some other states that have picked up the background checks for ammo, but yeah, that alone, just the historical analog for it should make it completely unconstitutional. There was no historical analog for, okay, you want to buy powder, you want to buy ball, you want to buy lead, da 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 da. Okay, here's your background check. You have to pass this before you can purchase these things to make your firearm or your cannon or your mortar or your grenade or anything else like that operational. There is no historical standard for this or historical analog. That alone should just be like, okay, we're done with this case. But Jesus Christ, man, these judges will do anything they can, jump through any hoop, twist themselves in any knot, lie, cheat, steal, rape nuns, whatever they got to do to uphold this unconstitutional horseshit.
possess cigarettes if you're under 18. So that's step one. And if you want to have a face-to-face requirement, you could require licensure. I mean,
Right, but doesn't that sort of limit it to in-state sales?
So no, because I mean, again, this is not just the face-to-face.
Yeah, if we're talking about alcohol in the Constitution, yeah. How well did that ban work on alcohol? Not too good. It basically just took the mob and made the mob rich and powerful. I mean, it's about the only thing it accomplished. Well, the government poisoned a whole lot of people during that, caused a whole lot of people to die and go blind. And no one in the government was ever held accountable for that. Yeah, it's worked out like a whole lot of other shit. Gunpowder speakeasy. Yeah, Chess, if you join the military at 17, 18, they will hand you full autos, and they had no issues with it apparently.
This requirement, there's also section 30314, which is the anti-importation regime, where you cannot bring it in with you, period, unless you have it sent to an in-state vendor. No state in the country does that for any product other than alcohol. Not for cigarettes, not for anything else. And the way that they do it is they say, it's a crime to sell to kids. So if the kid doesn't age, if the kid age verifies, well, that's a crime. And so they have criminal laws for both the seller.
Yeah, now it's everywhere.
And often the shippers and the children. And that's the regime that works for tobacco. And there is no other regime in the country's history, not now, not ever, that says you cannot bring a product in unless you funnel it through a favored select cabal of favored in-state vendors, which can then charge whatever price they want. I mean, the state points out, and I know I'm far over time, but the state points out very briefly that, it's only $1 fee for the in-state processing. That's only...
Dude, Agorizer, if more people actually knew about jury nullification, and if more people respected the Constitution versus just being told or, following what they're being told by the state, then none of these gun laws would even matter because nobody would be convicted under them. If you stuck me on a case today and said, and I've got no hope of being on a jury anyway, but if you stuck me on a case today and the case was, well, this person had a machine gun. They never hurt another living soul with it. If it was a case like, oh God, I can see his face. And I should have my ass kicked for not remembering his name offhand. But if it was a case like him, where say he built machine guns and never hurt another living soul with them, if you put me on that case, I'm not convicting him. Fuck you. He never hurt another living soul. Why does he deserve to go to prison just because he had something the government doesn't like? Fuck them. But most people are not aware of jury nullification. And to be honest with you, most people don't have the fucking balls to stand up for something like that. They just don't. They're going to buy what the state tells them. They're going to do what the state tells them. And they will convict over stupid shit just because the state tells them they have to. And it's absolutely ridiculous. Certainly been removed from the courthouse for smirking. Yeah, more than likely. The state doesn't like it when you actually do anything which calls out their bullshit. All right, Agrizer, be careful on the road, my brother.
If you are there the moment the product arrives, which almost nobody is because it doesn't come with them. It has to come through a shipper. So unless you are there the second it arrives, they can charge whatever fee they want. And we have evidence in the record, the Abel's declaration and the ammunition depot declarations at ER 64 and 67, that they're charging exorbitant fees, which has had the effect of just completely decimating out-of-state vendors' sales to California residents. That's textbook discriminatory effects.
Okay, thank you.
Thank you.
Thank you for your additional comments. And
All right. So now the lawyer for the state, for Rob Bonta, gets up here and she gets her second kick at the cat. And then this case will be over, and then we'll look at something, and then look at the next case. So yeah, get ready for more horse shit.
you have some time left for rebuttal.
So I wanted to just start with the Dormant Commerce Clause claim. I think what the court's precedents show that requirements have been invalidated as discriminatory on their face when they impose requirements that are so associated with protectionism that they're virtually invalid per se. I don't think that that's what these statutes do. Anyone, regardless of where they're incorporated or where their workers are located or where they manufacture their ammunition, apply for a license to open up a vendor location in California. If not, they do have the option of having their, my friend on the other side suggested that the fee is just, it's limited. I just wanted to clarify what the requirement is. The fee is limited to $5 if the purchaser is immediately present. The fee that's charged for processing the requirement if the purchaser isn't present has to be agreed on with the purchaser ahead of time.
Is there a storage fee that's not specified?
Yeah, there's a storage fee, but it has to be agreed upon with the purchaser before the ammunition is sent.
So in other words, they just fucking extort you. Hey, if you want your ammo, this is what we're charging. This is what you have to pay to get your shit. And of course they're fine with it because a lot of people aren't going to agree to, an extra $100, $200, whatever on top of an ammo purchase. It's already costing them a few $100s. Fuck these people.
And to the vendor. And so the purchaser's the option of declining if it's, but I don't think there's any evidence in the record that suggests that in-state vendors have been imposing exorbitant fees. And then I wanted to quickly return to the Second Amendment.
Did you see the lawyer's head behind her? Watch, hold on, I got to back that up because I didn't see that earlier. Watch the plaintiff's lawyer when she says that horse shit. Oh, come on, computer, don't be stupid.
But it has to be agreed upon with the purchaser before the ammunition is sent to the vendor. And so the purchaser's the option of declining if it's, but I don't think there's any evidence in the record that suggests that in-state vendors have been imposing exorbitant fees. And then
he looks at his co-counsel and then looks back like, did she fucking really just say that? Yeah, she really just did.
Wanted to quickly return to the Second Amendment claim. Plaintiffs have confirmed that they brought this case as a facial challenge, and Rahimi reiterated that Salerno is the standard that applies. I think what plaintiffs' evidence shows at most is that there have been individual circumstances in which the background check requirements worked less than seamlessly. In many instances, I don't think those declarations show that the firearm owner was unable to obtain ammunition. And so to take one example, my friend on the other side mentioned the Johnson Declaration in ER 5558. That's certainly an instance where someone experienced a regrettable delay in updating their AFS records. But of course, that
would it be against decorum for him to raise his hand at that point and say, "Bitch, don't call me your friend. We ain't friends." Because that would be kind of where I would be going at that point.
That person also had the option of requesting and passing a basic check while they were waiting for their AFS records to be updated. And stepping back a bit, I don't think there are more than 20 declarations in the record that express some sort of complication with the ammunition background check system for a system that performed 600,000 background checks in the first 6 months of 2023. And so that's not the sort of evidence that suggests that plaintiffs can prevail on a facial challenge. As to the threshold inquiry, I do think BNL is binding because it did purport to establish a standard that applies to ancillary rights. Stepping back a bit, as Judge Bybee noted, there have been several circuits that have been confronting this question about what you do when you're evaluating a regulation that's one step removed from the plain text. And I think the McCrory and the Maryland Shell issue and the Oakland tactical cases show that other circuits are converging on an analysis that may differ in its phrasing, but looks quite similar to the analysis in BNL, where you do have to inquire into whether or not there's a practical effect on the right to keep and bear arms. And then as a final point, I just wanted to say quickly on the history, even if this court were to assume that this is a case that gets past Bruin's threshold step, the challenged background check requirements are supported by historical tradition. I think plaintiffs relied quite heavily on the fact that California's system is novel, but Rahimi and Bruin stressed that the Second Amendment was not intended to impose a regulatory straitjacket or foreclose states from adopting new methods for addressing problems. Those methods were consistent with historical tradition.
So what's your best historical argument?
I think we have several. I think the loyalty oaths and the founding.
Now, when I read the declaration on the loyalty oaths, it was interesting. It was interesting history. I wasn't aware of all of the history of the various oaths that were issued during Reconstruction. What I had a hard time figuring out was the connection between the loyalty oaths and regulation of firearms. We found one example in paragraph 30 of somebody in Lawrence, South Carolina, that apparently was restricting persons who could own firearms, or if they haven't taken the strike.
Jess, are you saying Schiff resigned from the House, or just a hypothetical if he resigns from the House? Because I would love to see him resign from the House. I would love to see him thrown in damn prison for the horse shit he's done.
Strong oath. But that seemed like a pretty thin example, and it was the only one that was there.
The Vormberg Declaration speaks only to the Reconstruction era loyalty oaths. We've also cited some pre-founding loyalty oaths in our opening brief, and those are included in the Spitzer Declaration as well.
And did they connect directly to firearms?
Yes, they were.
Oh, he's going to the Senate. Oh, fuck. All right, thanks for ruining my day. Everybody have a great day. I'm going to go find a 2x4 to ram into my head for the next hour or so. Yeah, him in the Senate's going to be so much fun. That lined pencil neck piece of shit.
Enforcing underlying prohibitions on possessing arms and ammunition. And so someone who declined to take the loyalty oaths would have their arms and ammunition confiscated. And in many instances,
the other side says those are one-time, one and done type events as compared to this, just every time you buy ammunition. What's your response to that?
That's correct. It's one time that you have to take the oath. I do think the record also suggests that often the magistrate was required to keep a record in place of everyone who had taken the oath and who had not. And I think that's a very close historical precursor to a kind of database system where you have the option.
A whole range of citizen-oriented rights were allowed, and there was no requirement to revisit it. Isn't that right?
I think that is correct, but what I would stress is that Rahimi made clear that the analysis isn't just to find a dead ringer in the past for something that looks like a modern background check system. The question is whether or not there are principles undergirding that history that suggest that a background check a requirement would be constitutional today.
No, it wasn't just a principle, lady. It was an analog. It was something that functioned in the same way at the time of the founding. And getting these loyalty oaths at the time of the founding, loyalty oaths, we were trying to found a republic at the time. And if people said they would not be faithful to the Republic, then yes, they were disarmed. They were enemies of the Republic. It was at the time of the founding. And again, that was a one-time deal. Even if someone who had conspired with England at the time, when the war was won, they were asked, will you now be faithful to the Republic? If they said yes, okay, it's one time, one and done deal. You know, fuck you, you're a piece of shit, but yeah, you get to keep all your guns. They didn't go through a background check every time they turned around, every time they bought ammo or bought a new gun or anything like that. It's, oh, fucking Christ. It's pure insanity listening to these people. But the reason we do it is so everybody knows where we stand and they can see the pure stupidity of this shit.
So,
And I
so
think-
the loyalty oath is your best historical analog.
I don't think we have to show a best, and I think we've cited a number of other examples. 19th century carry licensing requirements come to mind, where someone would have to come in and demonstrate that they satisfied a set of eligibility requirements before they would be permitted to carry firearms. And I think that the most important point is what these different historical examples are showing is that throughout history, governments have imposed screening mechanisms to decide whether or not people are disqualified from possessing firearms or ammunition. And I do think that the back
So just because governments did something completely unconstitutional in the past, you think it ought to be fine to do unconstitutional shit now. That's where we're at with this. I mean, this is like them using prohibitions against freed slaves from owning arms or Native Americans from owning arms as basis to uphold modern day gun control. These people are full of shit.
background check requirements are relevantly similar to that tradition. So if there are no further questions, I'll submit. We ask that you reverse the district court.
Okay, we thank both sides for their argument. The case of Rhode.
All right. So that case is officially submitted. And it'll be weeks, month, whatever, before we hear what happened with that case and how these judges rule, if they overrule Benitez or not. Just listening to the questions the judges asked, I think this is a 2-3 decision that actually upholds Benitez's decision. But again, I could be completely wrong. It's very hard to gauge some of these judges until you get into, say, the Supreme Court, and we've heard these judges many times, and kind of know how they're going to rule on a lot of things. It's really hard to judge. And I mean, I've been wrong about how some of these are leftist judges on the Supreme Court were going to rule. All right, let's look at something that Brother Chess sent me. Screen share. I think this is it. So this is after the assassination of the CEO for the health insurance company. And after certain things with health insurance that I've had to go through in the last little while. No, I'll keep that thought to myself. Let's see what this says. Fatal shooting on Wednesday. Top healthcare executive Brian. Never experienced health insurance companies' hardest times in their lives. Torn of morbid glee from patients and well, yeah, well. say they've never had to deal with experienced companies. Well, apparently there are some people I could agree with. Thoughts and deductibles to the families. Ooh, shit. Yeah, that hits. Read one comment underneath the video of the shooting. Unfortunately, my condolences are out of network. Yeah. One TikTok user wrote, I'm in the ER. Things have been, I've seen dying patients get denied. Insurance makes me physically sick. I can't feel sympathy for him because all the patients and their families. I will say, again, after being denied for back surgery because I'm a smoker, and not just because I'm a smoker, but because I am a nicotine user. So I could be getting nicotine through vapes or patches or pouches, which patches and pouches are the way I'm trying to quit smoking right now. But just having nicotine in my system was enough to deny me for back surgery. They'd rather me be in pain and have to see doctors and be on narcotics and all this other shit just to be able to make it through a day. Yeah, my give a fuck is extremely low about anybody who has anything to do with insurance companies these days. To do dark commentary on the death, 50-year-old insurance executive highlighted anger and frustration. Yeah, I can see that. Hold on, what was this? This messages that law enforcement officials say found on bullet casings at the scene of the shooting in front of Midtown Hotel. Delay. 2 words familiar with many Americans interacted with the insurance. This dude might quickly become my hero. Providing millions to healthcare, sole employees. Company has legal issues as well as running up stocks, upper echelon, selling off stocks. Yeah, that doesn't fucking surprise me. The insurance, the situation we're in with insurance companies right now is a complete racket, and it has been since its inception. And the reason we're in this is all government created. Because certain companies back in the day, and this is boiling stuff down to or maybe blowing it up, taking a 10,000 foot view of it, you might say. Companies wanted to offer medical care as incentives to come to their companies because the government decided, well, you can only pay people so much to do certain jobs. So they decided to offer medical care as part of their benefits package to entice people to come to work for them, which added in the insurance companies, which put a layer of bureaucracy in between you and your doctor, and then bunches of shit that added on to that puts us where we're at right now. But I mean, if you wanted to distill it all down, it's another government created fucking issue. It's the reason that you can't afford to actually go to your doctor and pay cash most of the time. And I've been in a situation where I was paying my doctor's cash, and I paid cash for procedures that would have costed 3 times as much if the insurance company was paying for it, which is insane, but that's the way it works. So if I looked at a bill from an insurance company for an MRI, they were charging or actually paying for the MRI at either $1,500 or $2,000 a pop, where if I walked in and paid cash for the MRI, I paid $500. And I've literally done that. It's not a speculation. It's not a second, third hand story. I've done that. Matter of fact, at one point, I think it had been, I don't know, a few months in between, but my girlfriend at the time had insurance. I did not. I had to have another MRI done on my back. I went in another time where I paid $500 for the MRI, had my MRI, walked out with it. She had insurance, and our out of pocket for the MRI was $1,000. I can't remember which insurance company that they had at the time or what plan, but yeah, our out of pocket was $1,000. That's not what the imaging, and I think we had them done at the same place at Columbus Diagnostics over in Columbus, Georgia. That's not what Columbus Diagnostics charged the company. We paid $1,000, and then the insurance company paid so much. So they probably got at least $2,000 off that MRI. It's absolutely ridiculous. Insurance industry is not the most loved, to put it mildly. You think? Executive, another insurance company, longtime employee. Members were unhappy with Mr. Thompson as one of the few executives who wanted to do something about it. Speeches, Mr. Thompson spoke about the need to change the state of healthcare coverage in the country. So this dude was actually speaking out against shit with the healthcare. Yeah, well. CEOs are quite often the most visible face of the organization, he said. Sometimes people hate on the individual and wish to do them harm. I have heard people close to me say that when an insurance company denied certain procedures, that if they could find that person, they would burn their house down with them in it, and didn't mind boiling their goldfish. And, I feel that. Read last week there was a insurance corp that was limiting cost on anesthesia. Dude, I don't doubt it. I've never had insurance in my adult life where they didn't turn around and fuck me in one way or another. I never have. All right, so let's do this. Now that we've firmly established that the rest of America is much like me and can't stand insurance companies. And believe it or not, this topic kind of ties into it. Because insurance companies are actually paying for some of this shit. So Tennessee decided, to give a little background on this, that, hey, maybe it's not a good idea, and maybe it should be illegal to give things like puberty blockers and surgeries to minors, people under 18, that feel like they need to change their gender. And this is the United States government right now arguing that this law is in fact against the Equal Protections Clause and is illegal. So the United States government right now is arguing for giving minors puberty blockers and operations to allow them to change their gender when they can't even get a fucking tattoo because giving a minor a tattoo is illegal, but cutting their dick off is not. Just to throw that out there. Zany, what's going on, brother man? Yeah, you have to stay awake for your butt exam. Yeah, your butt inspection now. Yeah, believe it or not, I'm kind of overdue for that one, and not looking forward to it. So let's listen to the oral arguments in the United States government thinking it's okay to give children puberty blockers and cut their peckers and breasts off and give them addictomy operations, apparently.
The Supreme Court heard oral argument in a case challenging Tennessee's ban on transgender medical treatments for minors and whether it violates the Equal Protection Clause of the 14th Amendment. This is about 2.5 hours.
Yes, it is.
We'll hear argument this morning in case 23477, United States versus Skrmetti. General Prelager.
Mr. Chief Justice, and may it please the court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria. But
brother, at this point, they either don't realize it or they are just trying to make it happen to stop global warming or something like that. I don't know. I ain't figured it out yet. This is the U.S. Solicitor General. Apparently, she is one of the most evil people I've ever heard in my life. And she is arguing again for giving minors as young as kids who have not went through puberty yet, puberty blockers and surgical interventions. If you think the arguments in gun control cases are absolutely insane, I'm going to let this play, hopefully without snapping out. And you are fixing to hear some of the most insane arguments on this goddamn planet. Chris, what is up, my brother? How are you? Welcome to hell. It's about the only way I can put that.
SB 1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as a gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients.
Good to see you too, brother Chris.
SB 1 categorically bans treatment when and only when it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law.
All right, so let me throw something out here so we can kind of lay out some real general framework. So the puberty blockers, in some cases, do have a medical use for cases of childhood cancer where the child actually experiencing puberty could cause the cancer to be worse or to actually grow. It's getting into a whole lot of topics with that. But it could effectively make things worse. So they give them the blockers to keep them from going through puberty while they treat the cancer so that hopefully they can stop the cancer and then the kid can go on to actually live their life. So there is a medical use for these. What Tennessee is saying, outside of that justifiable medical use, you can't give a child medications to stop them from going through puberty as a natural course of their development, which is the same thing to argue, because it's absolutely insane to stop a normal, healthy child from going through normal, healthy puberty. It just is. Is puberty this fucking comfortable time in a child's life? No. All of us experience it. It fucking sucked. But it is what it is. It's what we all do. It's what we all go through. Fucking it's a healthy part of human development. But you're fixing to hear arguments that, oh my fucking God, are absolutely insane. Decapping Rod just pulled a Houdini on me and vanished into thin air. Yeah, that sounds like some shit that would happen to me, Blades.
And that SB1 should be upheld so long as it's not wholly irrational. That's wrong. SB1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care. But here, Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB1 can be reviewed under the correct standard. I welcome the court's questions.
Much of your, the latter part of your opening statement suggests that well, it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's
Dude, Blade, that is awesome, man. And I've said it before, Chris does probably some of the best gun content on YouTube, hands down. His production value, his cameras, everything is just fucking off the charts, man. So yeah, dude, thank you for subbing to his channel. You will get a lot of cool information.
really for minors. So why isn't this simply a case of age classification when it comes to these treatments, as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making that this isn't a sex-based line in the first place would equally apply in that context. But the court has likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how.
Well, that's something, Blades, and that's a good point. And that's something that we've seen in recent years is the whole being trans thing has really become a fad. It absolutely has. Because kids go through shit. And they're looking for certain reasons to feel certain ways, and they've been told this is what they are for so long, instead of just, hey, suck it the fuck up. Everybody feels uncomfortable going through this shit. So yeah, I mean, that's a very valid point. And it's become cool. Oh, I'm trans. I'm now in with the cool crowd. I'm now part of the protected class, and that's the way this is run.
The state
Oops.
ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference in if a girl takes testosterone?
So the district court specifically considered this question in detail and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with the cross-sex use
Is
of the
there no
hormones.
physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth.
And she is lying through her fucking teeth right here. If you take a girl and you feed her testosterone before she reaches the age of puberty, then her sex characteristics will not develop as they should. You will effectively make her infertile. If a boy takes testosterone because, say, he has some glandular problem where he's not producing testosterone like he should, then he's normally going to develop along normal lines. If you take a boy and you feed them estrogen before they reach puberty, then their primary sex characteristics, from penis size to everything else, is actually slowed to the point where they can end up with what you call a micro penis, and they're infertile. So there are absolute negative events that happen when you feed these kids cross-sex hormones. It is a fucking lie to say that there is not.
Or sex if he was taking
I'm
those
more
medications.
interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to a female, and
So,
vice versa for estrogen.
so if you take hormones, they will prompt the development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth.
Tis true,
And in fact, that's one of the intended effects of these treatments, because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks, and that it leaves regulation of medication unrestricted, even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just... Counsel, you rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig Reborn and some of the other ones, where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset. And it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally, that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certainly prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig v. Boren, different drinking ages, or Morales, can men and women adopt children in the same way?
And I think the court could recognize that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there's some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think we're asking the court to break new ground in this case. And in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification. But then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
Well, can I ask you a question about the state of medical evidence at the present time?
Yeah.
In your petition, you made a sweeping statement, which I will quote: overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2020.
Yeah, that was one use for them, was chemically castrating pedos. The other use actually had to do with cancer in kids, and certain cancers, once hormone levels rise, the cancers got worse, actually caused more growth for the cancers and stuff like that. That was one of the original uses for so-called puberty blockers. So this absolute evil industry that has evolved around changing kids' gender is definitely using these as off-label, and you'll hear some more arguments about off-label use during this oral argument. I think the way you stop chomos is to feed them into wood chippers feet first. I think that's the best way to do it. Really, really and truly. Big wood chipper fan. I don't know about y'all, but definitely a big wood chipper fan when it comes to that.
3. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the
Oh, no
risks
doubt,
of
Blades.
puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course,
Yeah, but there's not overwhelming evidence, and there has never been overwhelming evidence that these so-called treatments outweigh the effects of them, the negative effects of them. Every freaking rational study on this planet has proved that giving someone so-called gender affirming care does not change the depression rate, the suicide rate, or anything of people who get this so-called care. And as a matter of fact, the studies that have actually been done that talk about the suicide rate before treatment and after treatment prove that there's no change. And in fact, more people will commit suicide after the treatment, but if they don't get the treatment, more people will actually, I want to say grow out of, but it's more, they will be able to basically grow into their sex versus changing their sex and then committing suicide. It's not even close. And you got to remember this whole, a lot of this premise is based on research done by a fucking pedophile with a group of pedophiles. This whole gender affirming care, all this bullshit.
acknowledge, Justice Alito, that there is a lot of debate happening here
It
and
does
abroad
change. It
about the
increases,
proper
yeah.
model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the Cass report and Sweden,
Well,
but neither of those
can be medically
jurisdictions.
necessary for some minors, but for the general run of minors, do you dispute the proposition, in fact, that in almost all instances,
I will dispute that gender affirming care is needed for any minor at all whatsoever. You turn 18, do what you want, don't care. You're under 18, no, you can't take these chemicals. Guess what? You can't even get a tattoo. You can't cut your dick off. You can't get a tattoo. You can't cut your boobs off. You can't get a tattoo. You can't get a dick added to you. Just saying, it's kind of the logical position.
judgment at the present time of the health authorities in the United Kingdom and Sweden is that the risks and dangers greatly outweigh the benefits. Do you dispute that?
I do dispute
That
that
is a
because if you
huge
actually look
problem,
at how
lady.
those jurisdictions are addressing this issue, they have not outright banned this care. The CAS report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course, it's true that they have called for a more individualized approach to these issues and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that in England, I'm sorry to interrupt, but the time is running out, that the National Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and are already on estrogen, but for those who are under the age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the CAS implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Isn't all of that true?
I believe that all of that's true. It's outside the record in this case. And so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
No, those other countries have not banned the administration of these drugs. They have seriously restricted it, though. And it's, oh, fucking Christ. It's maddening listening to these people.
Well, in your opening brief, you did not mention any of
Yes,
these
Cole,
European
you would need a
developments.
stamp.
And in your reply brief, is it not true that you just relegated the CAS report to a footnote?
So Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically ban it no matter the need. With respect to the CAS report, that isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary Cass was not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief, that's obviously a facial sex classification, but our primary argument.
So not, and she's drawing a distinction here, or using an example, that not giving a kid puberty blockers is like telling a kid you can't dress like the opposite sex. How fucking ignorant do you have to be to use that argument? Because a girl merely so-called dressing like a boy does not affect her physically. Giving her puberty blockers, on the other hand, can make her infertile. It can effectively sterilize the kid. It's so insane. And you're right. They don't need reassignment. They do need a shrink. why are we not focusing on getting these kids psychological help, and we're just focusing on going to right off fucking, I don't know, cut their breasts off, add a dick to them, cut their dick off, turn it inside out, turn it into a fucking faux vagina. Why are we not focusing on the things that would actually help the kids versus just doing something aesthetic, basically? An aesthetic, and that's a very loose term because it actually mutilates the kids. It's, I told you guys, this one was going to be a lot more insane than listening to gun control arguments. Told you, I warned you. I wasn't joking.
SB 1 is worded exactly the same way, and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language in a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment. And the court has addressed the question how an equal protection claim should be analyzed when the law in question treats a medical condition or procedure differently based on a characteristic that is associated with just one sex. And that was Geduldig in 1974, reaffirmed in Dobbs in 2022. And neither Bostock nor Dobbs saw any connection between the Bostock reasoning and the Geduldig-Dobbs standard. Bostock did not mention Geduldig, and Dobbs did not mention Bostock. So why should we look to this Bostock-type reasoning here?
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the court's approach in Bostock and what this court has long done under the Equal Protection Clause.
Now, let me say this, and I got to throw this in here. So a facial sex classification would be, and an argument that would actually fit there is, just because it's my case, this woman can get back surgery, L5S1 disc, whatever, and this guy can't. And we're going to do that because she's a girl, and we're not going to do that because she's a guy. That would be discrimination under the Equal Protections Clause. It's two of the exact same cases. One is done because of a sex, one is done or not done because of a sex. That would be a case that would fit. This horse shit, trying to shoehorn that into equal protections, even though minors don't have legal rights, is fucking straight out, again, insanity.
In both contexts, the court has made clear that the right to equal
Brother Bob, what's up?
treatment is an individual right. So you look at the particular person and see how the law affects them. And the court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen.
No. Oh, fucking Christ. Both boys and girls for decades have not been prescribed these medications to fucking stop them from going through puberty because they feel like the opposite sex. That is a recent event. You lying. I'm trying not to say the word. I'm trying not to say the word. I'm really trying not to say the word. I'm gonna say the word for too long. Bob, what is up, brother man? How's it going?
They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose the statute said, let's just talk about puberty blockers. Suppose the statute said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty. So it's ruling out precocious puberty.
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
Brother Wilbur, what's going on?
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear. We only want to prevent the medications when it's inconsistent with, because we have an interest in having minors appreciate their sex and not be disdainful.
Well, let me
ask
one final question that addresses Golding and Dobbs. Let's take Golding first. One could make the same argument in Golding that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy.
Now, let's throw a couple things in here. One, just because I'm an asshole. The man or woman can get the surgery. Apparently, if they don't have nicotine in their system, then the insurance company can tell them to go fucking pound sand. So there's that. Just where I'm at. But two, why can we not recognize the difference in between men and women? There's a difference if I'm a man working a job and I get injured on the job and get benefits, versus if I am a woman and I get pregnant and then get benefits. See, one is a condition. So if I'm a man working on a job and I get injured on the job, I should get benefits from the company because I got injured on their behalf. And the other one is I got injured injured, using that as a very loose term for pregnancy, off the job. But I agreed with my company when I got hired on that I would have some kind of benefit, pregnancy leave, whatever, for that period of time. Those are very different things.
He cannot get an abortion. So you can make exactly the same argument that you make here under Godaldic and under Dobbs.
Yeah, I'm fixing to identify as a cripple here shortly and probably won't be able to take a whole lot of time off work at all, actually. No, in all serious, which I'll talk about later. No, I've got a epidural scheduled on the 7th of January. And as long as the insurance company doesn't shoot me down for surgery, I have carpal tunnel surgery done on the 9th, which will be on my wrist and my elbow. But we'll see. We'll see whether the insurance company shoots this one down like they did my back surgery. It doesn't make me feel too sympathetic with people from insurance companies getting injured these days. Just throw that out there.
And yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex. And that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through.
Oh, dude, Bob, I've had plenty of epidurals. None of them have helped with my pain. All of them have been painful. This will probably be my 5th one, somewhere around there. Yeah, I'm very familiar with them. Most of the time I get them, I have to have someone drive me there. I have to have someone that drives me home, and then I leave there and I go right to work. That's the way I've done pretty much every single one of them. Yeah, dude, Wilbur, I've had, like I said, probably five-ish. Yeah, probably right around there. I've never had one help me for more than the amount of time it took the anesthesia to wear off. It's just been the way that they've worked. I've had a couple where I've had the epidural, went home, didn't do shit, laid around all day. I think I took, in one case, took like the next day or so off, tried to chill out. The last 3 that I've had, I left there and went right to work. I mean, they just leave me sore as shit for a few days.
And I don't think it's controlled by Dobbs or Godaldic.
Thank you, General.
Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII.
Yeah, dude, I know some cats that have had them and they worked for a long time. And I know other people that have been like me and they haven't done shit. I mean, as soon as the anesthesia wears off, you're right back to where you started. And that's where mine have always been. As soon as the epidural wears off, no, it's right back to being right back in the same pain. Just a little more sore from having the needles poked in me. And normally when they do mine, they do them on like 3 levels. It's never just a single level. Normally it's 3 levels in both sides. So I'll have 6. They go in, they'll numb you up. So 6 sticks to numb me up, 6 freaking I can't remember what they call them, slid in, and then they'll do 6 sticks for the epidural. So yeah, I've never had one help. Along with the nerve ablations and all the other shit. Yeah, all that's never done shit.
And or the Equal Protection Clause.
Besides
The
leaving
first
hurt.
question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course, we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be.
Now, wait a second. Didn't she argue with Clarence Thomas just a second ago that she wasn't using a Bostock-ish argument? And now she says, of course we're using the logic of Bostock. Fucking what?
One but-for cause.
Dang old Matt, how's it going, brother man? How are you doing tonight?
Doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think that's an important.
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
with respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether. The Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European.
Well, yeah, you're right. She's very intelligent, Bob, which is part of what makes her so fucking dangerous when it comes to arguing this shit. Fluffy! What's going on, brother man?
European countries, correct?
Yes, I think it's reflected in the laws of those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, the things that are wrong or right. For decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is.
There is zero actual evidence that points to these kids, especially the preteens, kids needing this treatment. And you're fixing to hear some arguments from Sotomayor. God, she is the dumbest bitch I think to ever sit on a court wearing a black robe. Her actually being confirmed to sit on the Supreme Court of the United States, realizing that people like Lindsey Graham and other Republicans voted for her to be on the court, is enough to tell you that Lindsey Graham and other Republicans should never be allowed to hold a government office, and Sotomayor herself should never be anywhere near a courtroom unless she is the fucking defendant in a case.
Is uniform on that, whether you look at the standard of care.
Look, no, don't get me wrong. Ketanji Brown is fighting hard to be the dumbest bitch on the court. But Sotomayor right now still holds the title. Uh, trust me, Ketanji Brown ain't far. She is trying. She's fighting hard.
Whether you look at the view of every major American medical association that has taken a position, many of whom are amici here, it's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious
They
medical
think
condition.
some attempt suicide.
Yes, the rates of suicide are striking,
Some-
and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of his
Sounds like a lot of things that could be solved by, I don't know, mental health counseling versus giving them irreversible fucking drugs and procedures.
because of their inability to speak in a voice that they could live with.
Yeah, Fluffy, 100%.
These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments?
That's a hell of a graphic. Sotomayor and Elizabeth Perloger, however you say her name. It's like two dumb cunts, one argument instead of two chicks, one cup. Probably shouldn't have said it that way. That'll probably get me in trouble. But hey, it is what it is.
But that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary.
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take ideation.
Oh, I gotta let this play. I know I do. But one, there are zero health benefits from giving minors so-called gender-affirming care. Zero health benefits. To even say that someone is not taking into account the health benefits is so intellectually dishonest. Ah, shit. I'm gonna let it play. Let it play, Coop. Let it play. Let it play. Because yeah, I'm fixing to throw some shit.
And suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Well, 2 points here. I know I gotta let it play. I gotta let it play. But 2 points here. One, it's not just women. Anybody coming at these things from an emotional position, and 9 times out of 10, women are going to come at things from an emotional position. If you're coming at things from an emotional position, you shouldn't be involved in any of this shit. You shouldn't. That's all there is to it. And I completely forgot my second point because I really, really, really want to like throw some shit. Yeah, anything emotional shouldn't even be involved in this. It's not emotional. There's a condition that needs to be treated. If you're born a boy, you need to be treated as a boy. If you're born a girl, you need to be treated as a girl. If you have dysphoria about the sex you were born with, well, then you need counseling. You need some sort of treatment to address whatever is causing your dysphoria. You don't need physically altering treatments to make you look like the thing that you think that you are. It's no different than there are people in the first case I ever heard about someone with a dysphoria condition was a woman who, oh God, I can't remember which show I was watching. She was born perfectly functional, legs, whole 9 yards. She was dysphoric about her having functional legs. She thought she ought to be paralyzed. She just had that condition. And the argument was whether a doctor would go in and basically sever her spinal cord to paralyze her or to treat her for the mental issue.
Thank you.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification, because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is a discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state. And it's true, it arises in the context of medical care for transgender youth. But here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock, or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. You know, I think the court's recognition that
how is a woman or a man dressing like the opposite sex or taking a job that is primarily done by the opposite sex anything like giving them medical treatments that are irreversible? A dude can put on a dress and wear it for 6 months and then turn around and put on pants. It does not change his dick or his Adam's apple or his voice or anything else. A girl can put on pants and wear them for fucking 6 years. It doesn't change her boobs. It doesn't change her wuss. It's...
that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will, for, you know, a person born male who wants to get to puberty already.
Well, that's basically what she's doing, Blade.
And you say that that's a kind of under-inclusion problem. And, you know, it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, like, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because you seem to want to say, no, you can do heightened scrutiny, but you can also make certain deferential moves towards the legislature. And I guess I'm pressing you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one
yeah,
is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated.
Now remember, she's talking about their, you know, this is on disproportionate whatever about sex. And this is all about kids, children, under 18, but mainly with puberty blockers, children that are, you're talking, what, 10, 11, 12 years old, before they go through puberty getting these medications. So you have the United States government, again, the United States government, this is the Solicitor General, arguing that kids should get these medications to stop them from going through puberty. So you were talking about, you know, prepubescent kids, 10, 11, 12 years old. The government is arguing that they should get this medication or these treatments. Treatments.
For all other purposes, and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the
now, Oh, I wasn't going to pause it again that quick, but we'll pause it again that quick. You notice the switch that she uses. She's not talking about suicide. She's talking about suicidality or suicidalness versus actual suicide attempts and successful suicides at this point. Because, and the reason she'll argue that is because there are plenty of people, if you ask them if they've ever had suicidal thoughts, they'll tell you yes. And they really haven't seriously thought about suicide. And I say that because there are times where I made a joke about it in the past or said something about it in the past and hadn't really thought about it. There are other times in my life where I've been very close to it. So those are very different in between the so-called suicidality and actual the rate of suicide. And the rate of suicide in between people who actually get this treatment and people who don't get the treatment, the people who get the treatment actually have more suicides, successful suicides, than those who don't get the treatment, because those that don't get the treatment generally age out of this whole gender dysphoria nonsense.
The West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to...
Hold on, Bob. The judge in the Penny case took man 2 off the table? What? Yeah, last I heard, the jury was deadlocked in the case. Judge dismisses manslaughter charge against Daniel Penny. Jury to return Monday to mull criminally negligent homicide charge. Oh, so they took man off the table and left the criminally negligent on the table, which I think are pretty much the same goddamn charge when it comes down to it. Penny has a civil suit to deal with. Yeah. Apparently the asshole that ended up dying, I won't say Penny killed him because Penny didn't. The asshole that died, apparently now his family gives a shit about him and they're suing over his death. Fuck these people, man. Just
agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny, precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, want to ask about our role here and pick up on the Chief Justice's questions at the beginning. Who decides? I mean, you've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20 plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law. And I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here. But when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court saying, looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should.
Yeah, it's funny how that works, Bob, isn't it? They didn't give a shit about him when he was homeless drug addict, but when he does enough drugs where he freaks out and then ends up dying, all of a sudden they give a shit about him. Oh, my baby, my baby.
Should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is, then you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, the way you would think about this is, I guess it prohibits all boys and girls from transitioning using certain medical treatments. And it doesn't say only boys can do so or only girls can do so.
Well, I think the problem with trying to put that transitioning label on it as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that.
Yeah, that's an interesting point that he brings up right here. Believe it or not, legally, because she's arguing for the federal government. She's arguing for this, which shows you our federal government is absolutely evil. But she's arguing that some sort of sex-based discrimination is going on here. And Kavanaugh just brings up that, wait a second, this isn't a sex-based discrimination. It is stopping boys and girls under the age of 18 from getting these treatments. So therefore, it's not a sex-based discrimination at all. This is basically what he's saying right there, which is true. It has nothing to do with boy, girl, boy, whatever. It has everything to do with, no, boy or girl, you can't get these things if you are under this age, the age of 18, for the purpose of changing your gender characteristics. I can't stress this enough. Your federal fucking government, your tax dollars are going to argue that preteens should be able to get puberty blockers. This is where your tax dollars are going. Besides Ukraine, all the other bullshit they spend it on, illegals, whatever. They're spending it on defending, giving children, prepubescent children, drugs to stop them from going through puberty.
For what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety
Jordan
for
Neely's
minors.
42 prior arrests.
You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind and want to detransition, which I don't think we can ignore. We can't ignore what you're talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or
Fluffy,
rational
they will do
basis,
anything they
those
can to protect
justifications
their
for the
narrative
state,
and
how
their
do
argument.
we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
So let me react to a couple of different points you brought up. First of all, I do think that the standard of review very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that anytime the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern. And here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender affirming care at all. And also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves.
Her argument here that puberty blockers have no effect on fertility in and of themselves is absolutely medically fucking false. It is a goddamn lie. You take a girl and you give her puberty blockers and her ovaries, uterus, and everything don't develop as they should according to the hormones that her body would normally feed her, she is going to be absolutely infertile. A boy, if you give him estrogen, his penis, testicles, everything will not develop as they should if he had the same or the proper balance of testosterone in his system. He will be effectively infertile. To say that that does not happen with puberty blockers is an absolute goddamn lie. It's absolute horse shit. And it's the kind of shit that she can sit there and say in these documents because she has a couple of doctors that are activists that support this shit, while medical science in and of itself completely disputes her point. But she gets to say it because now these medical institutions, fucking American whatever doctors, have become so far left they support this horse shit. Because their industry, their medical industry, is making billions of dollars off of this shit now. It is making some of these doctors absolutely goddamn rich. So they, of course, will do it. It is fucking maddening. Again, I'll say it again. If you guys think the arguments in gun control cases from the left are mind-numbingly maddening, these are even worse. Yeah, Fluffy, micro penis, the whole 9 yards. I mean, there was an article not too long back, and I didn't read the whole thing. And this fucking stupid woman decided that her little boy was a little girl and got him puberty blockers when he was extremely young, before he went through puberty. And then when she wanted to transition him to a girl after all of that, well, guess what? The tissue from the penis that would have been used to make the vagina afterwards was so small, they couldn't do it because he had a micro penis, because she had him on estrogen when his body should have been getting all the testosterone, and it completely screwed everything up. Because guess what? Little boys are supposed to be developing on testosterone fed to them by their bodies normally, naturally, and little girls are supposed to have estrogen fed to them by their bodies normally and naturally. And yes, little girls will have very minute amounts of testosterone. Little boys will have very minute amounts of estrogen. That's just the way biology works. It's been that way since the dawn of fucking man. And now all of a sudden we want to change it, and then we're having all these issues, and then we got people wanting to do shoot. And then we wonder why. I could, yeah, I could talk about that for hours.
On fertility. So I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity. With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks.
Oh no,
As I said
Fluffy, they
before,
ain't about
I
to
can
bring that
understand
up.
that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB1 expressly permits, like on intersex individuals who often have surgeries as infants. That
Okay. Intersex individuals are completely different than a individual who was born obviously one sex or the other. Hence the fact that they are intersex, which is such a minute amount of births that it's not even funny. And yes, most of them tend to be born infertile, and their primary sex characteristics tend to be freaking all over the map. Micro penis, huge clitoris, vagina. There's so many things that happen with the intersex births, but they are such a very, very small amount of actual births, people, and you can't treat normal, healthy, viable people like intersex people. They are very fucking different. Hence the fact that the intersex people either have a lacking chromosome or an extra chromosome. Down to their chromosomes are fucking different. You can't treat them the same. Biology is a fucking thing. Oh my fucking God. Jim, what's going on, brother? Dude, I haven't seen you in a minute. Of course, I haven't been on in a while either, so hey, it is what it is. Welcome to the absolute shit show, brother. Vanessa Kitty, my sister, what's happening?
might permanently affect their fertility. I would also say that if you are
Yeah,
concerned
it's been
about
a hot
fertility,
minute,
there
man.
are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rate.
Dude, I was following you as the Tactical Pineapple before I even began to start my channel. So it's been a hot fucking minute, man. Hopefully you and the fam are doing good.
Of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is, you have this population of adolescents and there are documented very essential benefits for a large number of them, and maybe a small number that will regret this care, just like with any other medical care. But for the state to come in and just say across the board, you can't have the medication because of your birth sex, we don't think that's a tailored law.
You acknowledge there is some group, though, who later changes their mind and wants to detransition. That doesn't defeat your case. I just want to make sure you acknowledge there is, as a factual matter, some group of people.
Yes, we're certainly not denying that some people might detransition or regret this care, but all of the available evidence shows that it's a very small number.
Then to pick up on the Chief Justice and Justice Alito's questions, it's obviously evolving debate. I mean, just in the last couple of years in Europe, big changes in terms of how they're thinking about it and how they're thinking about these risks and benefits that you and I have just been talking about and you've been elaborating. If it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as, pretty heavy yellow light, if not red light, for this court to come in, the 9 of us, and to constitutionalize the whole area when the rest of the world, or at least the people the countries that have been at the forefront of this, are, pumping the brakes on this kind of treatment because of concerns about the risk.
Yeah, now we're talking about the constitutionality of things. I've read the Constitution many times. I've never seen in the Constitution a single time where you have the constitutional right to get medical treatment to change your birth gender. It's not in there. I haven't seen it, not a single fucking time. I haven't seen it. Yeah, no kidding, Bob. Yeah, if Sweden's pulling back, yeah, you need to be fucking thinking about some shit's probably pretty bad, because they tend to be way on the left end of shit. But yeah.
Yes.
We certainly are not asking the court to set forth some bright line constitutional rules in this space that is going to really take further debate and evaluation of regulatory options away from states. We think, as I mentioned, that the court really only needs to decide the first order question here of whether this law classifies based on sex. I think that's entirely distinct from some of the concerns you've identified about what justifications the state has.
Do you think that West Virginia law you mentioned is constitutional?
I think it would likely satisfy heightened scrutiny. It hasn't been subject to adversarial testing because I don't think anyone has sued to challenge it. So I haven't looked at the record that West Virginia would build, but I do think that there is room here for states to enact tailored measures to try to guard against the kind of risks that you're concerned about and that the state has identified.
And last topic on the heightened review, and you say all we need to do is do heightened review, and that's kind of a minimal step. I mean, I'm not sure really that the follow-on effects of that could be pretty significant. I think Justice Kagan alluded to that in her question, or at least raised that as a question. And want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports? In particular, would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports, basketball, swimming, volleyball, track, etc., notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case? So can you explain how intermediate scrutiny would apply to women's sports?
Yes, and just as a threshold clarifying point, I want to be clear that when it comes to access to sex-separated spaces like sports and bathrooms, courts already recognize that those are facial sex classifications that trigger heightened scrutiny. So it's actually not the question teed up here about how to classify the law in the first place or how to identify whether it's a sex classification. Instead, that's taken as given in that litigation, and the entire focal point of the disputes in those cases has been, well, does the state have an important governmental interest, and does it need to draw the lines to exclude transgender people?
Right, but how would intermediate scrutiny, which we may not, if we went to intermediate scrutiny, there's a possibility we would apply it here. How would it apply to, in your view, and maybe you don't have fully informed views, which would be fine, but how do you think they would apply to sports?
So courts have split on that issue, and I hesitate to try in a vacuum without an actual factual record to try to opine on the state's justification and whether it will satisfy that standard. It's obviously a different set of governmental interests that are being asserted there, and those would have to be analyzed in their own right. But I think that this court, if it wants to preserve space to make clear that nothing here should be understood to affect the separate questions that are arising there, the court could very well do so, and we would have no objection to explicit language saying this decision does not in any way or should not be understood to affect the separate state interests there that have to be evaluated on their own terms.
Okay, but looking ahead, do you think it's logically possible as a matter of constitutional decision making to say that laws like the one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny? Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think one readily apparent difference is that in the context of sports, there are arguments made that that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts. There's nothing gender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people. And so I think the court could well understand the statute here to fail intermediate scrutiny, even if it would survive there.
Thank you.
Justice Barrett.
Morning, General. I want to pick up on one of Justice Kavanaugh's early questions. You know, he pointed out that the burdens of the law fall equally on boys and girls because neither can transition. And you responded that it's kind of this sex classification or the expectations that one will conform to one's, biological or gender assigned at birth. Why isn't that more of an Arlington Heights argument about intentional discrimination than if what you're really saying or what the legislature is really saying is the burden of this is going to be equally applicable. Neither boys nor girls can have access to these drugs. But the reason why is because we want girls to be girls and boys to be boys, at least until they're old enough to decide otherwise.
So I think it would be wrong to overlook the fact that even separate and apart from any interest in conformity here or sex stereotyping, this is a law on its face that does not subject boys and girls to equal treatment. And you can see that if you look at how the law applies to some of the individual plaintiffs. Take Ryan Rowe, who is one of the individual plaintiffs here. He wants to take testosterone in order to live and identify as a boy, and he's prohibited by.
Yeah, Fluff, man, I've had some shit going on. The latest, which I talked about on the stream the other night, was having some issues with carpal tunnel and losing a lot of the movement in my right hand, a lot of feeling in my right hand. It's just been shit going on. It is what it is. Hopefully we'll get some shit done here shortly. But trying to get back into it, man. It's hard to get into streams sometimes. As much as I love hanging out with you guys, it's hard to get motivated to do anything when you got other things that are not going cool. I'll put it that way. But yeah, and dude, you're right. The worst lie of it all is, all this stuff can be reversed. It can't.
SB1 from doing so because his birth sex was female. But if you change Ryan's birth sex and suppose he was assigned male at birth, then SB1's restriction lifts. So he is not being treated the same as a boy, as a boy who was assigned male at birth. And I think that is the kind of quintessential test the court has applied for purposes of identifying when there's a sex classification.
So what would your argument be if a new drug is developed within, say, 2 or 3 years that just the only purpose of the drug, there's no precocious puberty purpose or anything like that. The only reason to give this drug is it targets minors who have gender dysphoria particularly. And a state passes a law, the FDA approves it, so it's available in some states, but a state passes a law saying no one has access to it. So now you don't have that whole thing falls out.
So that would not be a facial sex classification. And there, I do think that you would have to apply an Arlington Heights type of analysis to see whether the context and history demonstrate that actually the state was intending to treat people differently based on their sex. But I think that would function very differently from
Why don't you have an
SB1.
Arlington Heights argument here too? Because I take it one thing you think would be wrong with that law is the stereotyping function.
Well, I think that Arlington Heights doesn't seem like the natural doctrinal home for a law like SB1 that says on its face you can't act inconsistent with sex. And I take your point about that's applying some equal rules to boys and girls, but that's true anytime you have a law that says you can't act inconsistent with a characteristic. That means that there's going to be a restriction on males and a restriction on females. It's true of any other factor too, inconsistent with race, inconsistent with religion. You might say, well, that's not just singling out one religion or one race or one sex for disparate treatment.
Dude, I bet it is, Colt. I don't know. I don't think there's any way I could do it. Not living just on Social Security. That shit's fucking rough. I am doing my best to be the world's most retarded cripple, though. Let me tell you. Between my right leg and the shit going on my back and all the fucking pain and the shit going on my right hand and losing movement in it and feeling. Yeah, I'm doing my best to work my way into it. I'll work my way towards the handicap tag here shortly, I guess.
But I think it actually increases the number of classifications when you're applying parallel restrictive rules on the basis of a protected characteristic across the board.
So let me return to Justice Kagan's questions. She asked you whether really the more natural way to think about this is that it is discriminating on the basis.
Shit, California Forward, what's going on, sis? I just saw the guys talking about you, saw you pop in.
Of transgender status rather than, I feel like trying to make the Bostock-like argument, holding all things equal, or that you have to do this by reference to, biological sex, feels like an odd way to solve the problem. And kind of that hypothetical I gave you about the drug that just has the transitioning purpose. So if we just head on confront the question.
Shit, fuse, pin, and cage from C1 to T5. Good God, Fluffy. The bad part is I ain't too far from needing that shit, really and truly. Yeah. Damn, brother.
And which you raise in the second part of your brief about whether transgender status should be a suspect class. One question I have.
Yeah, well, that's forward. That's about where this is going is, leave the minors alone. Get them mental health treatment. But yeah, they don't need to physically start changing their body until they're old enough to make that decision for their goddamn selves. And parents who are pushing this shit on their kids, that's when the few times I think kids should be stripped away from parents. If you're pushing this shit on your kid, you are not fit to be a fucking parent at all.
Is, at least as far as I can think of, we don't have a history of de jure, or that I know of, we don't have a history of de jure discrimination against transgender people, right? You point out in your brief that in the last 3 years there have been these laws, but before.
Sister Ford, try to take it as easy as you can, chick. I understand. I mentioned it earlier. So January 7th, I'm supposed to have an epidural done, and then January 9th, as long as the insurance company doesn't fuck me around again, I'll have surgery on my wrist and elbow for this carpal tunnel shit. So that'll be fun. And then I still need surgery on my low back for all the shit going on with that. So we'll see. We'll see how this goes.
Before that, we might have had private societal discrimination, but I don't know of, but is there a history that I don't know about where we have de jure discrimination? And my concern about it is this: all of the other suspect classes that we've recognized so far do have that long de jure history of discrimination. And, the Equal Protection Clause applies to state action. So it feels like an odd fit to say that in their private lives, people have discriminated against transgender people. Therefore, we're going to treat it as a suspect class for purposes of the Equal Protection Clause.
So I think you may be right that the discrimination, historical discrimination against transgender people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here and it hasn't just been confined to private actors. I think that if you actually looked at the facts, there's a wealth of evidence to suggest that transgender people throughout history have been subjected to violence and discrimination and maybe lost employment opportunities or housing opportunities, even in contexts where there might be state public employment at play. And of course, that's especially reflected now in the law where there has been this, I think, attention and focus on trying to limit transgender people from being able to live and identify consistent with their gender identity in our society. So I don't even understand the state to be disputing the historical discrimination point. But if you're approaching this from the standpoint of saying, is this a group with a distinguishing characteristic that has no bearing on their ability to contribute and that needs some protection from the courts? I think if any group qualifies, this one does in light of the current laws and what might come in the future. And our basic argument is if you can look ahead and say, maybe the states will ban medical care.
Bob, I don't think you're wrong with that. Considering, the left wants people to vote as young as 14 these days. Yeah, either lower the age of adulthood or shut up. These kids said they can't even get a tattoo. There was a dude spent 2 years ago whose kid, 13, got a tattoo, showed up to school. School found out about it. School raised hell. I mean, this parent got held fucking accountable. I think they might have, I can't remember. I don't think they took the kid, but I think they wanted to put the dad in jail over it because this kid got a tattoo. But that's a tattoo. It doesn't affect their body anywhere other than aesthetically. And if that kid can't do that, but you want these kids to get seriously life-changing, physically altering substances, you're not being honest about this argument whatsoever.
Care for adults who are transgender. Maybe they'll ban adoption by transgender people or not allow them to be teachers. That doesn't look anything like the workaday economic regulation that just gets rational basis review. And I think the court could give effect to that intuition.
Yeah, and I don't want to be misunderstood to say that I don't think there's a problem or that there hasn't been private discrimination. I guess it doesn't seem analogous to me to say race or gender or national origin, those kinds of things, because we did have de jure discrimination to point to. And so I guess what I'm thinking is when we are in the business of identifying suspect classes, in Cleburne, we expressed, and I'm not saying that this is analogous to Cleburne in that respect, but we expressed in Cleburne hesitancy, to identify groups such as the elderly, or the mentally disabled as suspect classes, in part because those are judgments that are pretty hard for courts to make. And at least de jure discrimination of the sort experienced by women, or people on the basis of race gives us something to point to if we're going to be identifying a new suspect class, which we haven't done for a long time.
Yeah, and I, of course, take that point, and I should reiterate, we don't think the court has to confront it here. But in the cases involving age and disability, I understand the court to have approached those issues with somewhat different reasoning, that age is something we all experience, that disability is a broad and diverse group, and that individuals with disabilities have been able to harness the majoritarian political forces to protect their rights. And none of that is true here. Transgender individuals are a discrete minority. I think there's no dispute that they are being subject to a wave of legislation across the states today. And I think that this is the kind of circumstance where the court could rightly recognize.
That's because so-called transgenders are an extremely small portion of society. They are also an extremely small portion of them who actually present as one sex versus the sex that their brain is developing as. That's a you're talking about like 0.00001% of the population. But you want to take healthy kids presenting as healthy genders who just have doubts about things and give them irreversible medical procedures. I'm sorry, that should be a hard fucking no. And I'll stress this again. This is the United States government arguing in favor of this shit.
That heightened scrutiny should apply.
Last question. Do you agree with me that the resolution of this case has no impact on the parental rights claim that the Sixth Circuit also addressed?
That's right. I think we are not making a substantive due process parental rights claim here, and this court obviously didn't grant review of that issue. I will say that I think parental rights are actually relevant to the Equal Protection Clause as well, insofar as it's significant to me that Tennessee, in choosing to categorically ban this care, is taking a sharp turn away from how it ordinarily handles parental rights in the medical decision-making space. And Justice Kavanaugh said, who decides here? But when it comes to medical risks and benefits, the state's general approach is to
Okay, so and part of that issue is Tennessee thinks that parents shouldn't be able to make the decision to give their child life-altering drugs because somehow their parents are delusional enough to think that their little boy is a little girl or that their little girl is a little boy. I will submit to the class that if you have a little boy as a parent, mom or dad, and you want to change the sex of the child after the child's born, that child should be removed from your fucking custody and you should no longer allowed to fucking breed. Sorry. Well, no, I'm not. Because you're insane. Boys are boys, girls are girls. It's the way it's always been. It's the way it's always gonna fucking be.
say parents get to decide along with their doctors and their children. And so I think from the standpoint of under-inclusivity, it's pretty significant that Tennessee now is completely overriding parents' wishes when they are best positioned to know their individual child and to have a good sense of whether the risks of this treatment are outweighed by the benefits.
But this isn't, I guess my point is, even if we decided that this wasn't a sex-based classification that triggered intermediate scrutiny, that would not prevent parents from still asserting the substantive due process right.
Yes, of course, I agree with that. I do think that the sex-based classification under Equal Protection Clause is the most straightforward way to think about what's going on here, though. Yeah, thanks.
Justice Jackson?
So I'm glad that you've clarified that how we characterize this law is really the issue on the table today, not the risks or benefits.
Okay, I know I said Sotomayor is the dumbest bitch on the Supreme Court. Ketanji Brown is fighting so hard for that title. She is swinging at everything, and you're fixing to hear it from her mouth right now. So just hang on, because the arguments get even fucking worse.
Policies that justify it, but how we characterize it. And I guess I think there might be some confusion a little bit. At least I'm confused because there's so many lines that this statute could draw. The classification, as far as I can tell, is a line drawing, is the statute drawing lines, and there are lots of different ones. And Tennessee says this is drawing a line between people on the basis of age and purpose, and I totally see that. You say this is drawing a line on the basis of sex. I see that as well. But I guess my sort of initial question is, are those mutually exclusive? Do we have to choose between those characterizations? Isn't there a world in which this statute is doing both of those things? And the question for equal protection purposes is, if you're right that there is a sex-based line being drawn, then to the extent the plaintiffs are implicated by that line, don't we have to apply heightened scrutiny in evaluating their claims?
Yes, that's exactly right. And I think, of course, you could say this is a statute that classifies based on age and purpose and sex. Critically, we think that purpose incorporates sex here because the purpose is expressly defined in terms of treatments that are inconsistent with sex.
Right.
So I think the problem with the state's approach is to say, well, it's just purpose going on. You take one look at that, and that just dissolves down into drawing a sex-based line itself.
Can we put more flesh on that though? Because I mean, even
I
if we
don't know,
separate
Bob.
out
It's
their
close.
age and purpose, and we
Think
just say, okay, so
Sotomayor is
how
still
is this
dumber.
actually drawing a line on the basis of sex? I think I heard you say it a couple times with respect to some examples, but I think it would be helpful to get on the table exactly who's falling on what side of the line in a particular situation related to sex.
Yes. So the way that the sex-based classification is working here is that from the standpoint of any individual who wants to take these medications, their sex determines whether SB1 applies. John Doe, one of the plaintiffs, wants to take puberty blockers to undergo a typical male puberty. But SB1 says that because John's sex at birth was female, he can't have access to those medications. And if you change his sex.
Well, here's a clue. If so-called John Doe was born a girl, they are not going to get a typical male puberty. They're not. You fucking retard. That's not the way human biology has ever worked. If you give them testosterone to make them go through puberty more as a male, that is still not a typical male puberty. I promise you, unless you guys do some serious shit to her, she's not going to have to walk down the hallway with books in front of her because she got a hard on for no fucking reason. And as guys, that's what happens to us. I just fucking seriously. It just, no matter how many drugs you give her, she is not going to go through a typical male puberty because she's fucking female. Just fucking what? Is she suddenly going to notice she's got fucking balls? No. Is she going to get hard-ons for no reason? No. Is she going to come in her fucking underwear when she goes to sleep, wakes up, and has a fucking wet dream? No. Then guess what? Gee, oh, good God. I wish women could experience a typical male fucking puberty. I wish y'all could. It would explain a lot of stupid shit that guys do. But no, y'all go through different shit. A guy has never sat in class at 13 years old and then started bleeding out of his dick for no reason and went, oh shit. It's just fuck. When did we forget? When did we forget that boys and girls are different? When? I love my wife because she is way different than me. And in a lot of cases. In some cases, she's very similar in ideology and a lot of other things. But I love my wife because she's different than me. She doesn't have a dick for one reason. That's always helpful. But just...
then the restriction under SB1 lifts and it changes the result. And my friends say, well, that also simultaneously changes the medical purpose of using these medications. We don't dispute that point, that it might also inherently change purpose when you're changing sex.
But it doesn't have to, right? I thought of an example in which we have a plaintiff, a person a minor, who would like to take this medication to affirm their gender as a male because the medication deepens their voice, for example. They want a deeper voice and they're biologically male. They're taking the medication because that's what they want. They, I think, can get that medication.
That's right. And
But
so
a person who is biologically female who wants to take the medication for that same purpose, to deepen their voice because they would like to live as a male, can't get it.
Yes, she is equating this all to someone having a deeper voice, never mind the physical effects on the female body versus the effects on the male body. No, it's all about voice. So yeah, the boy wants a deeper voice. Give him testosterone. How many of us had a squeaky ass fucking voice at like 13 when we were going through puberty, and that voice hadn't really changed all the way yet? I kind of remember those days. At 14, I was told my voice carried through a class, so I didn't really need to, shoot the shit with the dude next to me because my voice carried. But at like 13, 12, yeah, that shit was fucking squeaky. It's just fucking. So wait a second. Fuck me, man.
Is that right?
correct.
Never
And
mind.
that is
I
on the
can't
basis
even
of
go
their
there.
sex.
So the purpose is held constant with that example. It's not changing. What is changing is just the biological sex of the individual.
I think that that's correct. But even in a circumstance where you might characterize that as treating delayed puberty instead of gender dysphoria, if you said, well, there is a different purpose there, even though the effects are exactly the same and they want the medications for exactly the same reason, that doesn't eliminate the sex-based classification because sex only has to be one but-for cause of disparate treatment. And I think the state will say it's perfectly reasonable to treat different medical purposes or uses differently. We don't disagree, but that's something that's channeled to the application of heightened scrutiny. And if the state has a really good reason to say there's a danger in using these drugs if your birth sex was female and you want to deepen your voice,
Right. That's Justice Alito's studies and all of this.
Exactly.
That
That
can
all
come in at
goes
that
to the
point.
application of heightened scrutiny, and maybe the state can prove it up and show they have an important state interest, and they really have a reason to distinguish between who can have these drugs for which purposes based on their sex. But that doesn't eliminate the facial sex classification or provide a reason for this court to turn its back on 50 years of precedent saying, if you classify based on sex, you have to justify that.
And it's interesting to me that you mentioned precedent, because some of these questions about sort of who decides and the concerns and legislative prerogatives, et cetera, sound very familiar to me. They sound in the same kinds of arguments that were made back in the day, 50s, 60s, with respect to racial classifications and inconsistencies. I'm thinking in particular about Loving, and I'm wondering.
Yes, Ketanji Brown, go figure, just turned the case of whether or not to give minors sex-altering hormones and treatments to race and laws in the South that would not let black people marry white people or white people marry black people. That's where she went with this. That is the level of Supreme Court judge that we have these days. I still think Sotomayor is dumber, but Ketanji Brown is fighting so hard for that title right now. It's just not even fucking funny. I mean, she looks like Rocky and they're punching a goddamn speed bag right now. Stupid, stupid, stupid right hand, stupid, stupid, stupid left hand. I mean, just.
Whether you've thought about the parallels, because I see one, as to how this statute operates and how the anti-miscegenation statutes in Virginia operated.
Yes, and
Ford, it creeps anybody out who is not a pedo how these people talk about this shit.
And I think the court has recognized that the Equal Protection Clause was intended to force some changes in society and get us to think more closely about the way that people were being classified, including when that was based on overbroad generalizations of how we expect them to live and order their affairs. And the court has made that clear in the sex discrimination cases as well, where it said, sometimes these laws operate to disadvantage someone who falls outside the average description, and that person needs the protection of the court.
Well, and the thing I thought what was most interesting about the potential comparison to Loving is that in that case, everyone seemed to concede up front that a racial classification was being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at
Yeah, dude, Blade, that is so fucking insane. It's just not even goddamn funny. And there are cases where, and I have to look the cases up, where a guy married to a woman, his wife, I think, wanted their little boy to be a little girl. Or maybe it was two little boys. I think it was two. And she basically started to transition them, quotes, air quotes, and ended up moving to California, and he lost custody of his boys. Because the courts in California and her transitioning the kids. It's so insane. I just really need to shut my mouth, but it's absolutely insane.
at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic. And in all other contexts, the court has recognized that as a facial classification based on that characteristic. And Tennessee even concedes the point when it comes to dress codes and to seeking a profession inconsistent with sex. But I think one other way to look at this, Justice Jackson, is that to me, it would be a remarkable proposition for this court to say that a statute that on its face says you can't have medication inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground.
Thank you.
Thank you, counsel.
So now it's time for opposing counsel for the state of Tennessee to get up.
Mr. Strangio?
Mr. Chief Justice, and may it please the court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex.
Oh, no.
An adolescent can receive medical treatment to live and identify as a boy if his birth sex is...
No. This is still for the pro giving sex hormones to your kids side. Sorry. The lawyer for the state of Tennessee doesn't get up there till after this person. Yeah, if you listen to their voice, you can tell that they're not male.
Male, but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female, but not male.
I don't know, Matt.
Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too. By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
If you are successful, what would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB1 as applied to our individual plaintiffs.
So in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex?
In practical terms, what it would mean is that an individual like John Doe, who was receiving medical treatment to undergo a typical male puberty prior to SB1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of review, that it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think as the Solicitor General made clear in her remarks that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the Sixth Circuit to apply that standard in the first instance.
Is there anything you would like to add? And maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus Bourne, unlike a case like Morales, and those where it was quite clearly simply stereotyping with respect, can men have the same rights as women with respect to adoption and the liquor laws. This does strike me, whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases?
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether a classification is benign. And many justifications for sex-based differential treatment in law were defended on the ground of biological differences and were upheld by the court under rational basis. And the role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counsel, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means ends calculation in this kind of medical context? Because I agree with you. I mean, I can see your point, like, well, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, undeniably in areas of public health and evolving science. And the court repeatedly made clear that, yes, of course, the states have latitude through their police power to regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some. Can I just last follow up? But even in those COVID-19 cases, courts weren't, and we certainly weren't, diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear.
Yeah, Blade, dude, you are 100% on point. I mean, 100% on point.
From some of my
click the right
colleagues
button here.
that they were worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns on
this thing wants to talk about suspect classifications. Are you fucking kidding me? Because you yourself are an absolute suspect classification.
underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie and exactly what the difference is between that 1% of children who receive these treatments expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we address this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, Counsel.
Could we explore what intermediate scrutiny might look like in operation in assessing laws like Tennessee's. So the Solicitor General on page 48 of her brief lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in response, Justice Alito. In the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law. And if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as a Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare. And we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point, if I could, to the history of discrimination. And there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
Yeah, we all lost track of that one.
Somebody was trying to make it.
Yes, I think it was me. And the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence. And I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It's not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. If this is similar to that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, or not the Tennessee court, this court is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications. It's more questions of constitutional allegation of authority. And, we might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor. Particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Well,
anyway, just what you think.
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here, what they've done is impose a blunderbuss ban, overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas?
The point I was getting at with respect to remedies is normally in equal protection cases, there's a difference between one group and another. In Bourne, it would be that the women could buy alcohol, but the male students could not. And what would that be in this case?
So 2 points points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys. And what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
Okay, let's change. What if, would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to make, discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose. And what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth sex and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of, does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that category that distinguishes on that ground is not a suspect classification? And I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
it's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is a law that I think is easiest to understand and in the most straightforward classification on the basis of sex.
So, Mayor?
So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct, Chair.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights perhaps question, but the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB 1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kagan?
Two basic questions. So whether we apply rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it, it's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me, but it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed. And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay, so if I could just make a few points in
Okay,
reaction.
I had one more point,
Okay.
sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, oh, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have this same discussion as I see it. So just to get you thinking about that too. Go ahead. How about it?
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that with respect to the difference between rational basis and heightened scrutiny, yes, of course, it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny. And we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient?
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to their risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trengale, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life. And there's a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Justice Jackson?
So I guess I'm suddenly quite worried about the role of the court questions and the constitutional of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening? What is the justification? And you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that. And the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine, is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel, because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Sure you don't.
Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policymaking. As Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, Counselor. Every medical treatment has a risk, even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other? One person of one sex from another sex from receiving that benefit. So if the medical condition is unwanted hair by a 9-year-old boy who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and his puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age can get that drug, but the other can't. That's the sex-based difference. It's not the getting it and the other's not?
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it to a minor who wants to transition. Those are not the same medical treatment. And once
What
you
you're saying
recognize,
is you're still depending on sex
Yeah.
to identify who can get it and who can't.
I don't think so, Your Honor. If a minor comes up to a boy, goes to the doctor and says, "I want puberty blockers to transition," the answer will be no. If a girl goes up to the doctor and says, "I want,"
if a sex-neutral looking child walks into a doctor and says, "I don't want to grow breasts," doesn't the doctor have to know whether it's a girl or a boy before they prescribe the drug?
I don't think
I
so,
know,
Your Honor. It
I've
needs
got to
to
tell
know.
you, I've made that mistake on children often. Look at one of them and think it's a boy, and I'm corrected and it's a girl, and vice versa. I hope that you're not going to tell me you haven't made that mistake.
Well, I may have made that mistake, Your Honor, but I don't think that that is an example of where a sex-based line is being drawn.
Why not?
Because
Yeah, please.
Because
Why not?
all that matters is the medical purpose for which the drug is used. So if the minor comes up, if you have a biological
No, it's the
boy-
same medical purpose. Her hypothetical is, I don't want to grow breasts. Same medical purpose. I'm trying to stop the development of breasts.
Well, Your Honor, I think that that likely would not be allowed under SB1 for a girl.
For a woman who is, for a
I'm sorry.
girl, but
Yeah,
it
and it would
would.
also not be allowed under Tennessee law with respect to a biological boy.
Really?
Tennessee law doesn't just allow doctors to prescribe drugs without a medical purpose. They can't.
No,
prescribe
but the way I understood
testosterone
the law to work is it has to be inconsistent with your sex in order for it to be blocked. So I don't understand why a boy, I don't understand why it would work in the way that you're saying. Why wouldn't it be differentiating on the basis of gender? A girl who doesn't want to grow breasts for whatever reason could or could not get it.
does not want to grow breasts
Yes.
without a medical reason could not get it.
And a boy who doesn't want to grow breasts could or could not get it.
Could not get it if there was no medical purpose. There has to be a medical purpose for these drugs. All my friend's arguments rest on conflating different medical purposes.
But they couldn't get it not under this law, right? Because this law is operating around the inconsistency. So if they couldn't get it, it would be for some other reason, right?
But we have other laws in Tennessee law that prevent malpractice and that prevent the use of drugs for a non-medical
I understand, but this law is the one that is being challenged today, and we're trying to decide whether or not it's operating on a sex-based basis. And
Well, I don't think
we have so what about my lower voice hypothetical?
Yeah.
All right. So a biological boy comes in and asks for a hormone treatment to deepen his voice in order to affirm his masculinity because it hasn't come and he'd like to deepen his voice. Can he get it?
If there's no medical purpose, no.
No, that's the medical purpose. I don't understand what you mean. The purpose is to bring on a deepening of their voice.
Let me try to rephrase.
Yes.
If there's no medical condition, the answer is no. You cannot use testosterone for purely cosmetic reasons. It's a Schedule III drug. You
In
are
this
not allowed.
statute or in another statute?
In another statute.
Okay, so setting aside that other statute, we're looking at this one and how it operates. This statute says something about inconsistency with your biological sex, and that's what I'm trying to test. The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? Under this statute?
Under this statute, no, but under Tennessee Code annotated
The boy could not, under this statute, to get a medication that would deepen his voice?
If there was no medical condition, no.
That's the other statute. Under this statute, with respect
Under
to
this statute.
consistency, he could.
Under this statute, he could. Under
Okay.
63-6-214-12, he could not.
I understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone to deepen her voice in order to affirm the identity that she chooses, which is masculinity. I'm asking you, would under this statute, she be precluded from getting that treatment?
I'm sorry.
She wants to, I'm sorry, one more time, Your Honor.
She wants to get
conversation
the
in
medication
between.
in order to deepen her voice and affirm her masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be
making
barred
her
from doing
voice
that.
deeper.
Under
But isn't that the point,
you
Mr.
shouldn't get
Rice, that if it's
hormones,
for the purpose of
moron.
identifying with their sex? I mean, the prohibited purpose here is treating gender dysphoria, which is to say that the prohibited purpose is something about whether or not one is identifying with one's own sex or another sex. The whole thing is imbued with sex. I mean, it's based on sex. You might have reasons for thinking that it's an appropriate regulation, and those reasons should be tested and respect given to them. But it's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
Both sexes are blocked.
Justice Kagan, we think that is a slightly, we think that's a request for a substantive right to engage in non-conforming behavior. We don't think it's actually drawing a line based on sex. And again, the only way that my friends can point to a sex-based line is to conflate the use of puberty blockers to address precocious puberty with the use of puberty blockers to transition. And those are fundamentally different treatments. They have different effects on the body. They're used for different purposes. I actually think my friend's response to Justice Alito's hypothetical regarding puberty blockers is devastating, because that law draws no different lines than the law that's drawn in SB 1. It just doesn't use the words inconsistent with sex. So we use the words inconsistent with sex to describe a single prohibited medical purpose. We do not use it to draw lines between males and females.
Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult the science may be, and no matter how evolving it may be, at the end of the day, legislation on this subject is subject to judicial review.
Yes,
Is that
sure.
correct? And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of the scrutiny that's applied?
Yes, Your Honor.
Okay, thank you.
Counselor, given your argument, you're saying your state can block gender treatment for adults too.
Your Honor, we think that if we're assuming a similarly worded statute, that there still would not be a sex or a transgender-based classification.
So you're licensing states to deprive grown adults of the choice of which sex to adopt.
Your Honor, I don't think that's a fair characterization.
That's what you're telling me, because you're saying to me rational basis would be the review for that kind of law for adults as well.
And this court has not hesitated to hold laws unconstitutional under rational basis review when they are rooted in unsubstantiated fears and prejudices. That's exactly what this court did in Cleburne. And
That's
to the
quite
extent,
an interesting way to protect the population.
and to the extent, Your
I
Honor,
thought that that's why we had intermediate scrutiny when there are differences based on sex. We're not acting on the basis of prejudice.
well, Your Honor, of course, our position is that there is no sex-based classification, but to finish the answer, that to the extent that a law dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
So in
when you're 1% of the population,
sorry,
when you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
You blacks were a much larger part of the population, and it didn't protect them.
So here's another idiot equating racist laws with laws that will not let a minor get life-changing drugs, life-altering, and not for the good, altering drugs pumped into their body to keep them from going through a normal puberty. That has jack shit to do with laws that this bitch supports, gun control laws, that would keep black people from being armed or anything like that. This is Again, getting to the sheer insanity of this fucking argument.
It didn't protect women for whole centuries.
Mr. Rice, I have one factual question, then one legal question. The factual question is, mentioned that this is an off-label use, that the FDA is not authorized.
Hold on. Patriot, you can completely believe I'm listening to this because you know me and you've known me for a long time now. You completely believe I'm listening to this shit. I'm going to get out of here after this is over with, but yeah, you completely believe I'm listening to this shit. You just can't believe I put everybody else through this more than likely.
Or is it for adults too?
It's still true. I think with respect to both children and adults, I know with respect to children, I'm not certain with respect to adults, but we do think that that's relevant in the sense that the FDA, when it approves drugs, it does so based off of the purpose for which the drugs are being used. And we think that we are drawing the same type of distinction in our law between using one drug for different purposes.
Okay, my legal question is, I wondered if you had a response. You know, I was asking your friends on the other side about de jure discrimination and what we should take account of if we're thinking about whether transgender people should be a suspect class for purposes of the 14th Amendment. Do you have a response to that? What we should be thinking about, or whether do you know the history of de jure discrimination?
I do not know the history of de jure discrimination. I mean, our frontline position is that the court has gotten out of the business of creating new quasi-suspect classes, precisely because it's a very unprincipled test when it comes to creating these classes. And in some of the cases, political powerlessness means that you need protection from the majoritarian process. In other cases, it means can you gain the attention of lawmakers in the most recent Cleburne test? So the court has not applied any form of principled analysis when it comes to creating these tests. It's been an exercise of judicial power, and the intermediate scrutiny analysis that accompanies the quasi-suspect classification is no more principled, and the court has often struggled to apply that as well. So we don't think the court should even open the door for further judicial creation of new quasi-suspect classes.
Okay, and last legal question. I was just going to ask you one. I have a second one. Could you address Justice Kavanaugh's questions about what the implications of this case would be for the athletic context or the bathrooms context?
I would love to, Your Honor. So we think this is, we differ with our friends on the other side with respect to their argument is that, well, there's a sex-based classification in sex-separated sports. So necessarily that means that there's a sex classification, intermediate scrutiny applies. We are not actually seeing challenges to the sex classification. When these challenges are being brought, they're not arguing that we don't want there to be boys and girls sports. They're arguing we want there to be boys and girls sports. We just want to be classified based off of our gender identity. And so we think that is a fundamentally a transgender-based challenge and not a sex-based challenge if you are not actually challenging the sex classification that is at issue.
Can I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been making a racial classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Your Honor, we think that in a case like Loving, when you look at the individual level.
Okay, so let's throw this down because apparently Kananji is too stupid to understand it. One, we're talking about minor children in this case who, one, couldn't get married if they wanted to. And two, it's not a discrimination on sex, gender, or anything else because it applies to every minor child. So it doesn't pick out, oh, white minor children can get this and black minor children can't. It doesn't pick out, oh, left-handed minor children get this and white right minor children can't get this. No, it is all minor children can't get life-altering drugs and physiologically altering drugs, for that matter. They can't get those. It's it makes my fucking head hurt. This is the federal government, your government that your tax dollars pay for, arguing in favor of minor children getting life-altering hormone treatments, and your Supreme Court that you pay for supporting, well, at least some of them, the leftists on the Supreme Court supporting these children getting these treatments. The insanity doesn't stop. It fucking can't stop, won't stop, whatever that song was. Yeah, it keeps going.
Which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level. That if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race. You couldn't if you couldn't. And I take your law to be doing basically the same thing. You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So
no, you can get these blockers if it is consistent with a medical treatment that is necessary. In other words, if you go through puberty, it's going to make your cancer worse. We can block your puberty so that it doesn't make your cancer worse. Male or female, doesn't matter. You can get these to block that. You, however, can't get these things just to change your gender, your perceived sex. She's like fucking Rocky. She's fucking throwing left hand. She's switching fucking right paw, south paw, all that to become the dumbest motherfucker on the court. She is fighting hard. I mean, she is punching Sotomayor in the goddamn face. Just, right. No, she's switching left. Yeah, she's fucking just that way.
how are they different?
We think it's different because we think in their use of inconsistent with sex and all of these examples that they have in the briefing, those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological stress associated with her body.
Thank you.
This is not only
What's your
different.
basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical?
No, it's a fucking medical physiology, you dumbass. If a boy is medically deficient in testosterone, you give him testosterone, you kind of put him back on the line where he needs to be. If a girl wants testosterone, you throw her all out of fucking whack. Oh, this bitch. She would not be on the Supreme Court if not for the votes of Republicans, guys. Lindsey Graham and others actually voted for this fucking ignorant bitch.
I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency,
I take it. I thought it operates on the body the same way. That would make you absolutely ignorant of biology, and you shouldn't be on this case if you can't understand basic biology. Plain and simple. How were you a so-called justice if you on a case about biology and hormones if you can't understand very basic biology? In firearms cases are no different, but I told you guys earlier, this is going to be more insane than any firearms argument that you've heard so far. And yeah, this case doesn't disappoint.
see testosterone because he has constitutional delayed puberty. That allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds.
Oh, I'm sorry. I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning, the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and recognize medical reality, then there is
you're right, Bob.
no argument that our law differentiates between treatments for males and females.
Can I ask you about one of the purposes of this law? And I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization
Well,
of our
encourage
law.
minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls.
If I could,
and that's an important purpose behind the law. And I understand that sentiment.
I'm sorry. How is wanting boys to be boys? I'm sorry, I'm fucking getting retarded. How is wanting boys to be boys and girls to be girls this bad thing? Kagan, you absolute fucking moron. How is that a bad thing? These people want, I can't say it enough, prepubescent children to be given hormones that will stop them from going through puberty. How is this not child? In any logical fucking circumstance, this would be child abuse. But you have the federal government arguing for this, and you have Supreme Court justices fighting tooth and nail to uphold it.
But it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
You ain't wrong.
If I could make a few points. First of all, it sounds like the question is rooted in a potential improper purpose-based argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely. And I would love to address.
And what seems to have produced this classification is that we want to ban treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So the appreciate their sex reference in detailed and legislative findings, that is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that that has to be viewed in the context of the legislative findings, with which both emphasize the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research and that assessment of whether the findings of that study, but the legislature specifically noted those studies. So I think that statement was rooted in the notion that actually this is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.
Go ahead.
You go.
No, go ahead. No, go ahead. I'll be back.
Justice Kavanaugh.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state, particularly in a situation, as General Prelager said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports.
Yes, Your Honor. So as my friends recognize, the parental rights question is not before this court. And
she explained how it informs. So just take the question as best you can.
Yeah, I think our position is that there are certain times in medicine, history has shown where the states in their traditional role as regulators have had to intervene. And that's not because, of course, the parents are trying to do the best they can and get the best treatment for their kids. But we've had multiple instances in somewhat recent history where we have stuff like lobotomy, eugenics, that had widespread acceptance among the medical community, and the state had to intervene as a regulator to protect its children.
Mr. Rice, just to let you kind of finish what you started to say to Justice Kavanaugh, you agree that the parental rights question is not before the court. So it would be open to parents to continue to press that point in other cases.
We agree, and we think Chief Judge Sutton got it right, but we agree.
Can I just ask you about, I don't understand at all the similarly situated argument that you make, and I hope that you can help me, because I don't know how you can say both that girls and boys are not similarly situated at step one when this law is being evaluated and it's not making a sex-based classification. It seems to me that recognizing.
You don't understand at the very basic level, apparently, that boys and girls are different. How Taji Brown's got to be in her 30s. Someone sent her a copy of Kindergarten Cop, where the little boy stands up in class and tells him that, hey, boys have penises and girls have vaginas. Someone sent her that clip. At least that clip, if not the whole movie. She'll get a kick out of the whole movie. But god damn, how stupid do you have to be? Fuck me. Why do I even have to ask? To support this absolute troglodyte of a woman.
Their lack of similarity, as you do in making the argument, is making a sex-based classification. So
I think our position is that if you're in the point where we're treating giving testosterone to a boy with a biological deficiency as the same thing as giving testosterone to a healthy biological girl who wants to transition, then there has to be some threshold inquiry that recognizes the biological differences between those two.
Right, but when you're doing that, you're making a sex-based classification. I mean, the very argument carries with it the characterization that we're trying to identify here.
Yes, you absolute fucking moron, because boys and girls are different. Boys rely more on testosterone, girls rely more on estrogen. It's basic human biology. I understand you're a lawyer, and you're more than likely dumb as fuck. But Jesus Christ, use Google every once in a while, because even Google, as leftist as it is, would tell you that.
You start by saying it's different to treat a boy who's using this medication for a particular reason from a girl who's, okay, so that's a sex-based classification. Haven't we dealt with step one now? We should be going on to step two. No. Intermediate scrutiny applies by the terms of what you're arguing.
I don't think that we agree that we've checked the box at step one, because there is no medical treatment that boys can receive that girls cannot. So we disagree with the notion.
Didn't we already dispose of that kind of reasoning with our equal protection cases that looked at things like interracial marriage, where we said, even though it applies to both, it's still making a racial classification? Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged. We said that's not an argument for why you shouldn't have a heightened scrutiny, or why the statute is not making a race-based classification.
And that's not the argument that we're making.
Okay, so what is
we are not arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and you go in to get puberty blockers, you can get the puberty blockers if you're going to use them for precocious puberty. You cannot get the puberty blockers if you're going to use them to transition. That is not a sex-based line. That is a purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here. And the only way they get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.
And the treatments are different because of the biological sex of the person, right? I mean, that's what you said. The purposes are different because of the biological sex and why you're going in to get them.
Not at all. I mean, with puberty blockers, the purpose, nothing turns on sex. Take puberty blockers. There's nothing that turns on sex as to whether there's a sex-based classification there. Everything depends on what is the reason that you are using those puberty blockers for. Happy to take more questions if the court has them.
Justice Thomas?
A number of times you've mentioned off-label uses of these hormones. What are some of the other off-label uses that are not legal in Tennessee?
So, for example, Your Honor, testosterone, we have a separate law that prohibits the use of testosterone for hormonal manipulation intended to increase muscle mass, strength, or weight without medical necessity. We have, like every state, we regulate medicine and we regulate the use of drugs. You cannot use drugs in the state of Tennessee if it's not for a legitimate, viable medical purpose. Here, through this law, all that we have done is make clear that these treatments, which are irreversible often, have significant effects on minors and often leaves them with damaged that you have to wait until you turn 18 to receive those type of treatments?
A number of times you've tried to say that what the classification that the state of Tennessee has advanced in this legislation. Would you spend a few minutes on that?
Yes, Your Honor. So again, we think that our law fundamentally draws a distinction based on medical purpose. I'll go back to puberty blockers. If a boy wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. If a girl wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. That is fundamentally a different treatment, and what is dictating under this law is the use for which you are putting the drug. And just to kind of build out on the notion that these are not the same treatments, we talked about earlier testosterone. If you give it to a biological boy, it allows the boy to develop a normal body and healthy body, whereas providing it to a girl causes a physical condition, hyperandrogenism, and that results in cleromegaly, atrophy of the lining of the uterus, blood cell disorders, increased risk of heart attack. So the notion that the risks are the same when you give testosterone to a boy as when you give it to a girl are simply not borne out by medical reality.
Justice Alito? Justice Sotomayor? Justice Cave? Justice Kavanaugh?
Just one clarification. It's an obvious point, but I want to make sure you agree with it, which is you're not arguing that the Constitution takes sides on this question. You, as I understand it, you are arguing that each state can make its own choice on this question. So from your perspective, as I understand it, it's perfectly fine for a state to make a different choice, as many states have, than Tennessee did, and to allow these treatments, correct?
Yes, Your Honor, that's correct. And we think that's because of what Your Honor has pointed out, that no matter how you draw these lines, there are risk and potential benefits and harms to people on both sides. And the question of how to balance those harms is not a question for the judiciary, it's a question for the legislature.
Thank you.
Can states make a different choice if doing so means that a state's law operates to treat its citizens differently on the basis of name the suspect classification? I thought that was the work of the Constitution and the Equal Protection Clause.
Your Honor, we don't think that it draws any lines based off any.
No, I understand. I'm not talking about this law. I'm going back to Justice Kavanaugh's suggestion that the Constitution doesn't play a role if the state is making a policy choice regarding issues such as these. And I guess I'm still seeing a role for the Constitution in circumstances in which the claim that is being made is that the state's choices are implicating the equal protection rights of its citizens.
The point is that the Constitution is neutral in the sense that it does not provide heightened protection based on any suspect classification, and thus rational basis review applies in the presumption of legislative validity and the presumption that these types of policy choices are best left to the democratic process. I think that is exactly what the correct way to think about this case.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you, Mr. Chief Justice. Two quick clarifying points. I want to make clear that Tennessee here is not regulating based on off-label use. Off-label use is extremely common in pediatrics, and we've pointed to a number of uses of these medications on page 40 of our brief, the very same medications that likewise are off-label use. If there are problems with safety and effectiveness, then that would not become the standard of care, and there are self-regulatory measures to address that issue. Justice Kavanaugh, you said this might be a space where each state can make its own choice, but I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress. And so I think that the court should keep that in mind when thinking about the level of scrutiny here. There were a lot of questions about how to take account of disputed medical evidence when there might be some uncertainty. And I want to make a few points. As my friend acknowledged, that doesn't go to the level of scrutiny. So that doesn't mean that you should ignore a sex classification when one exists in the statute. But at the point of applying heightened scrutiny, the court can take context into account. And we're not asking courts to step in here and say, we want to figure out as a matter of policy exactly what the right approach is. But you can ask the familiar judicial questions like, does the state actually have any evidence to support its claims that there's a harm to adolescent health? And is this law severely over and under inclusive? And if the court conducts the analysis here in the first instance, this law doesn't look anything like a typical medical regulation to protect adolescent health. That would look like the West Virginia law, where you're tailoring it, but still leaving some possibility for care when it can have enormous benefits. And the reason it doesn't look like a typical medical regulation is because the legislature was doing something different in trying to get minors to appreciate their sex and not become disdainful. That's not a medical-based justification, but I think it shows exactly why the state drew the lines where it did. Finally, I think the court should think about the real-world consequences of laws like SB1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care. And they say this is about protecting adolescent health, but this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health. But the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
The Supreme Court heard oral argument in a case challenging Tennessee's ban on transgender medical treatments for minors and whether it violates the Equal Protection Clause of the 14th Amendment. This is about two and a
Hold on. Let's see. Let me speed this up. We'll see.
Suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that category that distinguishes on that ground is not a suspect classification? I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
it's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here in SB 1, this is a law that I think is easiest to understand and the most straightforward classification on the basis of sex.
Sotomayor?
So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights perhaps question, but the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB 1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it, it's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me. But it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed. And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay, so if I could just make a few points in reaction.
I had one more point,
okay.
sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, oh, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have the same discussion as I see it. So just to get you thinking about that too. Go ahead. How about it?
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that with respect to the difference between rational basis and heightened scrutiny, yes, of course, it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny. And we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient?
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to their risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way. And
I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible, because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trego, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life. And there's a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Justice Jackson?
So I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening? What is the justification? And you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that. And the court really holds them to it in certain heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine, is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then
Night Strike, brother, we are all losing brain cells listening to Ketanji Brown or the Democrats' arguments in general. So yeah, dude, I know where you're coming from. Tuesday, if we do this Tuesday, yeah, I'm just going to be there drooling and eating pudding. I'm going to look like fucking Joe Biden in a press conference.
and state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is
okay. This Joker, if you look at this picture, that is straight out dried cum in that hair. That is not hair gel holding that hair in place. I just want to let the class know.
exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Yeah, sure you need to know.
Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments.
Shit. Bob, you got it 100%. Yes. Something about Mary. Yeah. Dude, does it feel like fucking Groundhog Day? Like we're back right into the same argument with this part of it? Jesus Christ.
Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving
no, Night Strike. If we just straight out go to the end of this, you're not getting these brain cells back. I'm Unfortunately, it just doesn't work that way. You just lose all the brain cells at one time versus over the amount of fucking hours we have listened to it today.
Issue. The Sixth Circuit should be affirmed. I welcome the court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policy making. As Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, counselor. Every medical treatment has a risk, even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop?
This has got to be a replay. Otherwise, it's just fucking Groundhog Day of this. But no, there are not millions of people who get relief from this, Sonia. There's not. The fucking the trannies don't even account for millions and millions of American people. They don't
Stop one sex from the other, one person of one sex from another sex, from receiving that benefit. So if the medical condition is unwanted hair by a 9-year-old boy who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and his puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age can get that drug, but the other can't. That's the sex-based difference. It's not the medical condition is the same.
Were these people ever were they human? Because the boys that got like hair first, it's like you're sitting in 3rd grade and the dude had a full beard. Yes, there were some people that made fun of him, but he made fun of everybody else because you didn't get a full beard till you were like in, I don't know, college. And when the girl had like fucking double D titties in, I don't, what was her, like 6th grade, she was not made fun of. Her date card was just awfully goddamn full. Were these people ever human? Were they ever human? Or were they just straight lizards from the word go? I'm leaning towards they were just straight lizards from the word go.
But you're saying one sex is getting it and the other's not.
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it.
Yeah, Bob, I didn't rewind it. This is the same recording, apparently. So apparently it flipped and it went right back to the start of this dude's testimony. Oh, Jesus Christ. Now, we're going to kill the video here and we're going to hang out for a little while because I can't. I can take a lot, but Jesus Christ, I can't take that. Hi, everybody. it still didn't work right. Yeah, I can't. I can't take Liv through that again. I can't. Oh my God, the girl got boobs. All the guys in her class are going, holy shit, she's got boobs. Yeah, we didn't make fun of her for it. We really, really wanted to be her best friend for that. The only people that were making fun of it or for her or of it, yeah, either way, were the chicks who were so flat chested they couldn't get boobs, and they were the mean bitches. And link me. Oh, here, let me throw it out here. Yeah, I copied it. All right. Here, I'm just going to throw it out in the chat. We'll hang out till the wife gets home because I'll bail after she gets home. But yeah, come on here. Jump on. Yeah, you won't do it, you bitch. But yeah, Jesus Christ, what was her name? We were in 6th grade. This chick had like double D boobies. She could have killed you with them boobies. No one made fun of her. I promise you, she had no problems getting dates. So this whole idea, well, if they develop this, people will make fun of them. No. Us guys, we get made fun of all the time. We had squeaky ass voices and sounded like fucking cartoon characters. But oh, it's maddening. It really is maddening. Hello.
Why did you spray that in here?
Because it was awful cold outside, and I put shit down in there, and I sprayed it in here. What are you looking for?
Flashlight. Avoid downtown like the plague.
Your flashlight was still on the counter, I thought.
I'll walk past it. In here, there's a parade going on. They've got shit blocked off. I got stuck in traffic. There was like a couple cars ahead of me. There was some sort of dispute on who was supposed to go first. A motherfucker hopped out with an attitude. I had my gun in my lap.
Well, at least you had a gun on you.
Don't go downtown.
I ain't planning on going downtown anyway. So, yeah. For those of you who don't know, don't go downtown. According to the wife, because apparently she just has some crazy shit downtown. Nice strike. What's up, brother?
Finally.
Yeah, well, you
crazy
started,
shit downtown.
Yeah, well, you got there. The wife started talking, and
Yeah. No.
she's physically in the room can slap shit out of me, so I had to pay attention to her.
Yeah, well, I didn't send you pictures of my wood.
And no, but still, she can still physically slap the shit out of me. So
Well, you deserve it
can
half the
send
time.
wood pictures all you want. She can still slap me.
She'll still do it anyway, so you know.
Well, yeah, she'll look at your wood and still slap me. So there's that.
By the way, I had to tell
Nice
Jason that joke, and I told him that the backstory to that. He's like, "Oh, that's great. That is great."
What's a good email?
My C&T, or try sending it since I reset my phone, because my phone's been retarded. But try sending it since I reset my phone. Sorry, she's in the room. It's like extortion.
I'll leave you the fuck alone.
No, she won't.
No, she won't.
No, she won't. And like, I was sitting there trying to get understand what they were saying. And it's some chick in school, like high school or something, if she finally grows her boobs out, I mean, boys are gonna want to look at her. She's not gonna want to transition unless she's got like a mental disorder.
Oh, dude, this entire freaking thing is so massively insane. Oh my God!
They're trying to make it legal so that people can pretend to be something they're not, and then when they go and have surgeries to transition, 20 years down the line, they're gonna feel like, you know what, I really don't want to be this anymore, and they're not gonna have a way back.
Oh, they won't even make it 20 years. It won't even be near 20 years. You got to figure this entire set of arguments today was about really giving kids medications before they actually go through puberty, basically.
No.
I mean, that's the
people
whole
can argue with
argument
me on
today.
this all they want, but I'm going to lay some truth out. Okay, listen. Until you're 18, you do what your parents say. Period. And if you don't like it, well, guess what? Tough. But your parents' word is law until you're 18, and you're on your own.
Yeah, dude. If you can't get a tattoo
at 18,
at 13, why should I be able to give you a chemical that is going to alter the complete development of your body at 13, 11, 10? It logically, when you think about this, it makes no sense.
Well, the problem is this whole argument doesn't have logic in the first place, because they're trying to say it's okay for people to pretend to be something they're not because they have a mental disorder, and they're not getting mental help. They're just mutilating their bodies instead.
Oh yeah, it's no different.
And that's my stance on it. People, you can argue, you can disagree with me. I don't care. That's your problem. That's your deal. My deal is, I think people that transition are mentally defective.
Well, they need
mental help.
They definitely have mental issues. In the vast majority, and this is the reason you see the vast majority who, if you don't feed the delusion, if you actually give them mental care, basically grow out of it. And that is so an awful term to use, but they grow out of it versus the ones that you don't give the mental care to, and then they do the transitions, and then later on they commit suicide.
And I get this is a touchy subject for some people, and some people are on the fence. Some people are, on one side or the other, and that's great. I'm on the side that they need to get these people who want to transition. They need to get mental health first before they go and do this stuff. Because half the people that get transitions, some of them go back, and those that do go back after they've gone and mutilated themselves, they're miserable. And the point is, had they gotten proper mental health care done in the first place, had they seen like a therapist or a psychiatrist in the first place, they may not have transitioned, and they still would have been happier.
Well, here's something that and I can't remember what I talked about in streams before or not. So we all know about people who are born intersexed, right? In other words, their body develops in a way that doesn't present necessarily primarily one sex or the other. I mean, it happens.
It's few and far between. It's like a needle in a haystack type situation.
It's very few and far between. I believe the brain can do the very same thing. If the body can, the brain can. But it is so few, and it is such a minute part of the population that if you focus on the mental end of it for the vast majority of people, like, hey, guess what? Your dick and balls are growing normal, so guess what? You're a boy. and you
Surprise!
focus on the mental end of it, then a lot of this just resolves itself.
I know.
Are there some that it will not resolve? Yes. I mean, if you take someone who's intersex who is not presenting necessarily primarily one way or the other, and yes, you have people mentally that won't present that way. Are there some that I mean, ultimately, I mean, it sucks. There are people who are born with one leg, no hand, and fucking left-eyed. And we don't have a whole fucking goddamn new classification for them. So guess what? If you're born fucked up in another way, we don't have a new classification for you. It's just it is what it
Right.
is. I mean, I don't know. I went to school with people, elementary school. One of the girls in my class, she had, I think it was her right hand, no fingers on her right hand, none. Just little nubules. Okay, no one stopped the whole fucking world and made shit about her. There was one of the boys in classes who had some obviously mental deficiency. He got around with a walker and pulled his whole pants down to go to the bathroom in the bathroom. No one stopped the whole world for him.
Nope.
It was just, hey, you guys deal with it. This is the thing. She wrote with her left hand. He pissed with his pants down, and no one made a big deal about the whole shit.
Hey, I write with my left hand. Don't say anything
Well,
bad about it.
I am, well, I would say I'm trying to work with my left hand because this hand's still fucked up. But I'm trying to figure out how to work with a fucked up hand versus dealing with my left hand. I can shoot left-handed, I can weld left-handed, I can't write left-handed.
I can write left-handed, I can shoot left-handed, and I can shoot right-handed.
I'm the exact opposite.
Mhm.
I can shoot left-handed, weld left-handed, writing left-handed. It looks like I had my son fucking sub for me. It's like, okay, write my name for me, Wubba. Get to work.
Can I write right-handed? A little bit if I break my left hand, but I'm not.
No, well, my right hand's broken. I still can't fucking write my name left-handed. Just it doesn't work.
Well,
See, what's up, brother?
Anyways, but yeah, this is like mind-numbing shit.
Oh, it was, dude. This
Don't watch the rest of it. You went far enough, Coop. You went far enough.
Oh, dude, the oral arguments for the transgender shit actually happened on like Monday or Tuesday. And I listened to that, and I didn't realize the Rhodes case for the background checks on ammo actually happened yesterday on the 4th. Until someone posted on the X. I was like, well, shit, I gotta fucking get into those because,
yeah,
I mean, Friday oral and everything, but oh, it's just fucking horrible. It is. Yeah, I mean, you guys, especially guys that were in here from the start where we're listening to Rhodes and then listening to that. Yeah, it was oral transgender day, baby. Hold on to it. You don't want to relive it. That's all I gotta say.
Sadly.
Right, ABCs, 2, 1, 2, 3s, do. Dude, yeah, no, I couldn't. Fucking left-handed. No, I said I can shoot left-handed. I mean, it takes me a second on a rifle. I'm better on a pistol left-handed. Takes me a second on a rifle, but I can shoot left-handed on a rifle left-handed. Because I have no strength in my right hand to be able to, or especially my right trigger finger to be able to pull the trigger. It is fun. I went to the well, not fun. saw the neuro guy yesterday. And he's basically like, well, it could be permanent. We don't call it permanent till it's been that way for at least 2 years. It's what? So I got a epidural scheduled on my back on the 7th, and I've got surgery on my wrist and my elbow scheduled on the 9th, if long as the insurance company doesn't fucking screw me on that. Bob's in.
Made it.
Brother Bob, what's up?
Bob.
Oh, goodness. Don't ever go to the doctor. You end up sicker than you walked in.
Oh, yeah. You've been here for a little bit today.
Yeah.
Oh, yeah. Well, tell me about it.
Yeah, I just want
Dude, I went to the doctor.
Overdue for my... What? Oh, yeah, I went yesterday for my overdue physical. and ended up feeling like crap because of that stupid shingles vaccine they gave you, or me. So I knew it knocked me on my butt. I was hanging out on a ham site and it's already half prepared. So anyway, just have to deal with it.
Yep, we hear you.
Yeah, overdue physical.
Yeah, or at least.
What are we doing, Wubba?
Yeah, it could be worse.
Come here. What do you want?
Bread. Bread.
You want what?
Bread.
Bread. Hold on, you have to show me in a second, buddy. I'm freaking going to the hospital and getting damn sick. Which
yeah, no, I think they actually tested it. I think they actually tested the shingles vaccine.
which mine was
unlike the bat sniffles vaccine.
I went to freaking Wednesday before last when I woke up, my right hand wouldn't work, and I went to the hospital. My daughter had a bad cough, which is what I'm dealing with now. So I don't think I got it at the hospital. I got it from my kiddos because God knows they love to share.
Yeah, all kids do.
So, yeah, I got out with a left hand or right hand that doesn't work right and a cough. So, yeah. Tactical Muffin Top, my brother, welcome back. I know if you were listening to this at work and you didn't sound like you have Tourette's to everybody else you work with, you haven't been listening.
Was there another one of these on this subject?
No. Well, there was no. I did 2 today, and it was the ammo background check for California, and then did the transgender one.
I just saw the transgender.
Oh yeah, the ammo background check for California is maddening too. But if we've listened to God knows how many oral arguments on a lot of gun stuff and some other things. It's nowhere near as maddening as listening to the state, the federal government arguing for giving kids transgender treatment.
Yeah.
That shit hit. It was either Monday or Tuesday. And I did. Fuck, if I'd realized it was going on, I probably would have streamed it, even though I was at work. But I got to work, and all of a sudden it popped up that, hey, this is happening. I listened to it, and my students thought I was going absolutely psychotic. They thought I had a break with reality, and I was fucking fixing to go off. Because I'm like walking around the shop, but like, really, are you fucking kidding me? It's like, Coop, wait. No, dude, it ain't you. It ain't you. I promise. It ain't you. Just fucking, what the fuck?
How'd you think the ammo case went?
I don't know, man. It was hard to tell.
Who's arguing for the government?
Oh God, I can't remember her name. But the two female judges, this was in the Ninth Circuit. But the two female judges were actually asking questions that kind of led me to believe that they would side with the plaintiffs in the case. In other words, they would go ahead and uphold the case from Benitez. And the male judge in the case, he sounded like he was trying to fight to uphold the state's ban on everything. Or not ban, but their background check, whatever. So I'm, after listening to arguments.
Oh, you listen to it at the Ninth Circus, not the not the Supreme Court. Okay.
No, yeah. The ammo ban was the Ninth Circus. So it was. I don't know. I'm kind of thinking that the two female judges, if they go off the questions that they were asking, I think that they will uphold Benitez's decision. In other words, they'll uphold the district court's decision and say that the background checks on ammo are unconstitutional.
You're right.
Now it's always hard to tell because you've got some of these judges who will ask some great questions, but the reason they ask the questions is just to kind of learn how to skirt around them to uphold the bullshit.
Right.
And we've seen that in a lot of oral arguments. So we'll see what these justices do, but just listening to oral arguments in that case, and what was it? Rhodes versus Bonta. Just listening to the oral arguments in that case, I think there's a really good chance that the Ninth Circuit actually says that California's background checks on ammo are bullshit.
Right. Well, let's hope so. I mean, there's a lot of stuff that they didn't earn the name circus for no reason.
Yeah. Well, I mean, they upheld. They even talked about it today. The case with like gun shows being held on state grounds, like the state fairgrounds and stuff in California, and the Ninth Circuit upheld a ban on those gun shows being held on state grounds because you could go so far away and then get guns that way. And so the Ninth Circuit's upheld some really screwy shit. And there's no lie. There's a reason they're called the Ninth Circus.
Yep.
But I don't know. In this panel, I think it's a good possibility they could really and seriously side with the people instead of siding with the state. But again, I could be completely fucking wrong. So yeah, don't hold me to it, because if you give me a 50-50 shot on a bet, more than likely I'm wrong.
Yeah, let's hope the Ninth Circuit does the right thing. My goodness, how many times have they been wrong on gun control stuff?
Pretty much every time, which makes me a fucking outlier on this damn guess. But yeah, and it was just the way the two female justices actually questioned some of the things during that case, and it was like maybe I'm assigning too much fucking logic to these people, but if I'm asking that question and if the lawyer answers it in the way that they do, I'm like, no, fuck you, you're wrong. But I don't know. We'll see how that goes. But we won't get that decision until, I don't know, a few weeks, a month or so.
Yeah, a couple months at least for if they just have the oral arguments. Yeah.
So we'll see how that goes. But I'm honestly, after the oral arguments and after watching them, I'm really thinking it'll get shot down. But again, like I said, I could be completely fucking wrong. So
yeah, let's let's hope they've learned to apply Heller and Bruin.
Oh yeah, that ain't happening.
No, that's not happening.
No, even one of the what was the or the one of the female justices. What did she ask? I can't remember the way she asked. But she started out with, "I'm still confused over the way Bruin applies this," or something like that. It was like, "Oh, wait a second. How can you be confused about this? You are a federal justice. I'm a fat ass welding instructor, and I get how the so-called Bruin test works.
Yeah.
But ultimately, when she asked her question about it, it was like, okay, I can kind of see where you're rolling. I kind of see where you're at. I might throw something at you.
Definitely.
Oh, dude, yeah, that's a.
We don't talk about it.
That's a. How do you say Gilf I wouldn't like to?
I don't want to go there.
Because Gilf is grandma I'd like to. How do you say one I wouldn't like to? Yeah, she's the one I wouldn't like to.
Yeah.
She comes out square on this. Yeah.
The old brunette one is way left. Let me see if I can find that case. Now I'm curious who the panel was.
Oh, it was. Oh, hold on. I could probably find the panel for you quick. Hold on. I gotta bring my YouTube back up. And I could probably tell you, but no. If you went off a logical assumption off what she asked, then it would be like, no, there's no way she freaking upholds this case. But again, you're thinking about logical at that point.
Yeah.
Hold on. Rhode v. Bonta, BB, Akuda, and Bade. If that means anything to you.
Let's see.
BYBEIKUTA and BADE. Bade.
Let's see if I can pull up their bios. I think they have pictures on them.
Oh yeah. If you see her picture, it's a wrinkled old bag with fucking reddish brown hair. It kind of resembles a catcher's mitt. I'm just saying.
Yeah. No, in I saw one oral arguments. It was about concealed versus open carry in the Ninth Circuit, and basically they ruled you only have a right to keep and bear arms within the four walls of your house.
Oh yeah.
I mean that was their ruling.
And part of the arguments with that, and it came up today with the one argument for the state is this is all about care, or the right to own arms for self-defense. Right to own arms for self-defense. She kept kind of pounding that drum, and no, it's not the right to own arms for self-defense. It's the right to own arms for any legal purpose. So I could use it as a doorstop. I could use it as a door handle. I could throw it in my driveway. You know, all legal purposes. Self-defense is a legal purpose. I could use it for target shooting for a legal purpose. All those are all legal purposes.
Right.
Which
hunting, falls right in there.
Which,
but
none of those.
That's not why it's there. But
yeah, none of those are tests for why we have a Second Amendment, because, I mean, the Second Amendment was about basically having the arms to stand up to a tyrannical government, or another tyrannical force coming in. That was the whole purpose for the Second Amendment.
And after reading the Federalist and the Anti-Federalist papers, the right to keep and bear arms was to protect our country or to take out our government, because our government is just an experiment.
Mm-hmm.
Nobody knew that this government would last very long.
No, the whole idea behind the Second Amendment is we are going to arm the people so that the government is more scared of the people than the people are scared of the government. Mm-hmm. So that if the government ever becomes tyrannical, then the people have the arms to go ahead and overthrow that government, and then they can reconstitute it in another way that,
our first government didn't work out. The Articles of Confederation. Fortunately, we didn't have to have a revolution over it. But our first government didn't work out. So
it was. If it's history, I swear to God, the worst thing that's ever happened to this country is the leftists taking over the education system.
Yeah,
because people aren't taught this. They're absolutely not taught it. And if you aren't a absolute freaking just pain in the ass like I am, and go find it yourself, or like you are, or like Night Strike is, or others, if you don't go find it yourself, they don't teach it.
No, and then I only had in Texas, I grew up here, and the only requirement was one semester of high school government, and then that was split with one semester of economics. What are you going to learn that? How much are you going to learn in that time period?
Oh, it's man, public school education is it's literally going to be the ruin of this republic. It honestly is. And I'm gonna fucking laugh and point fingers at all the sons of bitches who were in favor of it the entire time.
Yeah.
I just.
Well, it could be okay, when back, it was certainly a lot better when it was in the hands of the states. The individual states handled public education, but now that it was nationalized under Carter, so.
Well, why do you think they're so afraid of the Department of Education being taken out?
Well, that's one of their control levers, right?
Yeah.
Brainwashing the. I was gonna say even going for I went to high school in the late 80s, early 90s, and it's probably gone downhill from there.
Oh yeah.
So,
dude, so you figure, so I'm 47. So you were probably a little bit ahead of me.
Yeah. Just like 3 or 4 years ahead of you, but same generation of
more than a couple of years ahead of me.
And I mean, we saw the same retarded shit happening. I mean, it just got a little bit more retarded under you, and a little bit more retarded underneath me, and a little bit more retarded under Night Strike. I mean, it's just.
Hey,
I'm not saying you were well, you were the retard, but I'm not saying.
Don't flatter yourself. It wasn't your fault.
Yeah.
Hey, just because the bus I rode on had a smaller number of seats than the larger ones doesn't mean necessarily that I'm.
Every other bus had 47 seats. Yours had 12.
It's not my fault.
Hey, look. My wife literally rode the short bus to school, so that shows you where I'm at.
I'm actually joking about this. I actually rode the bigger bus to school.
Yeah, that's what you say now.
Yeah.
You talk about your pecker the same way.
Hey, don't make me send more pictures of wood. That's all I'm saying.
Yeah, but all your wood is fucking communist wood.
Oh, really? Oh, really? The M1 Garand? M1 carbine? Yeah.
I'm gonna.
Yeah, that's what I thought. No. Sure. That's commie.
I'm gonna choke to death.
Good.
I'm pretty sure that was a Chicom M1.
No way. No fucking way. I would not buy a Chinese M1. What's wrong with you? That's a CMP Garand.
Anybody who knows you would buy a Chicom anything.
I would not buy a Chicom anything.
That's why your name is China Strike.
I don't know what you're talking about.
Everybody who knows you knows what I'm talking about.
I have no idea what you're talking
about. You're gonna try to fucking kill me.
You damn right I am.
I'm gonna get rid of this cough one of these days. I'm gonna choke you out. Oh,
no,
God.
But seriously, yeah, I got a lot of Chinese guns because they were cheap. What do you expect? You'd buy them too.
Oh yeah, I would, dude. If I could get my hands on a bunch of Norinco AKs and SKSs right now, oh shit, yeah, I'd load my fucking truck bed up with them.
And yeah, I bought a Chinese M14. Okay, yeah, why? Because I didn't want a fucking Springfield that's a fake Springfield. One, and two, at least the receiver is forged instead of cast.
Yeah, you got it on that one.
I mean, it may be Chinese forged. I'll give you that. Made out of the finest Chinesium forges.
Well,
but it's still forged over cast.
Chinese forged is kind of like everybody else's Coke cans melted together. So, yeah.
I mean, it's either that or, maybe I'll get a receiver made out of Croatia.
You'd be better off with a Croatian.
No, not really, because I really don't want to give Springfield Armory any money for new.
This is true. Oh shit!
But there's also the fact that it was $1,800 at that point in time for a standard M1A, and I'm like, fuck that. So I bought a Polytech M14, which was like $800 less.
Oh man, me and my boss have talked, and then we've many times in the last couple of years. And he's about 10 years older than me. And it was like, dude, if we had known what we know now, we would have bought pallets of SKSs and AKs and just held on to them until now. And then been like, hey, okay, you want the SKS? Here it is, $800. You
$800. It's still in Cosmoline.
Yeah, I was gonna say
Cosmoline.
Brand new Cosmoline on that sucker.
Yeah, dude. Because the last, it's been 3 years ago. It's been at least 3 years ago. The last SKS I had my hands on was at a gun show in Opelika, Alabama, and Norinco, Spiker, whole 9 yards, $800.
Yeah.
What? And I remember that being a fucking $89 gun.
And cheap Mosins too.
Oh yeah.
I mean, you get a crate or a pallet of Mosins. You get a crate or a pallet of SKSs and just sit on them.
Oh, dude, yeah. If I'd known the stupid shit that would happen right now, I would have been investing in them.
And when they started selling AKs, you would sit on those too.
I would have been on those like I was investing in Bitcoin back in the day.
Right.
Because it was about as good of investment. I mean, it's a hard investment. It's not just digital shit. Yeah,
I do have a Chinese AK, so
I know.
But it's a machine gun style.
Yeah, no, you dirty bastard.
It's the RPK Chinese one.
Dude, I still got to build an RPK. I got to.
I mean, I got the I could get one from PSA, but at the end of the day, it was going to cost me $1,700. But I got one locally that was the Norinco RPK for like 11.
I know, but
and all I did was I bought some RPK furniture and fitted it to the rifle, and then there you go, you're done.
I know, but I want to build the actual gun. So
I hate doing the trunnions, and I hate doing the what you call it, the riveting. I hate riveting. That's why I don't build them myself.
After doing a set me receiver, building an AK is nothing, not a thing. It's not a thing.
I know, and I'm gonna have to talk to you about that later. So
you're gonna have to give me therapy over that set me is what you're gonna have to give me.
Well, I may ask for your help.
No, you're gonna need to pay for my therapy.
I'm not paying for your therapy.
I still got to finish it.
You have a better paying job than I do right now. So
I've got the receiver done, the barrel pushed into the trunnion. I've got the barrel pinned. So all I've got to do is apparently trim down the fucking return spring, because apparently my return spring does not allow my bolt to come all the way back. So I got to figure out when to cut that down and where to cut it down. And then I can slap furniture on it, and then I'm going to weld the top pick rail on it and everything else. But I still can't use this all the way. So that's kind of slowing me down.
Did you break your hand or something?
No, dude. I woke up Wednesday before last. Or actually, it's been probably the Wednesday before that.
Did you strain it or something?
No. I woke up, dude, and I could not move any of this.
Did you have a stroke or something?
No, they tested me for stroke. I didn't have a stroke.
All right.
I had I fucking woke up. I was talking about the other day. I woke up and I'm used to kind of my hands being numb sometimes waking up, and I'll kind of rub them and my hands will work. But I woke up and I'm sitting here in my office where I'm sitting now, and rubbing on my hands is like 20 minutes. And no, this shit still didn't work. My whole hand was numb. Now I can feel my ring finger and my pinky finger. Still can't really feel the rest of my hand. But I told my wife, I was like, something's up.
Maybe you slept on a nerve or something?
Dude, I don't know. I fell asleep.
That sounds like you slept on a nerve or something.
Dude, I fell asleep that night in the goddamn bathtub. And my wife left me in it because I hadn't been sleeping a whole lot. Just because other pain, fucking legs and shit, and all the other shit going on. And I got up and got up out of the bathtub, didn't notice anything, went to bed at whatever time it was that morning, and then woke up at like 7:30 when she woke me up, because I woke up a little late and I couldn't use anything on this hand. And then ended up going to the doctor, or ended up going to the emergency room. And they immediately as soon as they saw what I was talking about, they checked me in. And I spent from Wednesday morning to Friday evening in the hospital with them doing all sorts of tests and all fucking sorts of shit to me, to figure out that they think this is a carpal tunnel restriction in my wrist and in my elbow. They ruled out stroke and all that. All that shit's good. No problems with any of that.
You might have cut off circulation or something.
I don't know, because when I fell asleep in the fucking bathtub, my hands are in my goddamn lap and I'm laid back, fucking relaxed. And then, hell, when I went to sleep, no fucking like crazy bullshit when I went to sleep. I just woke up in the bathtub, dried off, and then went to fucking bed,
Yeah.
And I'm used to waking up with my hands going numb sometimes, but my dexterity's there. In other words, I could take my thumb, I can touch every one of my fingers. My strength is there. I just, I may not feel my fingers, but they're there. The other day when that shit happened, it was like, fuck, when I went to the hospital, dude was like, hey, squeeze my fingers. And it was like, okay, right hand, I'm going to send you to, or left hand, I'm going to send you to your knees if I squeeze your fingers. And right hand, it fucking felt like a newborn baby trying to squeeze the fingers. There was just no strength there at all. Now I've got my ring finger and pinky finger. I got a little bit of strength there, but my fucking trigger finger, no, I'm carrying left-handed right now. Because I can't fucking manipulate a firearm left-handed or right-handed. It's fucking ridiculous. Matter of fact, this weekend I might have to do a whole new Kydex holster for my gun, so I can carry left-handed dedicated. That might be my weekend.
Well, there are worse things you can do on the weekend.
Yeah.
Yeah, I know. I mean, stick your dick in a blender.
Yeah.
Fucking hang out with Hunter Biden.
Or a pencil sharpener.
Yeah.
I looked at the panel. That ugly chick was appointed by George W. Bush. So was the guy, and the other woman was appointed by Trump. So.
Yeah, well, it looked like the two women on that panel were the two that would probably. It sounded like, by the questions they asked, and again, I throw out a big caveat.
Yeah.
By the questions they asked, they sounded like they would probably go ahead and uphold Benitez's decision. The guy on the panel, by the questions he asked,
it's Saint Benitez.
Yeah, it is Saint Benitez. It is absolute Saint Benitez.
Bybee is the guy. Yeah.
Yeah, it's the guy on the panel sounded like he would probably uphold the state's case. And I got to throw it out there again, kids. I could be completely wrong. Completely wrong.
Well, what I've seen at the Ninth
Circuit,
Circuit
the way it sounded.
is that it may not, their political leanings going in may not make a difference. It seems like they go native when they go out there.
Oh, they do. They absolutely go native when they go to the ninth. It doesn't matter who appoints them. It doesn't matter how they ruled before then. When they go to the ninth, it's absolutely whoa. And, they go.
Let's all be communists.
It's more like.
Yeah, it's complete fucking. There would be male turkeys out there going, blah, yeah, every time they heard them. Yeah, that's the way they roll.
Yep. Sad to say.
Coop, thank you for keeping my blood pressure in check. Yeah, dude. I am amazed my blood pressure stays where it's at. Chest.
I am too.
The amount of shit that I pay attention to. Word. No, the papers are still in the truck. I was like, hell, I had to show you guys my blood pressure's been at for the last couple days, but no, it's still in the truck. I ain't going out there to fucking go get it.
It's pretty bad.
No, my blood pressure's been great. The only thing that they say sucks is my cholesterol, and fuck that, because I'm not taking cholesterol medicine. Everything else is fucking spot on. and they can kiss my ass on the whole cholesterol thing.
Don't believe him. Don't believe him.
Yeah. Well, if you look at how much your body needs cholesterol, and how many people that are in fucking homes right now with dementia because they've taken cholesterol medication for so long, yeah, I ain't taking it. No, I'll deal with that heart attack when I get there. And as much as my cholesterol's been high, or so-called been high. All right, when this shit happened with my left hand and they did all these tests on me, they can't find any blockages. I've been ultrasound, I've been MRI'd, I've been fucking EKG'd, all the other shit. They can't find any blockages anywhere, but my cholesterol is apparently high. And they want me going on medications, even though there's no restrictions, no nothing. And that's what they say that happens when you have high cholesterol. No, fuck you. I'm fine. I'll be gnawing on my piece of fried chicken when I die, bastards. Just saying. What are you doing? You're supposed to be eating lean meat. I'm sorry, that's a ribeye, motherfucker. And it's medium rare. That's where it's at.
Fried chicken in one hand and a cigarette in the other.
Yeah. Well, I'm trying to quit smoking now, so.
Oh, you are? Good for you.
Yeah, it's the reason you haven't seen me light like 19 cigarettes in the last 5 minutes. But
good luck with it. My goodness, that was the hardest thing I have ever done.
Oh, dude, I'm wearing a nicotine patch right now, and I got a fucking nicotine pouch in my lip.
Yeah.
I'm ready to chew on my desk like a fucking beaver right now.
Would now be a bad time to mention that I went cold turkey?
Fuck you. That's all I gotta say. Fuck you.
You can do that great.
Giant dildo.
Yeah.
I love you. I love you too, Coop.
Yeah, I love you too. But fuck you with a giant dildo.
Well, remember, at that point, I'd only been smoking for like 10 years.
Well, I have you by, let me see, I started smoking when I was about 13. So I'm 47 now. Yeah, I got you by a few years.
Yeah, I smoked for like 10 years, and then I was like, yeah, I'm going cold turkey because this shit's getting expensive. And it started getting really expensive, and I'm like, yeah, fuck that. I'm not smoking like 6 packs a day anymore.
Oh, dude, I know some people that have done it. Buddy of mine.
Oh, it's worse. It's worse. I smoke menthols.
Oh, well, it's like a buddy of mine. You know, when he got his first divorce, and he smoked. Well, it's been years ago, so he's probably smoking for 10 years, about like you. And when he got his first divorce, he was like, "Screw it, I can't afford smoking and everything else, and to be able to have money to like redate and shit like that," and he quit. And fuck Mike, if you're ever watching, you dirty bastard. But yeah, smoking is my kryptonite. I've come off of opioids like a heroin addict easier than I've come off of smoking cigarettes. I mean, just rode the shit out for about a week and a half and been like, yeah, I'm done. Easier than smoking cigarettes. Because the whole time I was coming off the opioids, I was smoking cigarettes. So there's that.
Yeah, it took me a week in bed to get off cigarettes and onto Nicorette, and then 9 years later, I'm still on Nicorette. Now I'm trying to quit that.
Oh, what was fucking Bill Engvall said he got off of fucking smoking by doing cigars, and then got off cigars by doing patches, and he got off patches by fuck, what did he say? I'm gonna have to find that goddamn clip because it was hysterical. And then it finally came down to he got off that by doing crack, so he's pretty much tobacco free. Yeah, that's pretty much the way it goes.
That's not much better.
Hey, look, Hunter Biden, just want to say, I mean, pardons and everything.
Hey, I need a couple pardons. Throw some my way.
Shit,
right?
Dude, I wish I'd been pardoned for half the shit I've done in my life.
I mean, most of the shit I did was before I was 18, so you know I got out of that. But seriously, you know I could use a pardon or two.
Oh, dude, I didn't start really fucking up until I was after 18, so I'm a late bloomer.
You are. I got all sorts of trouble.
Yeah, I was a definite late bloomer.
I mean, you know you did it right when you did it before you were 18, before they could get you.
Weren't you an army brat or something? You weren't in any place long enough to mess up?
Oh no, I was in plenty of places long enough to fuck up. I just really didn't do it real bad until I was in a single place.
Got it.
I mean,
yeah.
I moved around a lot when I was younger too, but that's only because my dad was climbing the corporate ladder.
Mm-hmm.
So.
Yeah, well, yeah. And climb the corporate ladder. Yeah, no, I did plenty of fucking up before I was there, but yeah, I really didn't reach my peak of fucking up until way after that. Dude, I spent fucking, when was it? Oh God, it had to have been 90. Oh shit. 92. Me and a bunch of buddies, and we were like teenagers, early teens back then. And in Germany, we could go get fucking beer, liquor like easy. I mean, it was just, if you had the money to buy the shit, you got it. And we were climbing a fucking crane in Heidelberg, Germany. Yeah, I like to broke my goddamn neck. But yeah, I did a whole lot of fucking up long before I did my serious fucking up.
Yeah, well, I've never gotten to the serious ones, so I'm gonna call it good.
Yeah, call it good. Trust me, call it good, and then don't do it. I don't recommend the serious fucking up.
No, because I like my guns.
Yeah, well, it took me from from 2003 to 2018 to get my gun rights back.
Yeah.
Well, yeah.
And just realize that's only in your state.
Well, technically, it was state charges, so it's a state deal, so it shouldn't affect my federal.
Yeah, they all say that.
Yeah. Look, the fucking funny shit. So when I finally got all my shit squashed, I called the lawyer Mark Post over in Georgia, because that's where everything was at. I got shit squashed. And he told me, hey, said, give it a month at least, and then you should be good. Because I told Mark, I said, look, I want my firearms rights back, hold on yards. He said, look, give it a month. Right. No problem. A month to the fucking day, I was at Bear Automotive in Butler, Georgia. I bought my 1911 and bought my wife her Fox side-by-side 12-gauge shotgun. No problem. Background check was back in like a minute. It was fucking poof. It was done. Fast forward to, when was it? It was 2022. Yeah, it had to have been 2022. Because I was doing SDI. My wife did SDI in like 2021, and I did it in 2022, and they quit doing 80% receivers, so they were sending out full receivers, so you had to get them sent to an FFL, and then you had to go pick them up and all this horse shit. So, okay. But a buddy of mine's an FFL, and I said, okay. I had my receiver sent to him, and I went to pick it up, and my buddy walked out there and went, dude, you're denied. I went, the fuck you mean I'm denied? He said, you're denied. I thought he was screwing with me. So we waited like 28 days for the ATF to rectify this shit. Because it was right underneath a month, which would have made me have to go through another background check. I waited like 28 days, and I was finally like, okay, fuck it, dude, I'll pick it up. I'm done. And after like 3 days, I could pick it up. But I went to like 28 days, and I picked it up from him. And then like fucking, it was 40-something days, because he asked the ATF about it. Hey, are we going forward with this, whatever? But it was like 40-something days. The ATF was like, oh, yeah, it's fine. It's good. It's like, what the fuck? You stupid motherfuckers.
You mean they waited 40 days to say yes?
Yes. It was retarded.
See, that's funny. When I went to go and buy my first receivers, you know what you know what I got right away after I filled out the paperwork?
Something Chinese.
Well, no, I didn't get something. No, I know people don't like to put their social security number on your 4473, but I did it then because I didn't have a carry permit then.
Oh, dude.
And guess what? I got within after I filled that paperwork out, they submitted it, and within 15 minutes, I was out of the door with my stuff.
I have used my social security number for pretty much every 4473 that I've ever done.
So have I.
Minus
the when I stopped doing it when I got my CWP, because in say South Carolina, you know, as long as you have a valid CWP, you don't have to put your social security number in there. Well, you have to fill out the 4473, but they're not required to send it in anymore.
Well, that's and in Alabama, which I live in Georgia, I've lived in a bunch of states,
and I keep that shit
in
valid,
Alabama, we can't do that anyway because there were sheriffs like selling fucking carry permits like they were confetti.
Well, in South Carolina, it's a state level agency that hands them out.
Yeah. So I mean, we couldn't do that. So anytime from the time I was 18 and on, anytime I bought a firearm, I used my social security number.
And people that's a funny thing. A lot of people I've heard that have guns and whatnot, and they go and get guns, and like they're always jumpy about giving the government their social security number on a government form, and it's like, hello, these are the people that gave you that damn number in the first place.
They already know you. They
already know
you.
They know who you are.
Yeah.
Your social security number is on your taxes when you send them to the IRS.
Yep.
So why are you so uppity about giving it to them on a federal form to buy a firearm?
Yeah, it's
whether you like it or not, any other firearm you bought via 4473 you filled out, they know you got. So it's not like they don't know what you have.
Yeah, even the 80% guns that I built, whether it's AKs, ARs, the set me, hopefully I'll finish one day. They already know. They already know what I got. All they got to do is do a little bit of research. They know what I've got. We've already proven that these credit card companies and everything else will turn all their information over to the government at the drop of a hat. They already have it. So unless you smelted it from, I mean, from the word go, unless you smelted it, and melted down aluminum cans, like these.
Someone did melt all of their aluminum cans, Coke cans, to make an AR-15 receiver.
They did. I've seen a dude do one in brass. It was awful freaking cool.
Even if it was brass, it'll still work fine because remember, all the forces of the AR-15 is in the upper.
Oh yeah, it's the upper. But
that's why you can put a 50 BMG upper on a 5.56 lower and not have any problems because all the force is in the upper.
But if you don't believe that the federal government doesn't like, I mean, my first AR, so I got a 80% Anderson lower, bought some parts, did the whole thing. I bought a PSA upper for it. If you don't think the government knows that I have that, you're
wrong.
Retarded. I mean, you are absolutely retarded.
The government knows.
Because all they do is they tell the credit card company, hey, we want this information, and the credit card company gives it right over to them. And that's been proven in a bunch of cases. So the only way you have a gun that the government doesn't know about is if you make the receiver dead by yourself from like a block of goddamn, I don't know, dog shit, and you make the upper by yourself, and you do the barrel by yourself. If you order a part if you order a part offline, they already know you got it.
Yeah, you do a private sale with cash. That's the only other way.
Yeah.
Get the whole gun.
Yeah. Just, I mean, hey, Fred, Joe, Bob, whatever, you got an AR for sale. Let me buy that from you. Here's $600 cash. But they can still track that AR to Joe Bob, and I guarantee you Joe Bob will tell them who they sold it to. It's
Joe Bob will crack in no time.
Oh yeah, Joe Bob's gonna crack in no time. They're gonna be like, Joe Bob, you want this shot of Jägermeister? And he's gonna be like, but I sold it to Fred so and so. Yeah. It's fucking.
Oh boy.
You give him a shot of Jägermeister, that motherfucker gonna give you your grandma's address. He ain't gonna give a damn about you buying that gun from him.
Nope.
All right. Give me just a sec. I'll be right back.
All right.
Yeah, I think I did on that Coke can receiver. Did they make a big block and mill it, or I think I saw a video on that, or did they cast it somehow?
I think they casted it.
Oh, okay.
Because it's easier to make it cast than it is to try and mill it.
Yeah, I thought I saw one where they made a block and then they milled it from there. I mean, once you have all your jigs and stuff down, that milling it's easy. So
yeah.
I watched the whole video series on a guy who eventually made a lower out of titanium. So he went through aluminum first to get all his screw ups out of the way. So, but he ended up with a nice titanium lower at the end of it. So.
Mm-hmm.
What I think Barton Fink said, there's somebody made one out of wood.
Yeah, I saw that one too.
I bought a couple 80% plastic ones. I haven't screwed them yet, but I don't see why not. They wouldn't work. So
I mean, I could 3D print them and they work just fine.
Yeah. People 3D print them, but
as I've printed a couple orcas, so they work.
Yeah. I was gonna say, what's his name, Hoffman?
Yeah, Tim Hoffman. So that's not like they don't work.
Yeah.
Are they gonna last as long as like a metal receiver? No, but will they work? They'll be work.
Sure. Yeah, when I get some more money, and hopefully in the not too distant future, I'll buy an Orca kit just to support him.
I just bought the parts.
Yeah, well, I think he has a kit, and then you print whatever you need to print. He sells all the rest of the stuff that's made for it. So I was gonna do that. So
yeah,
along with my other avocations that consume money.
What are we doing about money?
Oh, I need more money, and I was going to buy one of those Orca kits from Hoffman when I get more money.
So do I.
We all need more money. Who don't need more money? Hell, Trump needs more money.
Right.
Well, you know who else who needs more money?
Me.
No, Hunter Biden.
Yeah, Hunter Biden doesn't need more money. Nah, he's probably the one person who doesn't need more money.
I'm just messing around. I'm not being serious.
Oh, Jesus Christ. The amount of shit. Oh, so who
money out of Ukraine yet?
Oh, was Colt. Colt was when I started the stream today. Apparently Joe Biden was on Fox News trying to justify pardoning Hunter Biden. And I hadn't got to that yet because
maybe that video you should have been watching instead of in what you were watching.
I don't know. No, it's probably not because I don't have a nail gun to shoot myself in the face with. Because
I mean, I could loan you one.
Yeah, I might need one. If I'm watching that, I might need one.
I've got several of them. I could loan you one.
But just fucking just. This is like that dude. There was a true story about a dude. It's been I don't know how many years ago. He was running a skill saw and like cut his hand off. And the pain was so bad. He picked up the nail gun and just started shooting himself in the fucking head with it, trying to stop the pain. Okay. That's how I feel about watching Joe Biden. Fucking just keep.
That's how everybody feels of watching Joe Biden. It's not just you. Otherwise, they wouldn't have voted him out of office.
Well, there's plenty of people who are still pissed about him not getting back in office.
Yeah, well, they're also a bit of them are actually following through this time and leaving the country.
Not enough of them.
Not enough of them. No.
Yeah. Who is actually okay? Let's throw this out there. Who is leaving the country without child sex charges against them?
Ooh.
Ellen DeGeneres.
Okay.
Well, she was gonna leave. Unfortunately, didn't you hear about that house she bought in England?
Well, it flooded, but I thought she had already left. But
it flooded. It's underwater right now.
Yeah, well, I heard that. Is she still here? Do we need to?
And what about the child sex charges that are against her? Because I'm pretty sure there are some.
Are there? I don't know. I thought she was kind of a goody two shoes to have.
No. Pretty much every one of these people who has left the country like that has serious charges against them. Jesus Christ, Tom Hanks. Could fucking Forrest Gump have not been the one? But no, he's there too. That's why that son bitch moved to a damn non-extradition country. Why do you leave the country? Oh, nothing. Lieutenant Dan. You ain't got no extradition policy. Yeah, I'm moving to you. Yeah, every one of these fucking leftists that you see that leaves the country, it's always to a non-extradition country for some reason. I ain't figured it out yet. Yeah, I have, but I gotta say it for the fucking joke, so the joke works out. But okay. Mention Blow Joe, the cartel. Thanks. Yeah, dude. Yeah, Blow Joe and the cartels are gonna get mentioned constantly for long amounts of time. Just saying. If it's me, I'm gonna mention them any stream I do. If it's the mainstream media, they're gonna fucking memory hold that shit as fast as they can. Whatski? It's fucking it is so freaking crazy watching this stuff. If you're like us and you're actually awake and you're watching this stuff in real time, it's freaking crazy watching it. Watching how the mainstream media just memory hole shit. Watching who they call out and who they don't. And it's like
I almost feel sorry for you.
Dude, I feel sorry for me every day I wake up. So that's
Oh, I said almost, you know.
Yeah, well, like fuck, you wake up in the morning, look in the mirror, and go, "God damn, I'm sorry for you, son of a bitch."
And it's pretty much how it is.
That's pretty much how I wake up. That's why I haven't shaved in a while. I want to look in the fucking mirror and say I'm sorry for myself.
Yeah, you know, you look in the mirror and like, God, look at that sorry bastard.
Yeah, never mind the fact my right hand don't work. That makes it even goddamn worse because you're like looking at yourself with a fucking shaver going like this. Like, no, fuck, never mind. I won't even look in the mirror. Just fuck you. We're gonna roll with it.
Right.
Just come out of the bathroom looking like that guy on an airplane who shaved in the bathroom.
Oh, I remember that. That's great.
Oh, I wish we could watch movies together on fucking YouTube. I wish we could. We'd be watching Blazing Saddles and Airplane like constantly.
Airplane 2. I like.
Oh yeah, Airplane 2.
The second one was a good sequel.
Yes, that was probably. Well, no, I won't say that's the only good sequel because Lethal Weapon 2 was good.
Well,
and Die Hard was good.
The whole courtroom scene in the second one, where the person who takes all the notes started using the typewriter like it was a piano like Charles. That was great.
Oh, dude.
You know what I'm talking about? It's hilarious.
There are very few movies that make like a really good and true like second part, and that's one of them. Oh shit!
You remember the scene I'm talking about? It was freaking hilarious.
I know exactly which one you're talking about. Because I can remember the original Airplane, so I can remember the second one. Yeah.
Or how about the fact that in the second one they had William Shatner looking out of a space periscope and he sees the Enterprise.
Oh, dude.
Come on, that's funny.
Dude, there were so many movies back then that were absolutely hysterical. And I had so many things built into them.
And you can't make them today.
No, you can't. You can't. One, people aren't that informed today. They're just not. They won't get the entire joke. And it's
and they offend too many people. I mean, just Like on airplane. Excuse me, ma'am. I speak jive.
Oh, well, it's no different. We've said plenty of times. You could not make Blazing Saddles right now at all, ever. You couldn't do it right now. It would hurt too many feelings. People would be all like clutching their chests and falling to the side. And, oh my gods and everything. You couldn't do it. You couldn't do Blazing Saddles right now. And all it did was made fun of racists. That was the entire theme of the movie, was making racists look like fucking dumbasses. But you couldn't do it right now. You couldn't. I said that shit on the X not too long back, and there were some people that replied. It was like, "Oh, you're just a racist." Hold on, wait a second, you dumb sons of bitches. You don't get the point of the movie. You don't. You completely American History X. You lost the plot of the movie, and if you've never seen American History X, it is.
They would have had to have the plot to begin with. So.
Oh well, yeah, you're right about that. They just fucking they bypassed plot and went. I don't know, fucking left. They took the first left fucking turn they could find. That's the only thing they did. It's seriously like American History X. It was a great movie. If you only watch like the first, I don't know, 15 minutes of the movie, you think that was some racist shit. But if you watch the entire movie, you figure out the plot of the movie, and you figure out they're talking about racist shit as bullshit. But there were plenty of people who threw a fit over that movie. And it's like, don't you freaking get the point? No, you know, obviously you don't get the fucking point. You just need to be fucking hit in the head with a baseball bat and laid into a shallow grave. So okay, there's that.
Mm-hmm.
Spaceballs. Yeah, Spaceballs was another great fucking movie. And no, you couldn't make Spaceballs at this point.
No, you couldn't.
And chess, yeah. And that's my thing with some of these bullshit pardons that Biden apparently is fixing to do. And like the one he did with Hunter. How do you pardon someone for someone that they haven't even been charged with? I can see taking someone who has been charged with something, convicted in something, and saying, no, I'm reversing that.
Well, they're doing it. They're doing it like Trump pardoned the way Trump just automatically pardoned Joe Arpaio.
Well, didn't Gerald Ford pardon everything that Nixon did or would have done or whatever?
Yeah, maybe he did.
Yeah, I thought he had like a blanket pardon for even stuff they haven't charged him with. So.
But Republican, Democrat, whatever. Again, how do you? So in 2010, I got a pardon. I got a state pardon for my bullshit. It gave me my voting rights back, but not my right to own firearms rights back. I had to wait till a little bit later for that. But in 2010, I got a pardon and got my firearms rights back. But how do you pardon someone for shit they've never been charged with? How do you say this person is pardoned for shit that they have done?
I don't know. Look up Nixon's pardon. I'm sure the wording is there.
Yeah, haven't done, may have done for the past 11 years.
Your guess is as good as mine, you know?
It fucking baffles me. And I'm baffled by a lot of shit like tying my shoes. That's why I wear slip-on boots. But jam. Just it's like, and how do people automatically accept this shit? You know, there should be 90% of this country at least raising hell about it, but there's at least 50-something percent of this country going, yeah, it seems fine to us.
Yeah.
What? It wouldn't matter to me whether a Republican did it or anybody else. Fuck me. What? You're pardoning them for 10 or 11 years, effectively, for shit they have been charged with, stuff they haven't been charged with,
stuff they could be charged with.
Stuff they could be charged with. All that shit's just okay. What?
Well, maybe I should just ask Trump to give me a retroactive pardon just for the hell of it.
He needs to give me a pardon for the next, I don't know, a month or so, and I could sort some shit out. I'm just saying.
Just to ask him for a pardon between the years of this and this. That way, all of that is gone. And just say, hey, I've been good for the last, so many years. So just give me a pardon. Like if Joe Biden can do it, you can do it too.
Yeah. Give me a pardon for the next.
Yeah. The Nixon pardon says offenses that Nixon has or may have committed taken place between certain dates.
Yeah.
It just says offenses, and that takes care of just everything.
Give me a pardon in between 2024 and January 2025, and I can take care of a lot of shit. Let's just say in between that time.
Give me a pardon between the years 1995 and 2005, and I'll be fine.
Oh, you're way past the statute of limitations on that shit.
And some things, yeah.
Look, that squirrel in the rate does not count.
Hey! How did you find out about that one?
Look, I'm just saying that squirrel had a hell of a memoir, and I read every nut of it.
Ooh. Well, it's better than that time you were with that possum.
Hey, look, that possum was completely asking for that shit.
No, that possum was just playing possum.
Playing possum and asking for it are the same thing. Didn't you know that? That's like possum rule 101.
Well, they weren't happy about it. I'll tell you that.
Oh, please. That possum left here with a smile on his face.
No, it didn't.
Yeah, it did. How do you know where their possum smiles? They're always smiling. They got a big ass snout, a lot of teeth.
Yeah, those teeth kind of scare me.
They didn't scare me. It scared Moochie. Just saying. Which one of my kids screaming something?
They're always screaming.
Oh, they were going at it a few minutes ago. Thought one of them was dying or something.
Nah, they ain't that bad. Freaking. Oh, hell, last night. Freaking wake up. I went to sleep early, but I woke up at like 2-something. 2:15-ish, whatever. Walk in the office, go in here, fucking pop a dip in the mouth and like hating life. And I'm like, wait a second. I passed my son's room. My son wasn't in his room. Where's my son at? Well, he could be in 3 separate places at that point in time. And later on, like 4 something, I went in and laid back down in the bed, like 4, almost 5 o'clock this morning. And then all I heard was this little cough. And little thing roll over next to me. I'm like, yeah, I know exactly where he's at. he done bailed out of his room, went and got in bed with me. He's like, yeah, you little shit. Wake up with damn feet in my ear. And whatever the hell he's watching right now, he is having a great time watching it.
Yeah, it sounds like it.
He's watching Blazing Saddles.
It will not be long. He will be watching Blazing Saddles. Now there's freaking I can't remember what it's called. And it'll be like cars, like animation cars. They run through like all these like gears and shit that tear them apart and flip them around, do all sorts of crazy shit. And he's in love with that shit. That and like water towers tipping over. What can I say? He's a fan of destruction. Yeah, I kind of am too. What are you, dude? Are you?
Maybe you need to turn this off and go take care of them.
I don't. I'm trying to figure out what he's watching. Cause he just fuck. Holy shit!
You just need to put cameras in each room and then watch it all from your lair.
I don't
right
know
there.
whether I want cameras in that room right now. I don't know whether I want to see what's happening.
That might be best.
There could be a kangaroo in there getting violated at this point.
Either that or a crocodile. No, alligator. It'd be alligator down there.
Yeah, it's probably an alligator, but Jesus Christ, kid. Oh, shit. Ow. That hurt.
I mean, the dog's not there, is it?
No, the dog moved out a while ago. The dog figured out that I don't like the ATF and they don't like me, and that bitch moved to my mother-in-law's house. She was like, fuck it. The ATF don't know where the mother-in-law's at. That's where I'm moving.
I mean, I don't have a dog, so the ATF can't shoot what I don't have.
Oh shit. No. My wife, the husky, Mia, beautiful husky, who loves my wife. I mean, loves my wife. However, my mother and father-in-law have a beautiful big shepherd, Gunny. And Mia fell in love with Gunny. And, well, Mia kind of weaseled her way into moving in with Gunny. So, yeah. But I have my wife cats right now. The dogs are gone. Because Mia moved in with Gunny. Because that's her boyfriend. Although it's funny as fuck. Because when I show up over there, Gunny will move his big ass in front of me and won't let Mia near me. It's hysterical. Because I'll pick the kids up over there normally at least 2 days a week. And depending on what's going on, I'll pick kids up over there, more than that. But no, Gunny, his big fucking, he's got to be 110 pounds. Has to be. If Mia runs towards me, and Mia's like 50 pounds ish, somewhere around there, husky. If she runs towards me, he cuts her ass off. And then I got Gunny right there. He is freaking hysterical. He wants me want another shepherd so bad, it isn't even funny. I do. Oh God, I want another shepherd. If I knew right now I could get another shepherd like the female shepherd I had, dude, I would get that in a hurry because she was just absolutely outstanding. She was badass. Gunny in a way is kind of like that. He's the tank version of her because she probably topped out at like 45 pounds and Gunny is like fucking 110 pounds. But yeah, if I knew I could get another shepherd like her, oh, I would absolutely do it. Bob, what are you typing on?
I'm just entering in some stuff about the medication and vitamins I'm taking.
You are always typing in the background.
Yeah,
you can always tell what Bob's in because you can hear.
I don't know if you hear mine. I mean, you know,
I have
not like Bob's. Bob's is always freaking
click, click, click. Yeah, I have a mechanical buckle spring keyboard. So.
I have a mechanical keyboard too, but you know.
Dude, if it was me typing like Bob, you would hear that click like every 5 seconds.
Well,
it would be like to tap.
If I had my microphone gained up higher, you could hear me typing on the keyboard. You would yell at me because I'm typing.
Oh shit!
Because Matt used to yell at me for that.
Shit,
Yeah.
Bob types and it's fluid. It's like
and when I say Matt, I mean never enough ammo.
Yeah, but Bob types and Bob is like tap, and it's fluid. For me, it would be like tap, and then I have to use the other hand to tap, and then I have to find the other place on my keyboard to tap.
Yeah, I'm a touch typist, so.
Oh shit, dude!
So I'm not looking at anything on the keyboard.
Dude, I can't type without looking at the keyboard. You fucker.
Yeah. I mean, I took a semester of typing in high school, and I figured I'd be around computers, and I ended up typing a lot after.
That's Bob just throwing his dick on the table.
But, you know,
I took a semester of typing in high school, and I can type 10 times way better than you.
Well, not many people would admit. Not many males would admit to taking typing in high school at my age.
I took it in high school too. I took typing. It was 1 and 2, so I took both of them.
I think,
but by that point they were using. You know, this was like 97 and 98. Okay, and by that point they were still using computers from like 1987.
Oh yeah,
dude. Hey, look,
but at least they weren't Macintosh computers. At least they were IBM style.
Oh, look, in what was it? 1993, 1992. Had it been 1992, 1991. Yeah, I was still playing the Oregon Trail on computers and thinking that was badass. So fuck all y'all.
Well, I was doing that too at that time. It was like 91, 92. I was doing that too.
Yeah,
I had to get transferred into. I had originally signed up for like a year of typing, and I couldn't take it. It was the IBM Selectric, and they were like, and the teacher was just horrible, and I was like, I can't do this, counselor. Put me in a semester. So I actually got to type on a computer, but it was one of those the original IBM PCs.
But the funny thing is these computers, they were networked, but they weren't networked with, you know, the Cat 5 cables or the Cat 4 cables. They were networked with no, it was worse. They were networked with the BNC cables.
Yeah, the 10-base-2. Yeah.
So it's just like,
what the fuck you saying? Someone told me Coop was a big boy.
a bag boy.
He helped the lady with groceries car. Just you dirty bastard, you. Probably you are not lying. I'm just saying you might not be lying.
Wow.
It could have happened. I have watered some ladies' plants and stuff like that. It's happened.
I think before anything gets worse, we might need to call this one.
Yeah, we'll call it in a minute or two or 10, something like that.
Now he's laughing. I don't know. That's worse.
No, well, Chess was just telling the truth. I mean, I have been known to.
Don't say that in front of your wife.
She's in the other room. Shut up. What? What are you? What?
We're gonna wear his.
Can you what the what?
What the what?
Why do you still Monkey's jacket?
Oh boy.
Okay, that's a new one. My son has officially stole my daughter's jacket.
Well, takes all kinds, I guess.
Yeah, it definitely takes all kinds.
I mean, it's your family after all.
Yeah, it is. I guess kind of, sort of, sort of, kind of,
sort of, maybe.
Should be, maybe.
It
Yeah,
should be his family.
You got me on that one. Because they're not someone else's family. Because I wouldn't be raising the sons of bitches. But okay.
If they weren't yours, you wouldn't be raising them.
I've done that in the past, but I'm not doing it now. So. Yeah.
All right.
These two are definitely mine. I have DNA evidence that they belong to me.
Well,
trust but verify.
Yeah, trust but verify. Yeah, it's like okay, we're getting the DNA test done. Yeah, they're mine. Just holy shit. Yeah, they're mine.
Sounds like it.
I so want to tell you where to go right now, but I won't. Oh shit.
Let's see how many times we can get Coop to cough.
Ever since my daughter showed up, like what? It was before. Well, it was before I went in the hospital. She showed up with a cough. Okay, so your 7-year-old, 8-year-old now shows up with a cough. Okay, they're like carrier monkeys. You give them whatever you want, and they're going to spread it across the country. And I've made it all the way through the time I was in the hospital and the time I got home before this shit kicked in. So I was like, if you can dodge a wrench, you can dodge a ball, you can dodge a germ. And
another movie you can't make today.
Got me. Yeah.
You can't make Dodgeball today.
No, you can't.
Because of the ending.
It will absolutely be blackballed just because of that.
But just remember, fucking Chuck Norris.
But yeah, I was like Rocky, man. I'm like ducking and dodging.
Yeah,
had my fucking hands up, and I was
remember the 5 Ds of dodgeball:
in the face,
dodge, dip, duck, dive, and
yeah.
dodge.
Well, apparently at some point there was another dodge in there I wasn't aware of, and I caught the damn cough.
Yeah.
And then I've been like ready to hack up a lung for the last damn 2 weeks.
Hey, you'll be fine.
Yeah, I mean, who needs both lungs? I can hack one up, the other one will be fine.
Right. You'll get over it.
Yeah, it'd be great.
It'd be great.
But yeah, that's where I've been for the last I don't know, week and a half, 2 weeks.
Yeah.
2 weeks, kind of 2 weeks, maybe 2 weeks. I don't know. I don't keep track of this shit. I just stream whenever I get here, and you bastards have to deal with it. So,
no, because I can text you and bug you.
Yeah, you can.
Yeah.
Which there's a few people that can, but this is like what's the other night? Dude, I did not realize you were going live.
Yeah, well, I did set it up earlier that day, so
Dude, I didn't realize it.
Well,
so
I texted you while you were live streaming because I had to go take care of it, and I texted you just so you knew what was going on.
Well, yeah, that's when I sent everybody over to you, because I didn't realize you were going live, and it was like, oh shit, you and Banshee are going live. Well, fuck, I'll send everybody over there.
And I actually had a prepared show. It's like, what the fuck happened?
I know you having a prepared show, but it's Banshee.
I know.
It's fucking Jason. How can you not have a prepared show with Jason?
I know. I got to be prepared with Jason. And the funny thing is, Jason knows me better than you know me, Coop. And he's like, "You're never prepared for anything. How did this happen?" And I go, "Dude, I don't know."
If it wasn't for because I had a couple of guns dropped off me by some family, and one of them was a Winchester 94.
Yeah, we were talking about that.
And I would not have made it through that complete rebuild, and I reblued it, rebuilt it, whole 9 yards, without Jason's videos.
Yeah.
And then I think YouTube killed them. And it wasn't too long after that. And it was like, YouTube, you bunch of dumb sons of bitches. Because Jason's videos were so good on that 94. Because I took that gun down to nothing. And sandblasted it, reblued it, everything. And there was two different models, and there was a separation in between, like the lifters on it or something like that. And I had the one that Jason didn't do, but it was enough to figure out where I was at. But yeah, I wouldn't have made it through that whole freaking redo if it wasn't for Jason. And I've mentioned that a couple times with Jason and some other videos and stuff, because it's true. I would not have made it through that refit and that redo if it wasn't for him. Because Jason's he's one of those dudes. He's done so much stuff that it's, my wife right now, she's been working for a gunsmith for the last 2 years, and she gets to work on so much more shit than me. The only things I really get to work on is if I tear apart one of my own guns and redo my own guns.
Well, that's what I wanted to ask you off the chat, because I don't want to do it live, because
Oh, you can do it on the chat. I promise you.
No,
I will completely admit I'm a cuck.
That's besides the point. We're not talking about that. It's more possum related things.
Spit that in my lap. Well, I put my possum related things online. You've seen me fucking catch a possum on my porch and pet that bitch like a cat.
I'm surprised it didn't bite your hand.
Well, it depends on how you catch the possum. Because they are really just.
And I'm surprised it didn't have a lot of ticks on you.
Well, I got rid of all my ticks. I took bath before that, so the possum didn't really have any ticks to eat, and possums really are like, I don't know, dealing with a rat trap that's already set. You just got to realize where you put your hands, and they're gonna bite the shit when they want.
Yeah, well, that one possum really didn't like you.
Well, there's been a couple of them that really didn't like me, because when you grab them by the tail and you hold them up in the air, and then you put them down and you pet them on the head and scratch them on the ears, yeah, they really
no, Lightning Scott. We're not talking about Coop's tick. We're talking about ticks on the possum.
Yeah, I got plenty of ticks. I mean, especially lately, I got plenty of ticks.
Yeah. We know Coop's got a nervous tick. That's not what we're talking about.
Yeah. No, it's that one night. I think that's the one I shot the damn short on.
Right.
Possums. I had like 26 chickens. You got to understand. I had like 26 chickens. Possums killed like 24 of them. I mean, possums are the ones who killed most of my chickens. And I walked down the porch one night, and there's this possum out there who has most of the tail feathers of the last chicken I got pulled out and like hanging out of his mouth. And it was like, okay, fucker, I get to play with you. So I grab him fucking basically by the tail and the scruff of the neck and lift him up, set him on the rail, and then I just start like fucking petting him everywhere. I'm like, fuck you. You fucking pulled all the tail feathers out of my chicken. You get to get fucked with. I mean, that's basically the rules.
He didn't think so.
He didn't think so. However, he did to get fucked with, because I like, again, grabbed him by the tail and I petted him all over. It was like petting a fucking demented Mickey Mouse. I mean, he's got the ears, he's got big ass teeth. I mean, fuck it. That short should still be up. I mean, it's still there. Because it's like, fuck it. If you're gonna eat all my goddamn chickens, I get to fuck with you. I mean,
Right.
that's the general rules of the whole situation. My wife walked out there. It's funny as shit. I got this goddamn fucking possum by the tail, holding him upside down, petting him on the head. It's like, blah, blah, blah. Where'd the chickens go? This motherfucker pulled their tail feathers out. Well, what are you going to do with it? I'm going to fucking play with it. That's what I'm going to goddamn do.
Yeah.
And it's just fucking sit him down over the planter over there on the porch, and it's like, fucking shit. I got you by the tail. I get to fucking play with you. My wife was like, you're such a fucking retard. Yeah, I am. I'm an absolute retard. But this possum's getting fucked with for the rest of his goddamn life. Funny enough, he never killed another chicken that I know of.
You know why, right? He liked being accosted.
Yeah, he was like, "Fuck, I'm done with this shit. I'm not showing back up to that motherfucking ad."
That guy's fucking crazy.
That's such a fucking catch me, pet me, fucking rub his finger in my ear. Fucking, I'm done with this shit. But yeah, because dude, if you look at that video, like holding this possum by the fucking scruff of the neck, running my finger in his ear, I'm fucking doing everything in this goddamn.
Yeah, and he doesn't bite you, but he just hisses at you.
Oh, dude, they always hiss.
So
years ago, I did when I was doing nuisance wildlife. So I'd go to people's houses, I'd deal with their possum problem, raccoon problem, whatever. There was a place I went to, it was just north of Atlanta. And they had a drop ceiling put in their like basement, and there were animals coming in and getting above their drop ceiling. But I opened up one of the ceiling tiles. There's a raccoon, or not a raccoon, but a possum there. And it was like, fuck, I was wearing like my welding gloves at the time. And it was like, okay. So I just grabbed the bitch by the bottom jaw and snatched him out of the ceiling. It's just like, he ain't hurt nothing. Just fucking throw his ass in the goddamn cage. Okay. You guys have a possum problem. It's like, hey, did you really just do it? Yeah, I really just did that.
It's like he didn't bite through the gloves.
No. Dude, they're not gonna bite through the gloves. The only time I've been bit by a possum, seriously, is I had a possum that I brought home that was probably, I don't know, 6 months old or so, and it went underneath the couch where I was living. And I went to reach in there to get the possum out from underneath the couch, and I stuck my hand dead in the fucker's mouth, and it clamped down on my right pointer finger, and fuck, it just like blistered it because it was like a serious chomp. But then I grabbed it, pulled it out. But possums are. I didn't. The only thing about possums I never realized is how many chickens they would kill. I figured it would be foxes, it would be raccoons, it would be something else killing the chickens out here. No, it's fucking goddamn possums. I walked out there, fucking chickens raising hell out there at the chicken coop that I built.
Let me ask you this: do you have much coyote problems out there?
We got some yotes, and we've got some serious yotes, but they haven't been up here towards the house.
Because it just seems like, you know, people in a lot of the states now, they're complaining about coyotes being all over the place, and that's because, well, the wolves, we killed off all the wolves in the country, except
so they don't take care of the yotes.
A set amount that they re-released into the wild. But the problem is, did that too late, because all the coyotes found out that, hey, there's no more wolves around. We'll just take over their territory, and then they just spread like wildfire.
Oh yeah, no, we got yotes down here.
Yeah, we got them here too.
Hell, me and the wife, it's been, I don't know, 3 years ago, at least. Got back to the house about, I don't know, probably this time at night. So we're getting back to the house where it's cold, it's nighttime. And oh yeah, I got to tell a story here in a second. But it's cold outside, and the yotes just went off in what we call the bottom, which is down the hill from us. I mean, and went off. So if you've never heard coyotes like pack up, what we typically call it, where they're calling to one another, and it gets wild.
Mm.
And they were calling out real hard that night, and it was like, okay, yeah, we need to keep an eye on the chickens that night. And what killed the chickens? A fucking possum. Good.
Okay. On that note, we probably should kill this. Otherwise, you'll go on and on about that possum.
I'll tell you this, and this is screwy shit, and I mean really screwy shit. So, was it last night? Yeah, it had to have been last night. I picked up my daughter and my son from the in-laws' place when I got off from work.
Right.
And it's dark. And these days, by the time I get off from work. And we're headed at the back roads with country roads up here. And I saw the craziest shit, and this is serious. And I mean, in all seriousness, the craziest shit I've ever seen in my life. There were two what looked like fucking should have been comets burning in to the earth. I mean, where we're at. The only thing I can equate them to is like the parachute flares, but only faster.
Right.
So it was like two fucking orange balls with goddamn sparklers coming off the ass end and then burning in. And when we hit the second road where we can see it, there were like 3 aircraft, one stacked over the other, moving into the area where those like fucking sparklers burnt in. Now, we're near Fort Benning. I'm used to seeing aircraft fly over all the other horse shit. They are always on Fort Benning's property in their area, way off to where the left of where this shit happened. So if we get invaded by aliens, I'm just warning you, sons of bitches, keep that thing on you because it's probably happening.
Well, we'll just send the possums after them.
Yeah, the possums probably eat the shit out of them. I'm just saying because they're mean little bastards.
Or we'll send the gators.
Well, the gators are even meaner than the possums.
Well, not all of them, but most of them, yeah.
Yeah, well, you know, there are some gators that you can like flip over and like rub on their bellies and shit. And
yeah,
you know, there are some possums that you can't get near because they'll fucking eat the shit out of you. So yeah,
it's true. It's true.
I mean, you know, you're fucking the Carolinas, so
yeah, you know, I got gators in my backyard technically.
You know, I don't have any in my backyard. In my side yard, however,
well,
there's a few.
There's a river at the edge of my property, so the thing is there's some in there.
All I got is a creek at the edge of my property.
And remember, the southeastern part of South Carolina, you know, the Low Country area, it's all swamp.
Yeah, all I know is if you are ever in that area, and this is a pro tip for travelers, do not order a shrimp po' boy in northern South Carolina to northern Carolina. Don't do it. Because if you have had a shrimp po' boy in a place like Louisiana, which involves French bread and like fistfuls of shrimp and all this other shit, if you have ever had one there and you go to order one in those fucking commie states, They will hand you a fucking hamburger bun with 3 shrimp on it and then say it's a po' boy.
I didn't do that.
You have not done it. I have seen it happen. I have been there when it happened. I have went from Slidell, Louisiana to fucking Myrtle Beach and above Myrtle Beach.
Okay. Hold on. Here is your problem. Okay. Myrtle Beach is all lefties.
Well, that's what you just said. Those commie bastards.
All lefties.
Explain why they fucked up a shrimp po' boy.
You had to go down to Charleston to get proper food, because in Myrtle Beach is Myrtle Beach. You know, all the Northerners think it's been the best place to go in South Carolina since the 1950s. I'll tell you what, you don't go there. Not even people that live in South Carolina go to Myrtle Beach.
Okay, well, I didn't live there at the time. I lived in Slidell, Louisiana. All I wanted was a shrimp po' boy in fucking South Carolina, but they fucked that all up.
And I hate to say this, but Barton Fink is right.
Shrimp po' boy from Popeyes. Yeah, he is damn sure right. Dude, I'm serious. And it was, oh, fuck, it was
like Myrtle Beach. They don't know how to do seafood.
2000. It was before the 2000s. And me and my mom went and visit my oldest brother. He was in Myrtle Beach. And then we went up through Myrtle Beach and then went through a couple places up up the coast and ordered a shrimp po' boy, which was a hoagie sandwich with like 3 shrimp on it, which is depressing enough. I mean, it's like absolutely depressing. And then the fixings that came with it, it was, well, I would rather put a fucking like a kickstart on my shotgun than eating that sandwich.
Yeah. Well, see, that's the wrong thing. You should have went to a barbecue place and you should have gotten Carolina barbecue sauce.
Well, maybe that should have been the thing we did.
Because that is the one thing it's really hard to screw up in South Carolina is pulled pork and South Carolina barbecue sauce.
Yeah, well, that may have been a thing. We should have gone for pulled pork and Carolina barbecue and all that. But let me tell you something. As much as it is hard to screw up pulled pork and Carolina barbecue, they can absolutely fuck up a shrimp po' boy.
Oh yeah.
I mean, they can. It's like donkey screwed it. I mean,
and when I say Carolina style barbecue, you know, it's the Carolina sauce, because Carolina sauce is that mustard style barbecue sauce. It is freaking delicious.
Mustard and vinegar.
Mustard and vinegar, but if they do it right and they make it sweet, it's good. It's really good.
Yeah.
It's sweet and tangy. Got a little spice to it. It's delicious.
Oh, dude! Whenever I do, or the only times I've done like a whole pig on a grill, there's a recipe that I've used that is Memphis Gold Dust, which is a dude who's done like freaking, I mean, pig cook-offs forever for any kind of state, whatever. And it's more kind of that South Carolina brown sugar kind of cook-off to it. And that shit is amazing.
A friend of mine in Texas said he had never tried barbecue South Carolina style barbecue sauce, and I just got some and had Amazon send him some from one of the places I normally get my barbecue sauce from here in South Carolina.
Nice.
And they sent it straight to him, and he's like, This shit's fucking delicious.
Oh yeah, dude. If you've
it was from the place in Colombia that I really like going to when I drive through that way.
Yeah, if you've never had different sauces, because I've had them from say Kansas City to the Carolinas down to Alabama, stuff like that. I will say I love a good kind of mustard based vinegar based sauce more than I like a really sweet sauce. Because they just taste better to me. There are some places that love a really sweet sauce, and fuck them because they're all communist. Just saying.
Yeah. All right.
Anyway, let me get at it. Let's get at it, guys. I had to finish up kiddos and then get kiddos sleep, and then I'm gonna get sleep. So let's get out of here. Night Strike, brother, post your channel. Tell everybody where they can find you.
Just look me up on YouTube, guys. You know how. YouTube.com/@Nightstrike. NIGHTSTRIKE.
Just look up Commie Strike.
No, I don't have a channel yet. I got to make a channel for that.
Bob, let everybody know, brother.
I have no channel, but I have subscribers.
Give me your subscribers because I need more.
Bob probably has
both
more
of them.
subscribers than I do.
I don't even have anything up except this stupid logo, and I have subscribers.
Shit. I'm gonna die. Bob probably got more subscribers than I got. But anyway, you guys be cool. You perps be cool. Take them easy. We will see you guys on the next one. Hopefully I'll start doing some more shit here later. At least that's the plan anyway. We'll see how things go. I love all you guys to death. Barton, Lightning, Fluffy, dude, I love all you guys. We'll catch you guys all after a while. And we're gonna end this one here as soon as I can figure out how to do it.
What's this button do?
Yeah, this button. It's this button.
No, it's the other button. Yeah, no, that was the right button though. All right.
I'll talk to y'all later.
I can't turn it off from here. That's great. He's got to get back in here to end this. I can't end this. Maybe if I do this.